Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today as we are continuing our deep dive coverage of the Charles Jones murder trial. Let me just double check my audio. Of Justice. All right, sounding good. So settle in, get comfortable. We have a full day of pretrial hearings. We're also going to have time to check out Alicia Andrews' testimony from her trial back in October. So with that, let's get started.
Ready, I'ma pass you the phone, say a damn line. Is it just me or the vibe been steady going down? When with you, I'ma save mine. Took me so long, figure out what you want. Every time you're with me, it's a great time. Only way you reach out is with your hand in my pants. You unbuckling, so I gotta go. See what I move from my basement. I got so full, you got chills. Not what you used to, I'm different. You ain't getting in my feels. You should know with me, only got one chance. One behind my back and blew it. Shit is not my style, keep it so low-key. What I do don't need to prove it. One thing about me that I know for sure, you will never see me lose it. Never see me lose it. Never, no. I'm not hearing you out the recital. You and me when I mention the title.
All right, welcome in everybody. Welcome in. Thank you for joining us today as we are continuing our deep dive into the Charles Jones, who goes by the rap name of Julio Foolio, murder trial, which is coming up tomorrow. They are seating a jury today. In speaking with Florida PI Sam last night, they're going to be there until they seat a jury. So they will be starting. We'll be starting tomorrow. So let's see who's with us today. We've got Allison and Iowa Backyard Cam, good vibes only, and Kimbers. Good to see you guys both. Kathy Davis, welcome in. Good to see you. Hey Barry, good morning to you. Anthony, good to see you guys as well. Richard in the kitchen, good morning. Hope you're having a good morning so far. Green-Eyed Cat, happy Taco Tuesday to you. Good to see you. Cajun Bayou Queen, good to see you. Iowa Backyard, yes, Colleen has chicks and the horses. Yes, I saw the little baby chicks the other day. They are so cute. Snap, good morning to you. Let's see, G. Bamina, good morning to you. Hope I'm pronouncing your name right. Camilla, good to see you. Joy, good morning, welcome in. Who else do we have with us? Brown-Eyed Girl, popping in to say hello. Thank you for that. Let's see, who else do we have with us? Downey Lynn, good to see you. Jane Dixon, good morning. Joe and Jedi Platypus, good morning to you. Such a fun name to say. Debbie, good morning. Radioactive, good to see you. Thank you for joining us today. Jackie, good morning. Stella, good to see you. Never dive in shallow water. Good thing Squeegee is here to dig deep into this case. Yes. Thank you guys for joining us. Really appreciate it. Hey, Shoshana, Nevar, Holly, good to see you guys. Appreciate you spending your day with us. Hopefully you'll hang with us all day. We got a lot to show. Hey, Keisha, good to see you. Good morning, Lori. Gordon, good to see you. Fanny, thank you for joining us. All right. I think we can get started. Judy, good morning. Welcome in. All right, so we're going to continue with our pretrial hearings. We've got, I believe, 3. Let's see, we've got 2 from March and then one that's only 15 minutes in April. So we'll check that out. And then we're going to have time. So that's only about 4 hours. And then we're going to jump over to Alicia's testimony. Hey, Bama, good to see you. Cheryl, welcome in. Good morning. So then we're going to jump over to Alicia's testimony. So I'm going to play her opening statements and then her testimony, so we'll just slide right into Charles's trial tomorrow, which opening statements will be tomorrow. I'm not sure when, if it's 9 o'clock, 8:30, 8:45. Still not sure exactly when the time starts. So we'll find that out before the end of the day. But judge is convinced. Well, judge is going to seat a jury today. Come hell or high water, they are staying until they seat a jury today. So that's the latest coming out of the courtroom. All right. So without further ado, let's get to it. All right. So this hearing took place. Let's see, March 15th. So let me just post that for you guys. Yeah, March 15th, 2026. Pretrial hearing. All right, I'll go ahead and I'll post this up here for you guys. So if you're wondering, this is from March 15th of 2026. So just about a month or so. Yeah, just about a month or so ago. All right, get comfortable, settle in, and let's get to it.
All right, good morning, everybody.
Good morning.
All right, good morning. All four of the defendants are present. Their counsel are all present. State's present.
Good morning.
Good morning. All right, let me set up here. Okay, so some housekeeping matters first. Let's see. All right. I know that when we were here on Tuesday that Mr. Gathright had some motions that I think I ruled on, but I couldn't locate the physical copies. So I just wanted to make sure that we're all on the same page regarding the fact that all of the motions have been ruled upon, right?
Yeah, sure. The only one, and I saw it was on the list, it was sent out last night. The only one that hasn't been is really the firearm motion.
Okay.
The state and I discussed, I think it might make the most sense to kind of proffer it and address it when the expert.
Okay.
has got the
Well, I do have that one. So there were 3 motions that I located in my stack of pleadings, and I just wanted to make sure that I had addressed all of them really for the clerk as well as for Mr. Gathright. And I believe that they were, the first one was a motion to declare section 921.1416I unconstitutional as written and as applied, and I think that was the CCP aggravator, which I denied, so that has been denied. Do you need it?
I'll just check it, Judge, to make sure I got it.
Okay.
I think I got it.
Okay, I think you do too, but just to make sure. And then the other one, the second one was motion to declare section 921.1416B Florida statutes unconstitutional as written and as applied, and that's the prior capital or violent felony, which would be contemporaneous in this case. And I believe I ruled that it was denied. Just want to make sure.
Okay.
And then finally was a motion in limine as regards to general procedures, and there were paragraphs. I think A was granted, B was granted, And C was granted as to the names, but denied as to questionnaires. So granted in part, denied in part. Individualized and sequestered voir dire was denied, and contemporaneous objections, paragraph E, was granted. All right. So, Madam Clerk, that was granted in part and denied in part as articulated. And, okay, so I think those are the three motions that I located my copies of. Also, I had taken under advisement Rashad Murphy's motion to allow testimony of the impact of defendant's execution on family members, and specifically, Mr. Rashad Murphy had cited to Lugo versus State at 845 Southern 2nd, 74. I did take a look at that opinion, and in that case, the defendant had one of his proffered mitigating circumstances was that his execution will have a tremendous negative impact upon the lives of his elderly mother, siblings, and 6 children. In this case, Mr. Lugo contended that his sister passed away, he adopted her 4 children, and assisted in raising them. So in that case, what the real issue was what the issue on appeal was, Mr. Lugo, he argued that mitigating circumstance outweighed the aggravating circumstances, and the court said no, and that was affirmed. But it does appear that this mitigating circumstance was offered, which was his execution will have a tremendous negative impact upon the lives of his elderly mother and siblings. So for that reason, as the motion is drafted, I'll grant the motion. All right?
I will pass that on to Mr. Hernandez, Judge.
Yeah, just let him know. And really, and this applies to Mr. Rashad Murphy and all of the defendants in this case, obviously, if we get to a penalty phase, you and your counsel can and should tell the jury every great thing about you, every redeeming characteristic about the totality of your life, okay? So, all right, very good. All right, so let's move on to which would be Mr. Gathwright's defendant's motion in limine to preclude the state from presenting firearms identification evidence, and then the state filed a motion to strike Daubert hearing request in defendant's motion. So how are you all suggesting that we handle this?
Your Honor, my position in the motion, and I know the state certainly disputes this, is that this firearms identification evidence is not product of reliable principles and methods and should not be
I'm sorry,
submitted.
excuse me.
Should I?
Yes.
I can't hear either.
No.
This is better than courtroom 1, but it's not, it's still a big courtroom.
Understood. So, Your Honor, my position is that this body of alleged science, the firearms identification, is not reliable. It's not the product of reliable principles and methods. It should not be admitted at all. I recognize that has been addressed by many courts across the country, and the courts in Florida have not been particularly receptive to the argument. So, unless Your Honor is inclined to agree with me, I think that what Ms. Norton and I talked about is that the best way to address this might be to proffer the expert's testimony when that time comes and rule on it at that point. So.
Okay. All right, very good. So in light of that, I'm going to grant the state's motion to strike the Daubert hearing request, but I will allow defense to proffer before the witness testifies just for appellate purposes.
Thank you.
Okay, so just remind me that we need to do that before the firearms expert testifies. All right? So I'm going to grant the motion to strike. All right.
Judge, one more housekeeping matter. if I
Sure.
could. Judge, I hope the court has now seen that I erred yesterday when I filed my supplemental memo on severance, one addressing the court's question to me last week. When I filed a draft instead of the final memorandum. I realized that very early this morning, immediately contact Ms. Ismer, and this morning at about 8:30 or maybe before, I filed it amended. Now, I will
Okay.
tell the court that the amended is in fact very similar to the supplemental.
Okay.
There's not anything of grave change to it, but I wanted the court to be aware that that was my mistake, and I apologize to the state for not catching it this morning. We filed a draft instead of the final of what we wanted to file.
Okay, very good.
Okay, and then the other thing, judges, I know I asked the court about this earlier in the week, believing that this would conclude any motions. I did have, and I will reiterate again, a motion in limine as it relates to the state's witness, Robert Howard.
Okay.
It is not yet complete, but it will not
Sure.
require testimony and probably very brief argument.
Okay, that's fine. We're going to pick another date in the future to hopefully resolve any outstanding evidentiary disputes. And I know you all still need to get together to do your evidence view, correct? Has that been scheduled yet?
I was gonna talk about that today. I know
Okay.
because of the voluminous nature of it, I wasn't even sure the state was ready to do
Judge,
that.
We do have to, we've gotten some items out of evidence, but I think there are some additional physical items that we need to get out of evidence that were put in trial. And
Right.
so we will get that done. I think the photos, for the most part, we're just gonna reprint, but they are a lot of photos, so I do need some time, but we will schedule that.
Okay, so on the lunch break today, I need you guys to figure out a prospective date for that, and then I will set a motion hearing date after that, but we need to have at least an idea of when that's going to be, because I know your calendars are busy, and I don't want you all to get jammed up, and then we can't get together at least one last time to go over any and all outstanding motions or issues.
Yes.
Okay? All right, and I know we discussed this on the state's motion in limine regarding victims' gang activity and drill rap videos not disclosed in reciprocal discovery. Did I give you all an absolute deadline? Did I pick a date?
Judge, I think they were supposed to provide it to us today, by today.
Okay,
And Judge, that would be any videos that we intended to enter.
Correct.
Any of us.
Yes.
And yes, Judge, you did give us until today to do so. On behalf of Mr. Murphy, I will not be providing the state with any additional videos.
okay. All right, and so State, you're going to take a look at those and then let me know if you have an objection.
Yes, Judge, I believe the attorney for Mr. Chance provided us with a list of videos.
I
So we
did
will
see,
let-
yeah, I did see that. Okay, so I'm going to actually reserve ruling on that motion pending the state taking a look at what's been proffered. And if I need to resolve a dispute, then I will do so whatever our next hearing date will be. Okay? So that one I will reserve ruling on. Yes, Mr. Wise?
Your Honor, while we're talking housekeeping matters, I hope I'm not interrupting, there is, at some point today, I'd like to briefly readdress a question Your Honor asked during my traffic stop motion after having done a little bit of research on it.
Sure,
I can do that now.
sure.
Okay. So, when we were having argument on that motion at the last hearing date, Your Honor had asked if I would agree that finding the firearm in the car that Mr. Gathright was in would give a basis for, I guess, arrest. I don't recall if it was an arrest or a search of the car because he's under 21. And I didn't agree with that for a lot of reasons. But having done a little more research, I don't see a basis, I don't see a reason why his possession of a firearm being under 21 and over 18 was unlawful. I know that's what the officers apparently believed, but I don't see a reason why that was unlawful. And if the state, has a reason that I'm missing, I'm sure they would bring it up. But to go back and readdress that question after having done some other research, it would, if he was under 18, it would have been unlawful, but I don't believe possessing a handgun
Under
between 18
21.
and 21 is unlawful.
Okay, State, what's your argument?
Judge, Judge, it is securely encased, I think that he is correct, but there is a law for that. But what he was arrested for was the possession of drugs and drug paraphernalia.
No, I understand, but I think the argument was made, I think law enforcement took the position that that was also,
They did, Judge. They believed that, and correctly so, that there is a law that if you are under the age of 21, you're not allowed to possess a handgun. But there is also additional part of that statute that says as long as it is securely encased, and it's our understanding that that was in the console of the car.
so do you agree that that would have been securely encased in the console of the car within the meaning of that statute?
Yes, Your Honor.
Okay, all right, thank you. Okay, all right. So, next, we will move on to argument regarding the various motions as it relates to the gang evidence and whether or not it's going to come in. So the state has filed a motion for pretrial ruling regarding admissibility of evidence. And who's going to argue that motion for the state?
May I be heard, Judge?
Yeah?
Maybe, Your Honor, and again, strictly up to the court, having the defense argue their motions as it relates to limine of all of those things might subsume the state's actual motion when they argue against the same.
Well, no, and I agree. I agree. Really, the point of hearing the state first is for the state to articulate exactly what it is that they're intending to admit. So that's my motivation in asking the state at this point to proceed, is for them to identify on the record exactly which incidents they are intending to introduce, and then I will have the defendants argue their various motions.
Thank you, Your Honor.
Okay?
Just have one moment.
Sure. So if I'm looking at the state's motion, it looks like you're going back as far as 2018.
Yes, Judge, I am just looking, I have so many documents, just trying to find that one.
Yes, I understand. So it looks like pursuant to the motion itself, August 18th of 2018, Joe Rod Adams, also known as Spaz, was murdered at a Rains High School football game. Adams, it's alleged, was a 1200 associate. Robert Howard and Adrian Bibby Gaynor were suspects in the homicide of Adams. Howard and Gaynor are six block members, and Robert Howard was convicted and served a 5-year prison sentence for manslaughter and aggravated battery on that case. I believe Robert Howard was also a victim in this case, and he did testify in the Andrews case. The state also alleges or discussed in February of 2019, Adrian Bibby Gaynor was shot and killed in Jacksonville, Florida. Adrian Bibby Gaynor is known to be close with the victim, Charles Jones, and is associated with 6 Block. Hakeem Cusso Robinson and Leroy Scotty Whitaker, gang members of ATK, are currently charged with murder for the death of Gaynor. Then the state identifies August 16, 2023. Jaquan Pickens, bully gang member, was shot multiple times and killed. Bully gang is associated with and allied with 6 Block. And then August 17th of 2023, there's an attempted murder of Jacoby Beals, a 1200 gang member. This shooting was believed to have been committed in retaliation for the murder of Jake Pickens that occurred the day before on August 18th. On October 7th, 2023, Antonio Tilley, ATK gang member, was murdered. Members from 6 Block claimed credit for the murder on social media. On the same day that Tilley was murdered, immediately after, there was an attempted murder committed against the victim, in our case, Charles Jones. So I'm assuming, are those all of the prior incidents of gang violence that you are seeking to introduce?
Yes, Your Honor, that's what was outlined in my motion that we responded to, the motion for severance for Rashad Murphy. It's also what we have listed previously in all the defendants' case as under notice of inextricably intertwined evidence, Judge. Along with, there are some drill rap videos that also mention some additional gang members that we also intend to introduce. And Judge, it is the state's position that those 6 incidents, as well as the drill rap videos that we have listed in discovery as inextricably intertwined and evidence of motive, is relevant to this case against all.
All right. I believe we did play this yesterday. It says it's two different dates. Yesterday was from the 9th, and this one is saying it's from the 15th. But they do have the same clothes on. I don't know why that was posted on another channel as two different days. But if you guys are okay with it, I'm going to just keep playing this. So I'm just going to keep going forward. So yeah, this was I guess we watched this yesterday. I know it sounds familiar, but they go over a lot of things multiple times. So this does look like it was played yesterday, but I'm just going to I'm just going to continue to play, and then we'll get into another one after this.
Of the defendants. First of all, the three defendants, Isaiah Chance, Rashad Murphy, and Davian Murphy, are gang members, and as part of our requirement for proof for that particular gang enhancement, we have to prove that they were gang members and that this crime was committed for the purpose of enhancing or benefiting the gang in some way. And Judge, we are prepared to do that. As far as Sean Gathright, we believe that it is also admissible in his case. He is closely tied to Isaiah Chance, who is a known gang member. There is evidence that he is the supplier of the gun, as well as there is evidence that directly links him to the attempted murder of Charles Jones that occurred in October of 2023. We have listed the case law for this argument for inextricably intertwined that is directly relevant to gangs. In particular, I will again cite to that Richardson case what was very clear, that there were 6 prior shootings that was introduced in that trial. That was a gang case that occurred again up in Jacksonville, where a child was shot and killed, and his grandmother and another woman in the car along with him were shot at but unharmed. And what the court went through is this whole argument about inextricably intertwined, and the state in that case was able to show to the jury through the documentation by the gang itself, that's how it qualified these drill rap videos, was the fact that this gang war was documented by the gang members themselves on social media, by not only drill rap videos, by social media postings. All of that was evidence of motive, and the court acknowledged that that was highly prejudicial, especially the prior shootings, but it was not substantially outweighed by the probative value of motive. And that is what this is in this particular case. It is motive. It tells why in Richardson, why that baby was shot, because there were gang members that were standing on the street where that baby and his family were. And it provided the explanation why that shooting happened, the motive. And it is the motive in this case, that historical gang war actually will show the jury all of the reasons and give context to why this shooting happened. And so it is highly probative. Motive evidence in any case has a very significant probative value. And the court went through that analysis and said that that background, even the collateral crime evidence of the prior shootings, was not outweighed, that prejudicial effect was not outweighed by the probative value. And it is necessary for us to be able to actually explain to the jury what led up to this shooting, what was the motive, why they all came down to Tampa in one day for the specific purpose of shooting Charles Jones. And it all has to do with this back and forth gang war that is going on. 3 of the people of the 4 that are left are part of the gang that are allied together that dislike Charles Jones. Those drill rap videos, the evidence on social media that shows the back and forth, all of those are connected to these 6 incidences that we have alleged. In particular, Adrian Bibby Gaynor has a relationship the first one is the Rains High School where we start. Joe Rod Adams, I apologize, starting with that one in 2018, he had the nickname Spaz. was a Gang 1200 associate and is related to the Murphy. So obviously, going back to that specific case, especially since Robert Howard, who is also a person that was with the victim when he shot and is a witness in this case, is relevant and gives history to the significance of the motive in this particular case.
Okay, and I'm not meaning to cut you off, and just so everyone knows, the first thing I really want to discuss and what I'm going to rule on today initially is regarding the introduction of the evidence related to the 6 specified incidents in the state's motion, all right? Because then, once I rule on that, then we can have a discussion regarding what drill rap videos and what other evidence is going to come in once I've ruled on the admissibility of the 6 previous incidents.
And Judge,
Okay?
I may ask for the assistance of Ms. Ismer. She has kind of taken over this area for us and covering with the state, and to some particulars, I may require her assistance in responding to the particular specific reasons why they're relevant to the case.
Okay, and that's, you mean as far as the drill rap videos or the actual previous incidents?
Both, Judge.
Okay, so, yeah, so what I'm trying to say is that the any objections to any specific videos, I will address that after I've ruled on just the general nature of the gang evidence coming in. Once you all know the parameters of what's going to be admissible, then we can visit if there's objections to certain drill rap videos, whether or not they come in, okay?
Okay.
Okay, very good. All right, anything further before I turn it over to the defense, just with regards to the 6 previous incidents?
Okay. And Judge, I know that we probably will go through one by one, but some of the defense motion and limines that have to do with gang, there are several paragraphs that list different items. And so at some point, when we go through those items, I would like the opportunity to address those items.
Sure.
Okay, thank you.
Absolutely. And, one question. There was testimony that Joe Rod Adams is actually the brother of Davion Murphy. Is that correct?
Judge, there was testimony, I believe, by one of the detectives. They knew that there was a relationship. They had him referred to as a brother, but they were not absolutely certain as to whether it was a brother or a cousin. But they are sure that there is a relationship between both of the Murphys and Joe Rod Adams.
Okay.
But
And-
he did at one point believe that he was a brother to, I want to make sure, Rashad Murphy, and cousin to Davion. I now believe that that is the reverse. Is that correct, Ms. Ismar?
The only evidence that we have to support the relationship is that there's a familial relationship, that they are cousins. There was some discussion, but proof as far as setting that forward at trial of a brother relationship, other than referring to them as their brother, is.
So I was going to ask you, what is the state's proof? Unless the defense is conceding that they're related. Mr. Gonzalez? Excuse me. Well, it'd be Mr. Gonzalez and then also Mr. Sonardi.
Sonardi.
I'm sorry.
Well, Judge, I think it's the state's burden
I agree.
to provide testimony and evidence that they are in fact related in some way, shape, or form. So I would ask the court to defer to their proof in answering that question.
Okay, same, Mr. Sonardi?
Same for
Okay.
Davion Murphy.
I'm just asking the question. Okay, so what's your
Defendant's
proof?
Statements are calling Mr. Joe Rod Adams their brother.
Whose statements?
Mr. Murphy and, Mr. Davion Murphy and Mr. Rashad Murphy refer to Joe Rod Adams as their brother.
And was that in text messages or
In their interviews.
in their interviews?
Correct. More recently, there are phone calls which Davion Murphy has made with his mother, which indicate that the relationship is cousins. The detectives' evidence as far as following the gangs that they provided to us in preparing for the case were that the relationship established that they believed it to be was a cousin relationship. But the reference that we have is that they are brothers. I cannot tell the court whether that means that they are blood related or they just refer to each other as a brother.
Okay. Okay, very good. Okay, so who wants to go first?
I'll go, Your Honor.
All right,
Brian Gonzalez on behalf of Rashad Murphy. Judge, how the state of Florida gets to the point where they can elicit this type of evidence is the issue here. The second motion in limine, in addition to the Dahlberg challenge, requests that the court prohibit the admission of law enforcement opinion testimony and related evidence concerning A, alleged prior gang war history, hearsay-based gang intelligence, and purported uncharged gang-related incidents. It's our belief that the state is going to attempt to present to the jury a large and sweeping narrative that goes back 6 years, at least as referenced in the state's motion for pretrial ruling on admissibility, of a gang war in Jacksonville that includes multiple groups, dozens, if not more, of individuals, a series of shootings and homicides going back to, based on their motion, 2018. This murder being in June of 2024. The state argues that this evidence is inextricably intertwined and that it establishes an underlying motive for this particular offense, the murder of Charles Jones. And it's our belief that that is not supported by admissible evidence. Through what now appears to be 3 detectives, Detectives Nieder, Griffith, and McCullough, the state's going to attempt to introduce opinion testimony, which I submit to the court lacks or labeling historical violence as retaliatory conduct, and also utilizing a plethora and what is the primary basis of their testimony being hearsay-based intelligence derived from reports from other officers, confidential informants that are undocumented, lyrical interpretation of by opinion testimony of rap videos, evidence of uncharged and unsolved shootings, wholly, by the way, unconnected with Mr. Murphy. And collectively, I believe it invites the jury to decide somebody's guilt, in this case, Mr. Murphy's guilt, based on association and propensity rather than admissible evidence. The relief I'm requesting in detail is on page 2 of my motion, and the court will read that in her ruling.
And I'm sorry, we on your second motion in limine or third?
It's number 2, Judge.
Okay.
To that extent, the state is going to have detectives outline a history of this conflict going back to 2018, most of which are unsolved, and none of which are alleged to have been committed by Mr. Murphy. There will be testimony from detectives about gang affiliation as it relates to Mr. Murphy, as it relates to Rashad Murphy, as it relates to Mr. Chance, and there won't be any, I believe, as it relates to Mr. Gathright. The testimony is also going to outline the gangs themselves, the nature of the gangs, inclusive of their background and their history, sometimes going back to their inception, long before any of these detectives were involved in their particular investigation of those individual gangs, collectively or individually, and also how these gangs are not traditional gangs, they're hybrid gangs. They have no hierarchy, they have no rules, they have no consequences, they have no punishments, and that is an important aspect when we talk about how they differ from a traditional gang where one member does things only at the behest of other gang members or at the behest of the gang as a whole. There are individual motivations in these hybrid gangs that may not have any involvement other than an individual grudge or a particular issue between one person and another that doesn't trickle down to any type of group gang type decision or plan. And that is the nature of it being a hybrid gang that mostly is derived historically based on neighborhoods or where you grew up. As it relates to testimony last week, Judge, and I'm going to run through this very quickly, Detective Nieder has 7 years on the job at the Sheriff's Department. He was assigned as late as 2022 to the gang unit, and at that particular time, he started working exclusively with ATK. He has taken 3 yearly courses at the beginner and intermediate level through HIDTA, H-I-D-T-A, and these are 3-day organizational crime conferences where general gang intelligence is discussed, and they also do not provide any comprehensive instruction. And this is based on testimony from Detective Nieder, whether it be at the hearing or sworn testimony from his deposition, and that's set forth in the motion with particularity as to where the court can find that. He essentially admits during his deposition that the majority of his training and experience comes from on-the-job training and based on what other detectives had told him prior to him coming on board. Although he alleges that he speaks with a number in a group and on a regular basis, community members, they don't openly discuss gang details to where they are documented, to where there are reports, to where there can be testimony as to who they are, and certainly those witnesses will not be testifying in court. As it relates to Detective Drabeck, I'm going to pass him, as I understand by the court's ruling, that he's going to be testifying to this particular investigation in and of itself and will not be testifying to any historical information. As it relates to Detective...
Correct, not as a gang expert.
Correct.
He's a fact witness.
Yes, Judge. As it relates to Detective Griffith, he has been with the department for 16 years, but he didn't join the gang squad until 2021. And for him, he's been through that same HIDTA training for 21 through 24, 4 weeks total. And he has never been qualified as an expert or given testimony as an expert. And essentially, he pretty much says the same thing as Detective Nieder says, acknowledging that his knowledge of 1200's activities prior to 2023 is very limited, and he does not have any witness with firsthand knowledge of any group dynamics. All of his testimony, again, is contextual inferences by unknown individuals that he cannot document, he can't tell us when, he can't tell us who, and he can't tell us with particularity what they say. As it relates to Detective McCullough, he began in 2022, and essentially he is in charge, and that's after a long standing history with the department itself, but again, in 2022, January, and he became assigned to 6 Block. He also went through the HIDTA training. He also went through and did a couple of other trainings of general types, and talks about how social media downloads, rap videos, interaction, again, with community members would be his source of information, again, with no particularized documentation of any kind in any way, and would not be able to testify to that if given an opportunity to testify to these historical issues. He also had some, he was unsure exactly if he'd ever testified before as an expert. He does recall testifying a couple of times. He thinks just in front of a judge and the state attorney, which might lead me to believe it was either a motion or a sentencing. Doesn't appear that he's testified as an expert as it relates to any type of trial testimony.
Well, let me just ask the state something. Who are you intending to call as your gang expert?
Judge, 3 witnesses, Detectives Nieder, Griffin, and McCullough. They each are specialized in a particular gang that is involved in this case, and all of them have years of experience in that gang unit monitoring these gangs.
So, but we can't have cumulative testimony.
Correct, Judge, and we will not, it will not be cumulative. There may be one or two that we cover it all with one or two and not call the third, but we have just listed them under the abundance of caution if there's something that one of them cannot speak to.
Okay. We'll cross that bridge when we get there, so.
And Judge, it's my expectation that we will rely on one of them mostly for the expert testimony, but as far as the documentation, there is documentation. Each one of those gang members have been documented with field incident reports that are maintained by the specific person assigned to that gang, so there is fact-related evidence as well. So we are not intending on offering cumulative evidence.
Okay.
And Judge, what I anticipate Ms. Doherty is talking about is a particular report where a person is documented as a gang member pursuant to statutory criteria. That we're not talking about testimony from people as to their gang history and what they do and what they did and what they might be accused of doing and how they relate potentially to a particular murder or a particular shooting. None of that. What Ms. Doherty, I believe, is talking about is the singular report where a particular person is documented as a gang member and under these criteria. And certainly you look at those criteria, and in and of that criteria are unknown interviews with unknown people.
Sure, but there's two separate issues here, right? Okay, so what we're discussing right now is the historical evidence. That's all we're discussing.
I just wanted to respond to.
Yeah, no, that's fine, and that's what I'm focused on right now.
Understood.
What's the parameters of the historical evidence that's going to be permitted to come in? And three of the defendants, the state has identified for aggravators as being gang members or associates.
Correct.
And so that's a separate issue as far as the state's proof and who they're going to call to establish that, okay? So I just want to make sure that we're clear what I'm focused in on at this particular moment is the history and how much of that's going to come in.
So I'm mistaken, because I thought Mr. Gonzalez said he was on to his second motion in limine in which he's challenging expertise.
We are.
We are, and we'll get there.
Okay.
We'll
All
get
right.
there,
I
but
apologize, Judge.
I'm going to first deal with the issue of the admissibility of the history of the gangs in Jacksonville.
Yes,
okay?
Judge. So in my motion, and I'm not going to go into it because I want to get to other things, I give the court what I believe, based on testimony of detectives at deposition, the backgrounds as to each one of the gangs themselves, 1200, ATK, 6 Block.
Because there are a lot of incidents, it looks like in your motion, Mr. Gonzalez, that the state's not seeking to introduce evidence.
They are, Judge, but they were testified to at deposition, and we did not know until we got this motion
Okay,
for
that's fine.
admissibility.
So, because at this point, the state has identified 6 instances, 6 historical events, and that's the universe at this point of what the state is seeking to introduce. So,
And I'm going to just touch on each one of those.
Okay.
Only those 6, not all the ones that are in the motion, because when the time I wrote the motion,
Right.
we weren't there.
Okay,
So I
very
will
good.
touch on those very briefly because they are in much more specificity and particularity in the motion, but I'm not going to just track the motion. I'm just going to try to give
Sure.
some bullet points on each one of those circumstances.
Okay, thank you.
The gang war narrative, Judge, they are all listed, inclusive of the 6, in the table that I have in the motion. And I just would ask the court to look at that table. Now, you can cut it down to those 6. Just gives an overview of each one of those circumstances. As it's reflected in each one of these detectives' testimony, many of those incidents remain unsolved. Certainly, in trying to determine who might be associated with what, there's not enough evidence to charge anybody with anything. None of these defendants, no one else that might be associated with any kind of gang, and therein lies, even at its root, a problem with what they would like to testify to as it relates to opinion that can't be buttressed by what I believe is admissible evidence, especially as it relates to Mr. Murphy. The states can introduce law enforcement testimony that establishes a victim, that talks about a perpetrator's gang affiliation, but no testimony about any one of these individuals specifically involved in any one of those circumstances, except for maybe some testimony as it relates to Mr. Jones's attempted murder on October 7th, because they're going to take a leap and they're going to talk about Mr. Chance and potentially Mr. Gathright, but mostly Mr. Chance. Without establishing this gang association, and I don't mean criteria under 874, I'm talking about evidence from witnesses. I think the state's intent here is to try to fill this evidentiary gap with testimony from one or more of those detectives, and they're going to cloak it as expert testimony or opinion, but regardless of whether it is, it's based on hearsay, it's based on speculation, it's based on contextualized inference, none of which is admissible under 702. So I asked the court to make that correlation as you determine these issues. Of the 6 incidents that we're talking about, take a quick glance.
Sure. So just, again, to recap, August of 2018, the murder of Joe Rod Adams.
Mr. Howard was convicted of manslaughter in that case.
Yes, he was, and will be a witness in this case, correct?
Oh, he will be a witness, and certainly we'll have an motion limine on that, and I would, based on his deposition and based on his proffer, waiting to hear what he might say on the stand under oath about gangs.
Okay, well,
and about gang association.
And again, the only reason I raise that is because that's actually someone who will be testifying with direct knowledge of these incidents, right?
Direct knowledge of what, Judge?
Of the, he was convicted and served a 5-year prison sentence for the manslaughter and aggravated battery.
Yes, I believe he will testify under an oath that,
Right.
in fact, that's the case.
Which means he can be cross-examined.
Correct.
Which is my point.
Yes, Judge. And now what other contextual knowledge he may have about anybody here or gangs in general,
No, I
that's
know,
another
I
story.
know. I'm just trying to draw the distinction between at least that incident. The state will have some direct evidence with a witness who then can be cross-examined, right?
Yes, Judge.
Okay, all right.
Now, I don't believe it will be as it relates to evidence that I'm suggesting in this motion is inadmissible or not inextricably intertwined. But nonetheless, we get there when we get there.
Right.
Judge Adrian Bibby Gaynor, Hakeem Kesu Robinson was charged in that case.
Right, and that was from February of 2019.
Yes, Judge.
Okay, then we move on to August 16th of 2023.
Yes, that's Jake Jit Pickens. That case is unsolved. Jacoby Beals is unsolved.
And that's from August 17th of 2023, correct?
That's correct, Judge.
Okay.
Then October 7th, Antonio Tilley, Jawan Mills was convicted on that case, but I don't believe there's any gang association based on testimony from detectives, and I'll get to that when I get to that individual case. And then we have October 7th, which is Charles Jones' attempted murder. That is unsolved as well.
Okay.
So, Judge, while it might be reasonable to attribute some level of reliability to law enforcement intelligence that's derived from social media, in this instance, the basis for opining that groups, either in rap videos or in social media that no one's going to be able to testify to, right, other than there was some. When, who was on it, what date, who said what, none of that the detectives are capable of testifying to. They can't testify to a rap video and their own speculation and their own opinion as to what that rap video might say, but when we talk about taking credit for something, because that appears to be a big issue, taking credit. The court might remember that Detective Nieder testified that taking credit is actually trolling. You're trolling the other side. You're disrespecting the fact that that murder occurred. You might even be lauding that that murder occurred or that shooting occurred. And certainly, the state would like you to take the leap or allow a jury to hear or allow somebody to testify to. That's an admission of committing a crime. And I would ask the court to look very closely as to whether or not that inference is admissible. Essentially, just briefly, Detective McCullough, when asked, are you saying they're claiming credit for some of these shootings? What do you mean by that? Well, they'll get on social media, Instagram or Spaces or Clubhouse, which is like a social media platform, and they'll just start talking about it. He got what he deserved, stuff like that, just claiming, basically taking responsibility for it. None of that insinuates anyone is taking responsibility for anything. They are rapping about it. And he says that in one part of his response, but then would like to suggest that basically they're taking responsibility, which again is an inadmissible opinion on his part that's not buttressed by any evidence. No one is specifically saying I did this. Well, of course, as we talked about, nobody gets on a video and says, I killed this guy. And I guess that's not what I was asking, but his answer is correct. People are not saying they're just taking credit for it. So what's happening in these social media posts and sometimes in these rap videos are the same thing that's happening at the same time out in the community. Somebody gets killed, there are thousands of people talking about it. People hate it, people like it, people laud it, people think it was deserved, people know what happened, so-and-so got shot, so-and-so was walking down the street. This is a community whereby social media, the ability to have knowledge and information is quick. And detectives testify to that. This is not relegated to one single group or one single person that knows about what happened to somebody. It's what they say about it. And therefore, we have to be careful. I believe the court has to be careful not to suggest to the jury and not to allow evidence that would lead a jury to believe that somebody had something to do with something when that's not what they're saying.
Right, I agree.
Judge, talking specifically about the 6 instances, I'm trying to talk as fast as I can. Joe Wright Adams.
Right.
The state is going to suggest that there's evidence to believe that Joe Wright Adams is a cousin of Rashad Murphy and Davion Murphy. This occurred in August of 2018, 6 years prior to this particular case. Detective Dishman was the lead detective in that case. In her deposition, she actually said that in investigating this case, that the argument developed over a girl. And it escalated, and at one point in time, Mr. Howard, a state witness, told a person, somebody's going to die on my 8. And then Dishman testified that she believed that Howard was talking about his friend, Lawrence Davis, who's called 8. That's the evidence of this gang affiliation in my mind. What ends up happening subsequently is that Bibby Gaynor is alleged to be a second shooter. He's not charged. Mr. Howard ends up either taking the rap or pleading guilty to a manslaughter on what was an alleged first-degree murder. And essentially along the way, the whole case falls apart because people recant what they were saying. They say they weren't telling the truth.
Right.
And they say they got threats. None law enforcement can't corroborate any of these claims.
Well, let me see this, Mr. Gonzalez. Let's just assume the state has evidence, enough evidence to go before a jury to make the argument that Joe Rod Adams was, in fact, had some close relationship. They even, whether or not they were actual family members, maybe referred to themselves as family members, whatever that may be. Wouldn't that be direct evidence potentially of a motive involving Davion and Rashad Murphy?
No, Judge. I think we have a significant remoteness involved. I don't believe that the jury should be led down a path that simply because one person was related to another,
Right.
that would provide the modus
Well, let me ask
to
you
kill
this,
somebody 6 years later.
and remind me, and I may be getting, because I may be misremembering, but was there not a video that Mr. Jones is performing in, or someone affiliated with Mr. Jones, where the grave site of someone's being desecrated? Am I remembering that correctly?
You are, Judge, it's another incident, though, that's the town center shooting. But
Okay.
there are references, I'm sorry, I'll let this.
Yes, Your Honor, that is correct. And it is of Mr. Joe Rod Adams'
Right.
gravesite.
Right, so
That is
Joe
separate
Rod-
part.
Right, Joe Rod Adams, and again, I'm just assuming for the sake of argument that there is evidence that there is some close relationship between the Murphys and Joe Rod Adams. He's murdered, and then Charles Jones actually makes a video where I think that they're pouring alcohol or something on the gravesite.
That's correct, Your Honor. So there was an initial video where it's believed that someone was urinating on the gravesite.
Right.
And Mr. Jones is alleged to have taken that a bit further and made an actual video with beverages or something of the
Yeah.
like poured on the same.
Yeah, I mean, okay. I just want to make sure I'm getting my facts correct.
And Judge, that's addressed in the motion when you get to it. As it relates to Bibby Gaynor, February 15, 2019, 5.5 years prior to this murder, essentially, Mr. Gaynor is allegedly, well, not allegedly, he's killed by Hakeem Robinson, and essentially Detective Oliver was the lead detective in that case. He was deposed. That was unsolved for about 18 months. Only at such time as a jailhouse snitch came forward and gave information that connected that murder to some type of retaliation, that law enforcement was able to make that connection and attempt to run with that particular theory of prosecution or theory of the murder. At this particular time, I don't believe that person is going to be testifying. It's hearsay. I don't believe that anybody is going to hear from a person who had direct knowledge of what happened or why it happened or under what circumstances it happened. I think that Detective Drabeck, in his deposition, stated that as it relates to Gaynor's murder, that although he was a suspect in Adams' murder that he wasn't charged with because everybody recanted, that he opined that Adams' murder was not the nexus for Bibby Gaynor's murder. That's what he says on page 29 and 30. Instead, he believes that the murder happened out of pure opportunity, not revenge, not retribution. And that's his sworn testimony.
State, just real quick, what's your response to that in regards to?
Your Honor, since the depositions have been taken of those detectives, Queso or Hakeem Robinson, very prominent ATK member, has since been convicted of that crime. And so understanding the defense's argument that the weight of that evidence could be that there's some other reason why that killing occurred, it is yet another act of violence which occurs months after Mr. Howard is arrested for the murder of Joe Rod Adams and killing the other person suspected to have been involved. So the two 6-block members that are allegedly involved in the homicide of Joe Rod Adams in 2018, one of whom is arrested for that murder, the other of whom is killed in February of 2019, and then obviously now subsequently convicted of that murder.
Okay, thank you.
Judge, next briefly is Antonio Tilley, October 7th of 2023. Tilley, there'll be testimony from detectives again, and I'm not going to go over each time when I talk about testimony from detectives. The court already knows my feeling on how this testimony is going to be elicited from detectives and where they get the information. And I think at the root of the problem, it all is the same. So I'm not going to say that every single time, but every time I mention a detective and every time I mention what that detective is going to testify to, it's really under the same circumstances and same ability that he's going to be testifying to. Somebody else told him that we don't know who it is. Some social media post said it. Some Instagram Live said it. It's not documented. There's no report. There's no witness that's going to testify to
But
it.
can't gang experts testify to that?
No, Judge, I don't believe they can.
Okay.
Tilley was supposed to be an ATK member. Detective Anderson was the lead detective. Essentially, this was a contract killing. That's what the detective said who investigated the murder. And essentially, it was done by Jaquan Mills. Jaquan Mills is not a gang member. To my knowledge, and based on testimony from detectives, Jaquan Mills is not affiliated with any gang. Essentially, as I understand it, Detective Anderson testified that the suspected contractor is a guy named Paul Anderson, who is now doing a 25-year sentence for drug-related activity. I don't believe there's any indication that Copeland or Anderson are related to 1200 or 6 Block, at least on any basis I know, unless somebody's going to testify to it now, and probably under the same premises that they're going to testify to everything else that they testify to. Anderson then did defer to Detective Nieder in his deposition, and essentially he said, my understanding is that Detective Nieder suggests that Tilly had something to do with Cedarian Copeland's son being shot. So that's potentially the reason all this occurred. We now get to October 7th, 2023, which is Charles Foolio Jones. Obviously, that case is unsolved as well. Now we start dovetailing into evidence I believe is, in fact, potentially admissible against one defendant and shouldn't be admissible against others.
Which is what?
Which is NIBIN matches between the shell casings recovered on October 7th at the scene and casings found in Sean Gathwright's vehicle. And essentially, Detective Nieder, based on the same analysis, is going to say that Jones was shot in retaliation for Tilly. And he believes that Isaiah Chance was involved, and his opinion is that Chance and Gathwright were close friends, spent a lot of time together.
Well,
and,
the state's not going to be able to get into that.
well,
It's unsolved, and Detective Nieder is not going to be able to opine that he thinks Isaiah Chance was involved in the attempted murder of Charles Jones.
well, that's been what's been suggested up to now. And
No.
am I mistaken? I'm mistaken.
Judge, we wouldn't go into that sort of opinion testimony. We do plan on presenting the physical evidence that ties him to that,
Yeah.
as well as any statements he made through other, but not through the opinion of
Right.
an officer. They have not charged it.
Not relevant to Mr. Murphy and not admissible to Mr. Murphy.
Well, it's a conspiracy charge.
Judge, again, we'll get to that because that's what the supplemental,
Well, that's a separate issue. So
right,
let's just
supplemental
stay
issue.
let's just
Yeah,
stay
Judge,
focused. So, listen,
detect-
no gang, if the state calls a gang expert, whoever it may be, they're not going to be able to opine about culpability of anybody who hasn't actually been charged or arrested or proven guilty. So that's not going to happen.
Okay, because certainly Detective Nieder was very clear when he said that Chance was upset with ATK.
Well, I understand. Law
Got it.
enforcement says lots of things in depositions that never come before a jury.
Understood. And that's why we want to make sure that that's
Yeah,
covered in a
it's
motion
not.
like this. Judge, in an incident-by-incident review, in addition to the other incidents that are set forth in the motion, but they don't matter anymore, let's take these 6. We believe that it establishes that the state doesn't possess witnesses with first-hand knowledge capable of establishing gang membership, internal group dynamics of the gang, retaliatory decision-making, or coordinated action amongst these groups, part of the reason being that they're hybrid groups and nobody is accountable for anybody else. And that is clear by the nature of the detective's definition of this type of association.
Sure, and I indicated in my email yesterday that you all would be given 20 minutes each, so I haven't been timing you, Mr. Gonzalez, but
I hope
I'm
you're
sure-
not, Judge. Don't start now.
I am not, but I'm sure the other counsel would like a chance to weigh in, so I'm going to give you 5 more minutes.
Yes, Judge. Your Honor, when we talk about Hayes and Richardson as it relates to,
The admissibility,
yes, Judge, which is part of this, a large part of this, the severance issue as well as the intertwined evidence. I think that, Hayes and Richardson are co-defendants.
correct?
They were tried together, but with separate juries, notably, and essentially.
Because of a Bruton problem.
Judge, there's no brutal problem here. There's no antagonistic.
No, I know,
defenses
not in
here.
our case. In Richardson Hayes, there was a brutal problem, which is why they had two separate juries, but the case was tried together.
And Judge, although the evidence is similar as to both of them, I think Hayes is a little more illustrative in its opinion. And essentially, in that case, what I want to make sure the court understands, my position, that this is a feud between PCE and 187. You've already heard, things about that, so you can understand the interrelationship. And essentially, these two gangs got sideways at a Kodak Black concert in November of 2015. And essentially, that spawned a street war between them that lasted approximately 76 days. And those are the intertwined evidence that the state admitted over objection in that particular case, which is a far cry from the level of alleged inextricably intertwined evidence in this case.
Well, in the Hayes case in particular, and for the record, we're referring to 338 7 3rd 1123. In that case, the specific time frame as far as the historical gang evidence that was admitted was November 25 through January of 2016. That was the specific time frame. And I would just note for the record that in the Andrews case, I did allow Detective Nieder to discuss, I believe, the incidents of violence which kicked off in 2023. Like, you had the two incidents in the 2018, 2019 timeframe, and then there really appeared to be relatively quiet, and then in 2023, the violence cropped up again. So with regards to Ms. Andrews, I did permit Detective Nieder to testify to the history from the 2023. And I do believe, because Mr. Howard testified, that some evidence regarding the killing of Joe Rod Adams came in because he was actually a witness. So,
Fact evidence as to his involvement in that murder.
right.
Judge, the big difference here is that in Hayes and Richardson, firsthand knowledge, there were multiple witnesses that testified that the defendants were members of gangs, they were members of the same gangs, they interacted with the defendants in this case, Hayes and Richardson. In fact, Mr. Bradford testified to what their street names were. He testified they were both known as shooters in the gang and had participated in shootings in the past. That he, on many of the photographs that were entered, was able to say, I know that photograph.
Well, I agree. In that case, I don't see, and I'm not sure if the state called a gang expert or not, but in the reported opinion, the history of the gangs came in through gang members, correct?
Yes,
State?
Judge.
Yeah.
Which is the way it should be.
Well, that's why I asked you if gang experts could testify to that, and you said you didn't believe so.
No, Judge, I don't.
Okay. So I'll hear from the state on why gang experts can testify to that.
And so, Judge, if your court's read the opinion, you're not going to give me much more time. You're glaring at me. I get it.
I'm not, for the record, that's not a glare, Mr. Gonzalez.
I didn't want the record to reflect that.
It's just a mindful look.
Yeah, Judge, and I didn't want the record to reflect that actually as it was said. If you go through those two cases, with Hayes being a little more illustrative, you can see the 180-degree difference between those cases and these. And one of the major arguments of Mr. Murphy is that in circumstances like this, that's what the state needs. They need a firsthand witness to corroborate. They corroborated the videos that were admitted, the witnesses, the firsthand witnesses. They corroborated the photographs that were entered. They went so far as to be able to corroborate the car that was stolen and used in the murder because Mr. Bradford, the witness, supplied it. They were to the defendants. They were able to corroborate the gun that was used.
And I don't disagree. It's a separate issue. So,
Judge, at the end of the day, again, I would rely on the motion and the particularity it sets forth, and essentially tell the court that the state can only establish the connection between the charged act and the prior act by relying on the detective's in my estimation, I believe buttressed by the case law, improper testimony of lyrical interpretations. We skipped through that part, but it's in the motion, and what somebody thinks something says without it being coded language, without it being a circumstance where this language is used over and over and over and over again, which would allow an expert to testify to it. I do not believe that any of these detectives should be allowed to testify as experts based on the arguments that I've made and also those that are in the motion. I've included their depositions, Judge, which I think are really instructive when they're talking at length about their jobs and what they do and how they do it and how they get their information. I don't think the court has to rely on me. I think it's very clear in the depositions under oath. And finally, Judge, that they are drawing these clues from songs that are released by artists that are commercially viable. They can't establish gang affiliation other than maybe by 874 criteria, which I think is different than testimony that would allow this evidence to be relevant and admissible, and especially to show that there's a motive for these killings. It should be done with competent, non-hearsay evidence, and those prior acts are rendered irrelevant when they're not done that way.
Okay, very good. Okay, let's see. Mr. Sonardi, do you have a motion as it relates to Davion Murphy on this topic? Or have you adopted Mr. Gonzalez's?
Correct. As to the 6 prior acts that the state intends to introduce, both as to Mr. Rashad Murphy and Davion Murphy, we will adopt the arguments of Mr. Gonzalez on behalf of Rashad Murphy, and also add that we can establish that Mr. Davion Murphy was basically incarcerated either in the Jacksonville County Jail and Florida State Prison from 1916 until almost to January 2023.
Do you mean 2016? You
Yes.
said 1916.
I apologize, Judge.
2016.
2016 until January 2023. The same argument as provided by Mr. Gonzalez on behalf of Rashad Murphy. Mr. Davion Murphy is not alleged to be a suspect or anything in either of the 6 prior acts that the state intends to introduce. I concur also in the evidence that's available to even establish that Mr. Davion Murphy is in fact even a gang member of 1200. Again, he was incarcerated, the 5-year window under the statute had expired. He is at most an associate. So again, we submit that contrary to the state's position, that introduction of those 6 prior acts as it applies to Davion Murphy would be so highly prejudicial as to not to overcome his probative value. We would ask the court, as to Davion Murphy, to exclude that testimony.
Okay. And Sean Gathright, defendant's motion in limine to exclude collateral evidence. Mr. Wise.
Your Honor, I guess before I begin, maybe for a point of clarification, there are, as you've heard, casings found in Mr. Gathwright's home that not even matches to 2 prior incidents. I think the only one that's of the 6 we've discussed is the prior Charles Jones shooting. So
Correct.
I don't know if the state is, it sounds like the state may not be seeking to admit evidence regarding these other 2 alleged incidents, one of which I don't think they know what or who the target of was. But could I just ask if do I need to address the Byron Walker incident and this unknown shooting from 2022?
We can speak to that. All the NIBIN correlations to the other shootings from the traffic stop as well as from the safe of Mr. Gathwright's house, we are not going into. The only ones that we are going into were the ones that were actually confirmed, not just NIBIN, but FDLE
Right.
matches
For
to,
Mr. Jones.
Correct,
Okay.
the attempted
Okay.
murder, and then to our case
Yeah.
here.
Okay, so that streamlines it a little bit.
Okay.
So, Your Honor, Mr. Gathwright's a little bit differently situated because he's clearly not a gang member. No one's even alleged that he was a gang member. As you heard from all of the alleged experts who testified, I guess it was last week, none of them had even heard of his name prior to being contacted by Detective Ramos. The only connection that the state has as to Mr. Gathright is this allegation that he was friends with Isaiah Chance. And even that, I think, is pretty speculative. There clearly were communications between Mr. Gathright and Chance, but I believe there's some thought that they must have been best friends, and I don't even think there's evidence to support that. The only thing connecting Mr. Gathright to these gangs is his communication with Chance, and quite frankly, I think that the connection between Mr. Chance and the gangs is pretty speculative as it is, but that's the only connection. So he's clearly not a gang member, and I don't believe he can even really qualify as a gang associate just based on the fact that he's communicating with Chance. But that...
Well, the state has not identified.
No.
And then, as far as I can tell, they're not seeking to prove that Mr. Gathright is a criminal gang member or associate, just a member of a conspiracy involving other gang members.
Judge, we're not approving an enhancement against him, but he certainly qualifies as an associate by the meaning of the statute with his association with Isaiah Chance. And Judge, we believe it's the jury's decision to ultimately find who is an associate and who is a member.
Okay. All right.
And again, Judge, if that's the case, then basically everyone Mr. Chance has ever talked to is a gang associate. I know that's probably a separate motion, but when we talk about relevance of all these other prior gang activities, the only connection, again, to Mr. Gathright is the fact that he's communicated with Isaiah Chance. Talking about each one specifically, the Gerard Adams incident, Mr. Gathright would have been 13 years old, I believe, when that took place. The Bibby Gaynor incident, he would have been, I believe, 14 years old. There's nothing connecting him in any way whatsoever to the Jaquan Pickens incident. Same with the Jacoby Beals. And the Antonio Tilley. The only connection, again, with the Charles Jones incident that takes place on the same date is the casings that are found in the Nibin matches. But as you heard from the detectives last week, Mr. Gathright was not even on their radar in that case until the casings came back. So it's really just the mere fact that these casings are in the house. There's no explanation as to how they got there or whatnot. And there are, by the way, as you heard, there's a substantial amount of firearms and firearms evidence within the house that's searched. So that, Your Honor, I believe the relevance, whatever relevance would have all these incidences, and really the only one as to Mr. Gathright that could have any relevance whatsoever is the Charles Jones shooting. But the undue prejudice would far outweigh whatever relevance that evidence might have. I cite two cases in my memorandum that I think are remarkably similar to what we're dealing with here. And looking back now, I probably should have referenced them with regards to the severance issue too, but it's Thomas and Gilly, and it doesn't appear that these were cases that involved gang issues, but it was very similar in that there are prior shooting incidents involving allegedly rival drug dealers and then their associates. Maybe they were connected with gangs, but it's taking the gang word out of it. I think it's really the same exact situation we're dealing with here. There were prior shootings, and then someone is killed in one of these prior shootings, and then there's a shooting that takes place of this prior victim's associates, and then a bystander is killed. So when the defendants were being charged with the shooting of the bystander, and Gilly, and it's not clear why he was severed, but he's severed and tried separately, the state brings in evidence of all these prior shootings, and that goes up on appeal after everyone's convicted. And in both cases, the second DCA says these instances were not necessary to describe the shooting. It was a pretty straightforward, the allegations of the crime they were actually being tried for were pretty straightforward. The courts found they did not need to get into these prior shootings to describe what took place, and it became, as I fear will happen here, a feature of the trial. And for those reasons, both of those defendants' convictions were reversed. And again, I'm not sure why they were severed, but it would appear that Gilly may not have had involvement in these prior shootings. I don't know if that's the case or not, but for whatever reason, he was severed, and it appears, based on my reading of those two cases, it may have been for that reason. But all these all this prior evidence comes in both cases it becomes a feature, and in both cases the convictions are reversed. And I think it's really the same exact situation we're dealing with here, especially as to Mr. Gathright, because he really has no legitimate connection to any of these gangs.
Okay, very good, thank you.
Judge, we would adopt that argument on behalf of Mr. Rashad Murphy as we would all other defendants' arguments.
Sure.
Same here on behalf of Damian Murphy, Your Honor.
All right, very good. Mr. Petratus?
We filed our own motion, but we would adopt the motions of Mr. Gonzalez and Mr. Wise and their arguments, and I'll try not to be too repetitive.
Okay, and this is Isaiah Chance's. It's titled Defendant's Motion to Exclude Inextricably Intertwined Evidence at Trial.
Yes, Your Honor.
Okay,
And just
go
to
ahead.
go over the murders, again, very briefly, we have one from 6 years ago, the Spaz shooting, which is a alleged 1200, not ATK, of which Mr. Chance is purportedly a member of. And I think it's important to know that Robert Howard, who's, as the court is aware, is going to testify, at his deposition denied being a gang member of 6 Block. So I understand that they're going to try to get it a different way, but they're going to get someone here, like Mr. Gonzalez stated in the Richardson case, Richardson-Hayes case, but this time this person's going to say, no, I wasn't a member of 6 Block. Then we have a 6-month gap. We have the Gaynor shooting. That is alleged, well, it's not alleged, it's a charge of ATK. The next 4 that all occur in 2023 are all unsolved. And no one is going to testify as that was involved in any of those shootings. You're going to have no gang members to come here and testify to that. In the Pickens, in the state's motion, it says ATK is believed to be involved, Again, it needs to go back to Detective Nieder. And the court asked, the court said you can't opine on someone who committed a crime that we don't have conviction. And I would argue that you can't opine the gang affiliation of a person who we don't know committed the crime. You can't, it's another step that requires Detective Nieder to opine. Detective Nieder, in his deposition, stated he gets his info mainly from social media. He does talk to gang members, but he gets general information, not specific information for them. They are not confessing to crimes for him. That's not what's happening. He's just getting general background information from them. And I would argue that's not enough to come in and tell us who committed these crimes and say it's ATK, it's 1200. The Beale shooting is alleged to involve 1200, not ATK, and as Mr. Gonzalez stated, the last Charles Jones shooting has not involved a gang at all. They're going to say that Mr. Gathright is an associate, but again, that involves being friends with one gang member at the most. In Richardson, again, it was 76 days, and the court said this was a continuation and consequence of the preceding events. And I'm going to argue that 6 years and 5 years ago, there's not preceding events to this crime. I would argue even, we have an 8-month gap between the last event in this historical gang war and this shooting. The court mentioned Griffin in the Richardson case. It said, to prove its case, the state is entitled to present evidence which paints an accurate picture of the events surrounding these crimes charged, surrounding these crimes. In the Richardson case, again, 76 days, that happened one after another in a 2.5-month period. That is not what we have here. Richardson, one of the reasons they allowed it in, from my reading, was that they wanted to get the state why these victims were in fact the victims. We had a toddler and we had 2 elderly, or maybe not 2, but an elderly grandmother and a middle-aged lady, and they wanted to explain how they could be the victims in that. But that's not the case here. We have someone, Charles Jones, who is not a random civilian. There's going to be gang evidence presented about Mr. Jones. There's going to be gang evidence presented about all the co-defendants. There's going to be evidence of their involvement in the gang, testimony of a rivalry between ATK 1200 and 6 Block, all without the need to mention any of these prior shootings. The motive can be clear through the state's evidence without having to mention any of these shootings, and I think that's what the court should require. one other thing that hasn't been mentioned is these cases mentioned it cannot be a feature of the trial.
Correct.
And I find it hard to believe that if the state puts on 3 gang experts and then all the witnesses, and I'm going to use witnesses in quotes, to come in here and testify to show the other murders 6 times, that's days. It's days of testimony.
No, and I do just have a little experience because the Andrews case, that's not what happened. Detective Nieder testified in his capacity as a gang expert, just historically, as far as the history of the gang violence. The state did not bring in, my recollection, any witnesses other than Mr. Howard, who was a victim in this case. So.
Well, we're talking, and I understand that, but I think that's going to be different in this case because I think they're going to try to bring in more.
Well, we'll see. You're right. It cannot become a feature of the trial.
And I find it, well, I understand, but I just find it hard to believe it will not end up being a feature of the trial if we're talking about 6 other murders. I don't know if that's exactly what happened in the other case, but everything else that I would get to is either in my motion or has been stated by the co-counsel, so that's all I have.
Okay, very good. All right, state any quick rebuttal just as to the 6 previous incidents that the state wishes to introduce
Judge,
into evidence.
Judge, we are certainly not going to make it a feature of the trial. We do plan on calling one detective to really go over the historical gang war, so it will not be a feature. However, we are going to add
And
some...
who's that going to be? Do you know?
Judge, we believe it's going to be Detective Nieders. The other 2 are listed because we still have to show gang enhancements and stuff of that nature, and I do believe their expertise adds to...
Sure, that's a separate issue.
That's a separate issue.
In the indictment, the state did specifically allege that Isaiah Chance, Rashad Murphy, and Davion Murphy were either criminal gang members or associates.
That is correct, Judge.
Okay, but not Mr. Gathright.
We did not, Judge. But Judge, there are going to be, I know that Mr. Gonzalez has kept saying, like, this is all based on hearsay. That is not true. There were some additional witnesses that were listed that were involved in those 6 other cases. And again, it's not going to be a feature. What I plan to do, Judge, is to have either a first responder just testify briefly within 2 to 5 minutes that they responded to that homicide, who the victim was, and then the gang expert is later going to connect up that victim was actually a member of one of these gangs. And then the next day, these are real things, real facts, real deaths that did happen, and the victim of one gang is killed, and then the next day, a victim of the opposite opposing gang is killed. And so, Judge, this jury should have a real, true, accurate picture of the very gang war that is going on. And these incidents also, even though they exceed the time frame, I understand what they're saying about Richardson and Hayes, the particular of that gang war, the escalation of violence, but it was 6 shootings that occurred back and forth, happened in a very short period of time. It's different in this case, but the incidences that we have selected are relevant to this case, and some of the relevance doesn't even have to do with any of them. It has to do with the victim and as a consequence with all of them, because the victim in this case, the motive for, and obviously one of the rap videos that we're going to introduce, and the motive for why they did not like him and were very upset and angry enough to kill him is his drill rap videos. And certainly that also goes to our gang experts' testimony. They do have specialized knowledge. This is something that they all have years of experience in this gang unit where they are monitoring this activity on social media, and it's not hearsay. They are visually monitoring it, and they see a death happen, and then within 2 or 3 days, sometimes within the very next day, there is a video that is posted detailing and ditching the person who was just killed.
Well,
all of that.
Desecrating someone's gravesite is pretty provocative behavior.
Yes, Judge. All of that is part of this gang war back and forth, and the jury needs to have an accurate view. And some of this is highly prejudicial towards the victim because the victim is out there doing the same thing, which makes him a target. And he is dishing and disrespecting the close members, people that we can connect to them either through their wearing necklaces, they have posted their own videos, Judge. All of that is relevant to this case and is inextricably intertwined and shows why he was targeted and why he was killed. And Judge, when you talk about the hearsay, that is why we have listed either a first responder or the detective. Detective Nieder actually responded to some of those incidents. So we are not going to call 6 witnesses, but certainly the ones that he did not respond to, we have just listed a first responder, or we have listed the detective who actually went on scene and can say, on this day I responded, this person was killed, and his name. And then we will go to our detective to say that that is a confirmed member of 1200, or that is a confirmed member of 6 Block or Bully Gang, which is a subset of 6 Block. So this by no means is going to be a feature of the case. And all of these detectives, even within the depositions, were honest and said they didn't know that that was an unsolved case. But certainly after a case where a victim is identified as a gang member and the opposing group then posts a video claiming credit, making fun of that victim's death the very next week or within a short time period, certainly that is a specialized knowledge, and it goes to the very heart of this case and the very motive why our victim was killed. And the probative value of motive, wanting to kill the victim, has a high value, and it is not going to ever be outweighed by the prejudicial nature. And that is what Harris and Richardson really explain when it let in 6 other shootings into a case, because it gave the jury an accurate depiction of the war, the escalation of this gang war, which led to those 3 people being shot and a child being killed. And so, Judge, that is what we have here. The prejudicial nature is not so significant. Some of these deaths are from our victim side killing the other side. The ones that are targeted, they are not charged with, and none of the detectives said, with the exception of the attempted murder, and we know we're not going to elicit what their personal opinion may be, but certainly there is going to be physical evidence that ties this as part of the conspiracy, that they tried to kill him before and they weren't able to do it. So certainly all of those incidents, even though we go outside of that time period in Richardson and Hayes, are still relevant. They're inextricably intertwined, and those specific cases are tied to our victim and the defendants in this case as being relevant, and again highlight the animosity between these 2 groups. They're making fun of people that are killed back and forth. Some of these shootings within the very next day, including the attempted murder of Charles Jones, was done the very next day after members of the opposing side, one of their members, was shot. And so that is the state's argument, that this is all relevant. It is not going to be a feature of the case, but it goes to the very heart of all of this group's motive to kill Charles Jones, the victim in this case.
Okay, so in the Hayes case, the court stated as follows, and get the page number, at page 1130 of that opinion, in establishing its case, the state is entitled to present evidence which paints an accurate picture of the events surrounding the crime charged, but cannot make the evidence of other crimes the feature of the trial or introduce evidence solely for the purpose of showing bad character or propensity. Collateral crime evidence, regardless of its status as similar or dissimilar fact evidence, is admissible if it is inextricably intertwined with the charged crime. Collateral crime evidence is inextricably intertwined if it is necessary to 1, adequately describe the deed, 2, provide an intelligent account of the crimes charged, 3, establish the entire context out of which the charged crimes arose, or 4, adequately describe the events leading up to the charged crimes. Additionally, evidence is admissible if the prior incidents are relevant to several material issues, including motive, intent, and identity. So based upon the facts and the motions and the arguments of counsel, I am going to find that the identified incidents in the state's motion in limine are inextricably intertwined, and they are relevant to motive, intent, and identity, okay? So those, just as a threshold, those 6 incidents are admissible in this case. All right, I'm going to take a recess, and so, actually, before I do that, so as it relates to the state's motion in limine regarding those 6 incidents, I'm going to grant it. Let me just take a look here. I'm going to grant the motion, but I'm going to reserve ruling regarding the introduction of any videos, any rap videos that the state seeks to introduce. And once the state does their evidence list, as far as what they're actually going to attempt to introduce, then if there are further objections as to any individual videos, defense can renew their objection and I'll rule. Okay? All right. So as to Isaiah Chance's motion to exclude inextricably intertwined evidence at trial, that motion is denied. However, defense, as I indicated, can raise contemporaneous objections to any individual items of evidence. And with regards to Sean Gathwright's motion in limine to exclude collateral evidence, that is denied. However, again, defense has the ability.
Well, and can I add, because I actually specifically addressed those other 2 instances the state is not seeking to evict, so could that be?
Yes, it's denied as to the 6 incidents that are in the state's motion that I've articulated here today. It would be granted to any other incidents that are not part of the 6, and that goes as to all defendants. Okay? So we're just talking, so it's denied in part and granted in part. Thank you for that clarification, Mr. Wise. And then as to Rashad Murphy's second motion in limine, there were a number of items, Mr. Gonzalez, that you raised. At this point, it's denied in part only as to the 6 previous incidents that I articulated here today. Okay? All right, we'll take a break, and I'll be back at 10:50.
Court's in recess.
Going to be objections. I want to handle those after the state has identified which videos they're going to actually seek to admit. And you all have had a chance to review them, and then I will handle specific objections after that happens. Okay? So I'll reserve ruling on specific objections to any specific videos that the state intends to seek. Or, for that matter, any other evidence related to these 6 prior incidents that I am allowing into evidence. Okay? All right. So, there are a couple of, a couple other motions that were filed related to the gang issue. I know that Mr. Gonzalez, you have defendant's 3rd motion in limine as to gang affiliation, gang identification, gang charts. Ready to discuss that?
Yes, Judge.
Okay.
Judge, this motion does have some dovetail effect.
Okay.
As it relates to some of the court's prior testimony, argument, and rulings. Essentially, the motion seeks to prohibit the admission of opinion testimony, again, identifying an individual as a member or an affiliate of a particular gang, defined in 874.03. Certainly, as the court knows, one of the things that the state intends on doing is admitting gang charts that would include victims of prior uncharged incidents, and probably seeking testimony as to those people and their deaths.
And State, are you actually intending to offer these charts into evidence?
Judge, we are going to use them as demonstrative exhibits.
Okay.
Certainly the same issue, whether they come into evidence or not. The jury obviously is going to see them, hear testimony about them, and the same limine issue, I believe, is still intact, and that is that I don't know and I can't anticipate the state's testimony. That's what these motions obviously are for.
Right.
But many or some of those individuals, whether they are killed by some other member of that or another gang,
I'm sorry, and are the charts that you're going to intend to use as a demonstrative, are those prepared yet, or they're going to be?
Yes, Judge.
They are prepared.
and they're exhibits in the motion, Judge, too.
Okay.
And essentially, they include a bunch of people that are dead. And not only people that are no longer with us in the 6 incidents,
Right.
but otherwise.
Yeah. Why do you need the chart?
Judge, I think it's a demonstrative aid, and there are a lot of gang members that are in the 6 incidents or in the videos, or there are actually other pieces of evidence that are either from the defendant's Instagram accounts or stuff of that nature, Judge, so that places them on the chart so that it can assist the jury to keep track of who is with whose group.
Is the state going to elicit testimony as to each one of those individuals as to what their gang criteria is, how they are documented as a gang member, under what circumstances? Because, again, a picture of someone.
Right.
Judge, no, and we may further modify and take some people out, Judge.
Yeah. So what I'm going to do, I'm going to reserve ruling on the gang chart. State, you're not going to use it in opening, okay? And you need to be very conservative, even though it's a demonstrative aid, you need to be very conservative in who you put on that chart.
Yes, Judge.
And honestly, that, to me, this is more of a discussion about whether or not you can use it in closing arguments, depending upon what the evidence is, okay?
Yes,
So
Judge.
that's my initial thought on the gang charts.
And so the court's just going to reserve until we see another exhibit?
I'm going to reserve ruling, but I am going to specifically find that the state cannot use that demonstrative in openings. Okay, so we just need to see what the evidence is, and then we'll, as we get to closings, we'll see if there's further objection, then I'll let you know if they can use it as a demonstrative in their closing argument.
Judge, the next area of the motion is the actual documentation of Mr. Murphy, of Rashad Murphy. The court heard testimony from Detective Griffin, who is allegedly the person who follows and has specialized knowledge as to 1200, and documented Mr. Murphy as a 1200 gang member a month after this shooting took place. He was not previously documented as a gang member, only having done so July 23rd, a month after this particular murder, which is curious in and of itself. Now, granted, the position is, pursuant to testimony, is, well, we can document somebody anytime we want. We could have criteria for them in 1921 and not document them until 1924. I said, well, even if you've already got criteria under the statute, isn't that the point of this? To have everybody know, law enforcement and other related people that have access to the fact that somebody's a gang member? Well, yes, but there is no timeline. Everybody does it differently. Everybody has their own style. Some people document after 2 criteria, some 3, some 4. But the gravamen of the situation at this particular juncture is, number one, Mr. Murphy was documented as a gang member a month after this shooting took place. Secondly, although I recognize there is statutory criteria that document somebody as a gang member, and certainly I can take issue all I'd like as it relates to that criteria and what it means in and of itself, the one thing that is undeniable is that in order, I believe, for testimony to be heard by a witness, in particular a gang investigator, that testimony still can't be hearsay. And it's the same admission standards as it would be any other type of evidence. And in this particular case, Mr. Murphy is documented a month after the shooting because there's been a documented, reliable informant that identifies him, A. B, he adopts the use of hand signs. C, he associates with one or more known criminal gang members. And D, he's observed in the company of one or more gang member 4 times or more. Again, it's a statute. I'm halfway in shock, but it's a statute. And essentially, the first category, that being that Mr. Murphy is subject to a reliable informant, that is really not the case. It's a reliable documented informant. The informants, 2 of them, that Detective Griffin, or not even Detective Griffin, by the way, Judge, not Detective Griffin, somebody before Detective Griffin, documents Mr. Murphy with is somebody who stopped for a possession of marijuana misdemeanor. They have a list of people when they're doing whatever investigation they're doing on that misdemeanor marijuana. Hey, do you know so-and-so, 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 and so-and-so, and Rashad Murphy, and are any of them gang members? Maybe number 3, number 5, number 7, and Rashad Murphy are gang members. So that is supposed to be check, an indicator of his documentation as a gang member with no name, no date, no incident as it relates to the stop, doesn't tell us where, doesn't tell us why Mr. Murphy is a gang member. It is that statement from a stranger under those circumstances that is going to be testified to as Mr. Murphy's gang criteria number 1. That happens twice. Same circumstance. And I won't go into the second set of facts, but extremely similar with no direct evidence as to anything other than it happened. Secondly, the second criteria, I believe, lacks foundation and is entirely speculative. This particular circumstance happens where Detective Griffin says, yeah, I saw Rashad Murphy give a hand signal. And he points, and I said, what is the hand signal? He says, well, I can't really do it. I mean, I can't really tell you exactly, how it's done, but it's in a video. So we can look at a video, and I'm not a gang investigator, and certainly Detective Griffin says, hey, you look at that. But there is no specific movement in hands or presenting a signal or a handshake that I believe is shown within that video. That's criteria number 2. Third criteria is that Mr. Murphy is allegedly identified as a person depicted in a music video, not one of the ones that we're talking about. And it wouldn't be Detective Griffin that can identify him based on having looked at that video, because he hasn't had and didn't have any interaction with Mr. Murphy. It would be something told to him by another detective. And on top of that, as it relates to identification, I think the law is clear that someone can't identify someone based on a prior interaction with them, when in fact the jury can look at a video, if that's what the state's objective is, and decide whether or not it's Mr. Murphy or it's not Mr. Murphy. But the way that it dovetails into this argument is, it is a criteria which the state is going to rely on to be able to provide the testimony that Mr. Murphy is a gang member, which, as the court certainly knows by now, that is a critical statement to be made for the jury's consideration, considering the totality of the evidence here as the court has ruled to be admitted. So to that extent, I would just argue that, first, a witness cannot testify to a legal conclusion that an individual is a statutory gang member because it is based on hearsay evidence. And we still have to go back to the evidentiary foundation as it relates to testimony at a trial, and I believe that the case law would buttress that. There's a distinction between the state offering fact-based testimony for which a jury can determine whether a legal element is satisfied, and there's a difference between whether it's opinion testimony based on maybe not even what that detective did, but what a detective before him did. And I would suggest to the court that that's impermissible, and I think that's what the state intends in this case. It's going to present evidence that is, and it can't present something that is a statutory conclusion that's cloaked in some type of official authority.
Well, you're saying that the detectives, if they testify as a quote-unquote gang expert, that they can't tell the jury that any of the defendants meet the statutory definition of criminal gang or criminal gang-related activity, correct?
And not especially as it relates to Mr. Murphy. I don't know about in general based on what the evidence is and based on what they're going to testify to. I don't believe the state can rely on hearsay to establish gang membership, and that I think is reflected in the case law in the Fossum case and in the McGill case. And essentially in Fossum, the state found that recognizing that although experts may rely on inadmissible evidence, that it may not be used as a conduit for evidence and may not testify regarding their consultation with others. So that is, I think, an issue in McGill, holding that the trial court's reliance on hearsay testimony regarding a defendant's gang affiliation in rendering sentence, this is a sentencing case.
About McGill?
Yes.
Yeah.
It's a sentencing case. Require reversal and new sentencing hearing. And although I understand that certainly evidence that might be admissible in sentencing may have a different admissibility standard as it relates to a trial, usually admission of sentencing evidence is broad and more easily attained than what would be allowed in a trial.
Well,
So-
in that case, I guess at sentencing, the judge, it says the trial judge improperly relied upon unsubstantiated allegations of McGill's gang involvement in the form of objected to hearsay from a police detective.
Correct.
Once the truth of the hearsay information presented at the sentencing hearing was specifically disputed, the state was obligated to carry its burden of corroborating the accuracy of the information. Okay.
Correct.
So hearsay, it's admissible. You would concede that hearsay is admissible in an expert opinion, correct?
Well, as long as it is relevant and as long as it is within the bounds of the rule.
And has some indicia of trustworthiness?
That's correct. Judge, as it relates to identification of the defendant through music videos, we're gonna hold off on that. The court has.
Yes, I really just would prefer that we not talk in the abstract, and that when it comes time for me to rule on those specific objections, that we have the actual exhibit, so that way I can look at it if need be, so.
Judge, understood. Admitting improper opinion testimony in this particular case, gang affiliation, is even more uniquely inflammatory. Now, granted, evidence that you don't like or evidence that may, in every case, there's going to be prejudicial evidence. That's the nature of a trial. But in this particular case, it's, in my opinion, it's going to invite the jury to associate potentially Mr. Murphy with other individuals that may have and may be properly designated as gang members. I can't tell you that. Counsel, if they choose to, are going to have to argue individually about the criteria used and the evidence used in order to make that designation. I can only speak as it relates to Mr. Murphy, but it also has a substantial likelihood, again, of a spillover effect as it relates to his association with anyone else involved in the case. Concluding, Judge, I'm not suggesting to the court that admissible factual evidence related to gang affiliation be excluded. What I'm suggesting is that in this case, normally I would say witnesses, but the only witnesses in this case that are going to talk about anything in terms of Mr. Murphy's gang affiliation or involvement with others are going to be law enforcement officers that that relying on hearsay to the extent that they are, and in addition to substantive interpretation, which that's part of the motion, and with particularity that you'll read with regard to those lyrics in other motions that I've drafted, and improper opinion identification that establishes that classification, its prejudice is outweighed by its probative value if it's even relevant. I am suggesting to the court that the motion in limine be granted as it relates to testimony from detectives that offer legal conclusions that an individual qualifies as a statutory gang member based on the means and manner upon which they gained that information, and not providing the foundation for its admissibility. Now, it would be a different story if we could cross-examine a detective regarding a report that was written where so-and-so on a particular day, based on this particular knowledge, told us that Rashad Murphy was a gang member. Okay, that may be hearsay, but it would indicate to us the specificity that would allow us to rely on that opinion. And we will not find a single instance as it relates to Mr. Murphy, and I might even suggest some of the other defendants, whereby a detective is going to tell us when something took place, who it took place with, where exactly it happened, other than to tell us we stopped somebody for a misdemeanor possession of marijuana, we gave him a list of people, and he ticked off the number, however many number that might have been, based on what the list was. He's a gang member, he's a gang member, he's a gang member. That's it. And when I asked about, well, was there any other particularized information that was given? And the answer was no, it was general information. So to that extent, Judge, I believe that it should be prohibited in limine, and certainly that would extend to hearsay-based gang classification testimony, as I've just talked about. It's improper, and I believe it should be prohibited.
Okay, very good, thank you. State, what's your response?
Judge, pursuant to statute 874, law enforcement is permitted to utilize a reliable, documented informant statements regarding each of the defendants' gang affiliation. In addition to that evidence in this case that we have for Rashad Murphy and his affiliation to 1200, we do have several, at least 3 music videos that were listed in discovery. We received notices on those music videos of our intent to rely upon them and the contents therein. Those were certified and provided to the defense as well. In each of those videos, the defendant is meeting several of the other criteria, of which obviously the witnesses are permitted to testify about their opinion as to who is depicted in those videos, because they're being listed as experts. They're certainly in a better position when they're reviewing those videos to determine who is depicted in them. The defendant is, in fact, in many of the screenshots that I have, and I can show the court, I know the court asked for specific examples, but utilizing hand signs which have been identified by law enforcement as those meaning that the defendant met the criteria. Is the court interested in actually seeing those today, or did you want to wait on that? I know there are kind of a blend of arguments being made with this particular motion in limine, so I'm not sure what the court...
Well, at this point, I'm just going to broadly rule on the motion in limine, and then once the state has again identified all of the exhibits they intend to introduce, We can revisit if there are specific objections to any of those identified items of evidence.
Yes, Your Honor.
So we're just kind of talking generally at this point.
I will say that there is direct evidence of the other factors that are utilized or testified to by the detectives which deem the defendant, Rashad Murphy, to be a gang member. That is in at least 3 of the music videos. He is utilizing signs, being depicted in those videos with other gang members, and certainly as gang experts, I'm not getting into that argument, they're permitted to testify about those observations that are being made, and also we have the videos and screenshots from those videos which depict the same. Also, the defendant's correlation with other gang members is documented in more than just those music videos, so in addition to the firearms and gang signs that are used in those, he had been stopped with other gang members. Those stops were documented and law enforcement relied upon the information that was retained in those results as well. Law enforcement themselves have testified that they directly saw the defendant utilizing several of the accounts that they saw evidence of gang activity on. So there's certainly a sufficient amount of direct evidence. I understand that the argument from defense is being looped into this one element from the gang statute that a reliable informant gave a statement to law enforcement, but there are several items of direct evidence, including those music videos, the stops, the defendant's use of gang signs, that the state intends to rely on to establish his actual gang membership. That being said, I want to just draw a distinction between the agency's documentation of each of the defendants as gang members and that being separate and apart from whether they meet the statutory criteria and what the state has to prove at trial as far as whether in meeting that statutory criteria the crime was committed in furtherance or in progression of the gang's objectives. So I understand, again, the defense's arguments regarding the dates and times of the documentation, but essentially it's the state's burden to prove that these things were met at the time that the crime occurred, not what each agency did.
And what's your position on your law enforcement witnesses being able to tell the jury that in their opinion, any one of these defendants is a criminal gang member or associate? Is that not invading the province of the fact finder?
I believe they can testify as to each of they're going to testify that they have documented several items of
Sure, they're going to
evidence.
testify to the statutory factors.
Yes.
Correct. And and what supports the statutory factors. But as far as the ultimate conclusion, isn't that ultimately the jury's decision to make?
I think the conclusion that the witnesses will make are that they are documented with the Jacksonville Sheriff's Office as a member of 1200. Documented with the Jacksonville Sheriff's Office as a member of 6 Block, instead of making a general conclusion that they are documented gang members that killed Charles Jones in furtherance of the gang's objectives.
Okay.
2 separate things in the state's opinion.
Okay. All right.
Judge, quick rebuttal. Were you going to,
No, yes, thank you.
Judge, number one, this confidential informant is neither documented nor reliable, so I would take issue with that representation. At least I understand it's coming straight from the criteria under the statute, but in this particular case, neither of those things are actually accurate. Second of all, I don't believe that any of these detectives are in a better position to look at a still shot, okay, of a video and look at Mr. Murphy and make a determination whether or not that's him.
Well, maybe yes, maybe no. And again, that's going to be very item of evidence specific.
Yes, Judge.
Okay.
And I also asked the court to reserve ruling as it relates to whether or not any of the music videos would indicate or show Mr. Murphy utilizing gang signs.
Okay. Okay. All right. So as to the defendant, Rashad Murphy's third motion in limine, I've already ruled on the gang charts. With regards to gang affiliation and gang identification, I'm going to deny the motion, but again, generally speaking, Mr. Gonzalez, you can always raise contemporaneous objections at the time the testimony's coming in as to any particular factors that law enforcement's going to rely upon. And with regards to the ultimate finding whether or not these defendants, any of them, meet the statutory definition, that's not for law enforcement to opine or render an opinion from in front of the jury, because that's going to be a fact that the jury has to find as to the 3 defendants where the state is seeking or has notified those defendants that they're seeking to have them identified as a criminal gang member or associate.
Judge, in clarification, are you saying that the state's prohibited from eliciting testimony from the detectives that Mr. Murphy has been documented as a gang member from 1200?
At this point, yes, I am, okay? So law enforcement can testify as to any and all of the factors, and law enforcement, for example, Detective Nieder can tell the jury there is a statute that is utilized, and these are the factors, and this is the evidence that supports the factors, but that ultimate conclusion is for the jury to make, okay?
Your Honor, Nick Sonardi on behalf of Davion Murphy. Obviously, we're going to join in on the motion to exclude any designation of Davion Murphy as either an associate or a gang member. My understanding as it applies to Mr. Davion Murphy, I've been provided a photograph from the internet that goes back to 2016 that shows Mr. Davion Murphy with Noah Williams and Reginald Williams, who I believe were documented 1,200 members. That's the only thing I'm aware of. Mr. Davion Murphy is not depicted in any music videos that I'm aware of. The only gang sign that I am aware of that alleges that Mr. Davion Murphy is a member of any gang is at the interview that was conducted in Jacksonville, where he is singing to one of the rap songs, and during the course of that singing, allegedly is instantaneously a gang sign. And again, he is in no social media that I'm aware of. The designation by law enforcement that Davion Murphy is allegedly a gang member, a gang associate, occurs after the homicide here in Tampa. He is not even known to Detective Griffin, who was the gang detective for the 1200 gang, as I recall his testimony. So we would also ask the court to exclude Mr. Davion Murphy designation as even a gang associate.
Okay, thank you. I will deny that motion, but again, the same ruling applies as to your client as it does to Rashad Murphy. Okay? Okay. And let's see here. I know that Mr. Gathright filed a motion in limine to preclude any reference to the defendant as a criminal gang member or associate. You want to discuss that one further, Mr. Wise?
I don't know that it's necessary, Your Honor. I think we kind of addressed it earlier. I mean, it's almost like he just dropped in one day. No one in Jacksonville knew who he was. There was no connection. The only alleged connection is apparently talking to Mr.
Well,
Chance.
State, are you going to seek to elicit any reference or designation as Mr. Gathright as a criminal gang associate?
Judge, no. Now that, Judge, we did not list him under the enhancement in the indictment.
Okay, so that motion's granted.
Thank you.
Okay. Okay. Let's see. Okay, let me go to my next pile, motions.
Judge, did you rule on Rashad Murphy's first motion in limine regarding Ghost 197? Because I thought...
No.
Okay.
Nope. You want to do that one next?
Yes, Judge.
Okay. Mr. Gonzalez, you're up again.
Is there one we might be able to do in the interim so I can catch up?
Yeah, sure. Let's do, I tell you what, eeny, meeny, miny, mo. Let's go with Davion Murphy's motion to, C4 motion to dismiss.
Well, John Nixon, Hardy for the record. We did obviously file a C4 motion, and concisely the evidence, although the state did file a traverse. The evidence as it applies to Davion Murphy is basically alleged that phone records tracked what's supposedly his phone from Jacksonville to Tampa prior to June, I believe it's 22nd. He is then seen supposedly in a vehicle at a McDonald's going through the drive-through on June 23rd. The next time they allege that Mr. Murphy, Davion Murphy, is seen is in a security video at the Airbnb. There is no phone records that place Mr. Davion Murphy either at the clubs that are allegedly visited prior to the homicide or at the Home 2 suites. The next time that Mr. Murphy, Davion Murphy, is allegedly located, or again, supposedly phone records going from Tampa to Jacksonville and the license plate readers. He is not identified at the scene of the homicides, and that is substantially the state's case, and that's what we're alleging. That's insufficient as a matter of law to survive a directed verdict.
Okay, thank you. State, any argument? I know you filed a traverse. Anything further?
We rely on a traverse.
Okay. That motion will be denied. Okay. Let's see. What else do I have over here? All right. Davion Murphy's motion in limine to exclude the office of the state attorney from indicating or intimating that Davion Murphy is affiliated with ATK or 1200 Block or any other gang.
I believe that goes along, Deborah Toomey on behalf of Davion Murphy, that goes along with the discussions and arguments by all counsel thus far.
Okay.
So I would rely on those arguments and
Okay.
the court's previous
All right.
statements regarding this.
So again, the motion will be denied. However, defense reserves the right to make specific objections to specific items of evidence or testimony. All right, but the motion is denied. Okay. All right, let's see. Mr. Chance has a request for judicial notice. And essentially you're asking me to take judicial notice of the fact that Ms. Andrews was convicted of manslaughter on October 31st, 2025. Is that correct?
Yes, and was indicted in the same
Okay.
as well.
Judge, I would like to be heard. Obviously, Judge, you were the judge and presided, and that
Right.
is what happened. But I do have concerns and do want to raise at this time. Obviously, what happened with a co-defendant
Right.
does not get to be mentioned in front of this jury, and I would ask that all the defense attorneys in this case, what specifically was found in her case is not admissible in this case, Judge, and should not have any bearing and should not be referenced as to that jury's actual findings and verdict.
Okay, well, the gist, all that's here is a request for judicial notice, so
Well, Judge, but the state has concern, why is he asking for judicial notice?
I don't know.
Are they trying to argue?
I don't know.
They're in a similar circumstance, in the same car.
But you weren't going to try and get into that in guilt phase, are you, regarding what the verdict was of the Andrews co-defendant?
Well, my motion would be, my request would be for both, but I think specifically, I think it's especially relevant in the penalty phase.
Well, that wasn't the question. I asked you about guilt phase.
Well, my answer would be yes.
Okay, well, I don't think you're going to be able to get into it in guilt phase. Penalty phase may be a different story. We'll see.
Yes, sir.
Okay? So,
And Judge, I'll file a motion limiting. I didn't know what his intent was, but obviously we don't believe that that should be mentioned or referred to in front of the jury for guilt phase.
I agree. Okay, I agree. It's not relevant for guilt phase. It may be for penalty.
Okay.
Okay? So, even though there's not a specific motion pending, I will grant the request. I will take judicial notice if it is a relevant issue for me to take judicial notice of. But just so we understand each other, that's not admissible evidence in the guilt phase of the trial, okay? Penalty phase may be different. So technically, I'm granting the request as that's granted. I mean, as it's proposed. Okay. Mr. Gonzalez, or you want to address the Ghost 187, or you want to do that after lunch?
No, Judge, we can do it.
Okay. And this would be defendant's first motion in limine.
Yes, Judge. This is a motion in limine seeking to prohibit any admission linking the Instagram account Ghost 187 to the defendant. A quick backdrop, Judge. As you know, you've heard some testimony earlier that Ghost 187 was provided initially by Detective Drabeck to Detective Ramos in the very couple of days inception of the investigation, and that's kind of what buttressed the Chevy Silver Cruise and part of the probable cause for the affidavit, search warrant affidavit for the cell phone and for the vehicle. On June 23rd, within that Instagram account, Ghost187__, the account included 3 items: an image of Tom Brady and Bill Belichick celebrating a Super Bowl victory. Number 2, a black screen containing 4 crying, laughing emojis, and a black screen displaying the phrase "Prosper and Junior G-Day today, 187 babies." The defense believes that the state's going to attempt to elicit testimony with the opinion that Ghost 187 is an account owned by Rashad Murphy or operated by Rashad Murphy. And also, unless they tell me otherwise, they're going to seek testimony from detectives interpreting, at least for one thing, the meaning or what Prosper and Junior G-Day today, 187 babies means. Let me just ask real quick, are you guys still going to do that, considering we're not getting into incidents that happened before the 6th? Okay, just want to know. That's fine.
Yes.
I got it. Okay.
Yes, and I assume you're maybe seeking clarification for getting into prior incidents before.
Just clarification for my argument, whether I need to. So essentially, Judge, detectives are going to speculate, and they're going to provide testimony that Prosper refers to Prosper Johnson, a suspected 187 gang member who was killed in 2014, which obviously would be an incident that was originally within the table and the number of incidents that detectives testified in deposition. That was part of my prior motion, and certainly understanding that the court has limited the prior incidents to those that occurred in those 6 circumstances, this not being one of them. Because what the detective is going to testify to is, in his opinion, that Prosper refers to Prosper Johnson, who was killed in 2014, that Junior refers to Gerard Adams, a relative of the defendant who was killed in 2018, and he's further going to opine that G-Day means get back, and that the post reflects retaliation for the deaths of Johnson and Adams, namely as it relates to Charles Jones being killed in reprisal. And so certainly that's of concern to me for a number of reasons. Number one is that, again, they would have to foundationally determine that Mr. Murphy owned or operated that Ghost 187 underscore. And secondly, it dovetails into the type of opinion testimony that doesn't include specialized knowledge. It's simply saying, this is what I believe this says. Again, this is not coded language. This is not language that's being used over and over and over again in some underbelly of communication between gang members. And I would suggest to the court that in a sideline, in an underscored situation, that's improper. Going back to the 187 underscore, Ghost 187 underscore, the account records indicate the subscriber as an Arindam, Arindam, Omerta Nimrod, and then a registered email address, which is ghost187official@gmail. No identifying information, obviously, that would have anything to do with Mr. Murphy. They do attribute Detectives Griffin and Nieder that account to Mr. Murphy, and in asking about that and in getting testimony under oath, I asked Detective Nieder, and he declined to identify the informant that told him that this was an associated account, and when asked to identify anything else linking the defendant to that account, he said that's it on page 32. Detective Griffin, who is a 1200, an individual detective who looks after 1200 on a daily basis, I asked, could he show me a screenshot or a post or a story that you've captured that would show Rashad Murphy in it from that Instagram account? No. Can you and will you testify under oath that you have monitored that Instagram account and you saw Rashad Murphy on it? No. Is it fair to say that your testimony is in that area as it relates to the Instagram account that would be somebody told you that it was his Instagram account? Yes, sir. Harken back also, Judge, to testimony last week from Detective Nieder when I asked him essentially the same series of questions. Have you ever seen him on that account? Well, yeah. When? I don't know. With who? I don't know. Who else was on live during the posting on that account? I don't know. What were they saying? I don't know. Again, back to the overall issue and problem with the majority of the type of testimony I anticipate the jury hearing if the court allows it. Essentially, during the course of that deposition, the state asked some additional questions and said, hey, look, is there any other significance of 187? And Detective Griffin said, yeah, it's the penal code in California for murder, 187. And essentially, he conceded, though, that it's not known in the state of Florida that it has any significance, that it's not based on any kind of popular cultural type of reference, other than the fact that it's noted in a couple of gang-related movies, which is a problem in and of itself. And when I asked him whether or not it had anything to do with anything happening in Tampa, Florida, and certainly even more importantly, anything happening directly with Rashad Murphy, the answer was no. The other reason Detective Griffin gave for associating Mr. Murphy with Ghost 187 __, in addition to what I've just told you, which is, in my estimation, clearly speculative and certainly not admissible, Detective Griffin said, well, you know, he appears in some of these videos, not videos that are related to anyone being killed, okay, but he's in the background, and you know he's not really up front, and he's there and then he's not there, so I attribute that to him being the ghost, and that was his testimony under oath. Detective Nieder similarly testified and I told you this about that he went live on this account at some point in time that he can't give us a date for, nor any other corroborating information for. And that is in his deposition on page 69. He also, Detective Nieder admitted that he had limited familiarity with the defendant. He did not know whether or not there were photographs of the defendant that came on this account. He was not aware if any photographs were posted to this account. He wasn't aware of any connection between the defendant and the subscriber name or the email address. And essentially, I believe that the state cannot link Ghost 187 underscore to Mr. Murphy, nor can they offer any permissible evidentiary foundation for suggesting that Prosper and Junior G Day Today 187 babies has any relevance to Mr. Murphy. And I believe those posts can't be authenticated and they're irrelevant. I would ask the court to prohibit any testimony purporting to link Mr. Murphy to Ghost 187 underscore. Any evidence derived from Ghost 187 underscore Instagram account, and any opinion testimony purporting to interpret that phrase. I have set forth in my motion, Judge, case law, rules of evidence, particular circumstances that I believe support not only testimony linking Mr. Murphy to that account, but also posts that are associated with that account, and essentially would suggest that the state lacks any subscriber records connecting him to the account, any evidence tying him to the registered name or email, any posts or photographs or videos depicting the defendant on that Instagram account, any admissions as to ownership of that account, and any forensic evidence that establishes any control or authority or authorship of that account. I would cite the court to the Tharp case, which is at 777 Southern 2nd 385, a Supreme Court case in 2000, that the state seeks to interpret and establish motive, namely that this charged offense was committed in a reprisal situation, and it's not a conclusion based on the explanation of the language that we're talking about here. It's an inference as to his intent. And in Tharp, the Supreme Court reversed a first-degree murder conviction and a death sentence based in part on the improper admission of a witness's interpretation of defendant's statements. The defendant's cellmate was permitted to testify that when the defendant said he did a hooker, that means he killed it, and killed her. And the court held that this type of testimony was inadmissible because it's grounded solely in inference instead of any specialized knowledge or training. And I would suggest to the court that when you look at that, and even if you take into consideration any specialized training or knowledge, none of that would come into play when it provides the explanation that Detective Nieder did about his interpretation of that statement that was located on that account. And certainly I would suggest to the court that even if you did, certainly my objection as it relates to this motion, Ghost 87, that certainly an interpretation and an opinion statement by Detective Nieder should in and of itself be impermissible. Thank you.
All right, and I want to thank you, Mr. Gonzalez. In your memorandums, you put page numbers on your case law, so it did make it much easier for me to find what you were referring to. Okay, Sismer?
Yes, Your Honor.
So how are you going to prove that Rashad Murphy is somehow related to the account Ghost 187?
So yeah, so we did watch that yesterday. So I apologize for that, but I'm actually kind of glad we rewatched that, because I feel the more I watch this, because I only saw that once before. So the more we watch this, just the more I'm going to become familiar with the pretrial hearings and the motions and what's allowed in, what's not allowed in, and I hope then you guys are also more educated as well. So basically, Holly, they were basically talking about. They talked about a lot, but one of the main things they were talking about was what the state was going to bring in. And we created this timeline. The state's going to bring in only six prior instances, or incidences, I should say. So we expanded the timeline. So the state's going to start at 2019 with Adrian Gainer's shooting, Bibby. You guys may know him as Bibby. But we expanded it to go back to Aiden McClendon. And then it really kind of started at a Kodak Black concert where a couple guys got together. There was supposed to be this handshake. Somebody didn't shake somebody's hand. Somebody got slapped, and then all hell broke loose. Actually, one witness said they started to shoot. Let's see, that was disrespectful, and everyone was fighting like a rumble. An eyewitness says, being kicked out instead of fighting, we were shooting. So this happened back in 2015. So then poor Aiden gets caught. He's 22-month-old little dude, and possibly somebody else was supposed to be in that car, but they shot that car up. And he was cousins to Reginald and Noah Williams. Also known as Wappa with the Chop and Spinabens. So to me, from what I've been able to understand, and you guys correct me if I'm wrong, but I think it all kind of started back then. And then you got Zion Brown, you got the Wasabi restaurant ambush, and of course Corbin Johnson. So the state is not bringing in that at all. They're not going to start there. Where they're going to start here. They're going to start February 25th of 2019. When Adrian Gainer gets gunned down at the Hilltop apartment complex. And he's a close friend of Charles Jones, who goes by Julio Foolio. And then we're not going to hear, the state's not going to bring in Tiki or Lil Nine, but both of them are very closely related to Charles. They appear prominently in the Who I Smoke video, which Yungeen released. And if you guys missed that, we did a whole history of ATK versus KTA last Wednesday, if you guys want to check that out. So the state's going to bring in Bibby from February 25th, 2019. Then they're going to also bring in Spaz, or Gerard Adams. He was shot and killed at a high school football game. That's that Reigns football game. I don't remember who they were playing, but there was a football game going on, and after the game, 3 people were shot, and Spaz was one of them, and he lost his life. Now, they were talking during this pretrial hearing that Robert Howard, who was in the entourage that got shot up in Tampa, that he took the fall. He said that he was involved, but then he proffers that Bibby was actually the shooter. So Bibby's already gone. So they ended up they went with Howard's testimony, and he went to jail for that. Then the next thing that the state is going to be bringing up is all these from 2023. So you got Jaquan Pickens, Jake. Now, is it Jake Jit or is it Jake J Hit? You guys tell me. I like Jake J Hit, but if I'm pronouncing that wrong, let me know. Is it Jake Jit? I've heard Jake Jit, but is it Jake J Hit? So let me know if I'm pronouncing it. Is it Jit or is it J Hit? So anyway, he's 19. He was shot and taken out. He's driving down 95. Car pulls up beside him, gets shot. He goes into a semi. I was really hoping I could find some kind of news clip on this. Can't find any news on it, which is kind of a bummer. I was hoping that I could get something newsworthy for you guys. Shooter was unknown. Then we got Jacoby Beals, or Lil Kobe. He was shot the next day. So he was the cousin of Darius and Maliki Beals, and that was retaliation for Jake's life from the day before. Then we go to Antonio Tilley. So he's October 6th, and then a few hours later, say about, I think Detective Nieder testified 5 to 6 hours later, but essentially put it to the next day. So Antonio Tilley took an Uber to a house, and he got jumped, and he and the Uber driver both got shot. Then we go, then a couple hours later, Charles Jones, Julio Foolio, he was shot multiple times, meaning different times. Once in Houston, a couple times in Jacksonville, and then unfortunately in Tampa was the last time. So this one was in retaliation for Tilley's shooting. So that's what the state's going to be bringing in. That's one of the main things that they were talking about. So Holly, I hope that helps you understand what was going on. We also have we made some charts of who's who, but I'm not going to. I mean, there's so many, right? There's just so many. I'll put those up in a second. Or after we go through here. All right, so now we go to March 31st. All right, so now we go through to March 31st. All right, let's go back here. So this one we did not see. This one, we haven't watched this one yet.
The conspiracy.
Let me just pause this. And rewind a little bit. Although Rashad looks the same. I say it's from a different day, but Rashad just has the same look. He just always has the same look. All right, this is from March 31st. So this is a hearing from March 31st. Let me just get this for you guys. All right, so this is from March 31st, even though Rashad looks the same, has the same expression. Every pretrial hearing we've watched, he has the same expression. All right, kitties are acting. As you guys can tell, we have cats. So if you haven't watched us before, during lunch we show kitty cam while we take breaks for lunch. So if you're new to the trial and you're okay with cats, we're going to show cats during lunch. All right, here we go. This is from March 13th of 2026. Thank you, Hellrider. Appreciate that.
Okay, very good. The defendants are present, defense counsel is present, the state is present, and I need to get my glasses because I can't see until I have my glasses, okay? So I'll be right back. No, they're in the office there, either on the desk or in my purse on the interior pocket. Thanks. I set him down, then I'm like, yeah, I can't see. Okay. So I have reviewed the following motions. Isaiah Chance has a motion in limine, and the state filed a motion to compel disclosure of raw data generated during administration of tests for a number of the defendants. And then Rashad Murphy filed a defendant 6 motion in limine as to Robert Howard. Are there any other motions that we need to hear today, other than those 3?
Judge, I believe Mr. Harmon filed yesterday a motion for order in limine having to do with the verdict of Alicia Andrews. Did you receive that?
I don't believe that I did.
It was filed yesterday.
I thought we discussed that already, but
We did briefly, Judge, and I think that's why Mr. Harmon filed the motion.
okay. Yeah, and I indicated that it was certainly not relevant during guilt phase.
And so this has to do with penalty phase.
Okay, well, I don't know. So, all right, I haven't reviewed it yet, so I'll take a chance and take a look at it. Take a second and look at it after we do these. Okay, y'all care which ones we start with?
Judge, I think Ms. Isburn was hopeful that we could do Mr. Howard's motion in limine last.
Okay, sure. All right, so why don't we start with the state's motion to compel disclosure of raw data generated during administration of tests. And I have a motion filed as to Rashad Murphy, Davion Murphy, and Isaiah Chance.
Very, very quickly, just for the record, Christopher Delauder is going to be sitting in. He is a certified second phase attorney. He wants to get some experience on first phase, so he will be sitting in with myself.
For the remainder of the trial, or just today?
That's correct. As much as he can. I don't know if
Sure.
I
That's
just want
fine.
the court to be aware of that.
Yes, thank you. Good morning. Okay, so those are the three defendants. Did Mr. Gathright, do you have one as to Mr. Gathright or no?
No, Judge, it's my understanding from Mr. Harmon, these were the only three defendants that had mental health experts in this area.
Okay, so Mr. Gonzalez, as to Rashad Murphy, do you object?
Judge, I think that would be a...
Oh, I'm sorry, Mr. Hernandez, do you object?
What motion is this?
It's the state's motion to compel disclosure of raw data generated during administration of
No,
tests.
Your Honor. Obviously, that is done directly from one doctor to the other. We don't get involved in it, but I can contact my doctor and it gets sent directly to the state's doctor.
Okay, and obviously, and I don't know, only you know in the raw data, your expert may know, if there's anything in there where the defendant spoke about the facts of the case or defense strategy, then obviously that data does not have to be disclosed to the state.
I would have to check with the doctor, but based on the deposition that was taken last week, I think that that's not going to be an issue because in response to one of the questions, my doctor indicated that the defendant had not discussed whether any issues regarding guilt or innocence. So I don't think that's an issue, but I would have to double check with the doctor.
Okay, well, just make sure that they know before the data is conveyed to the state that if there is anything in there that that can be redacted or withheld, but you just need to, essentially, what I would need the doctor or you to do is to make some type of privilege log, just so it's reflected that this is what we held back and this is why. And then if there is a finding of guilt as to first-degree murder, and if we're going into a penalty phase, then potentially that material would have to be disclosed, but we can discuss that if we get there.
If once the state can provide me an email for the doctor, I will reach out to my doctor to have it sent with the court's instructions.
Okay?
That's fine, Judge.
Okay, very good. All right, so as to Mr. Sonardi, as to Davion Murphy, do you object to the motion?
Yes.
Or, go ahead.
Yes, correct. To the state's motion you're referencing?
Yes.
Yes,
Okay, just, you don't think any raw data should be, at this point, disclosed?
correct,
Based upon what?
correct.
No, what is your argument? What's it based upon?
Just adopt the other co-defendant's arguments as to that.
Okay. Okay, so I'm going to grant the motion with the same exceptions. Mr. Sonardi, you just need to confirm with your expert that they are to supply the raw data you get the information regarding the state's expert. However, if during the interview of Mr. Davion Murphy, if he made any statements regarding the facts of this case or any defense strategy, then those statements or that data does not have to be transmitted, but you do have to create a privilege log if you're holding it back. Okay? All right, and finally, as to Mr. Isaiah Chance, Mr. Petratus.
Good morning, Your Honor. We would object. I spoke with our doctor, and her concern was that the state's doctor is a psychiatrist, not a psychologist, would not have been trained in the test that she administered, specifically to Mr. Chance. So based on that,
Okay, well, it sounds like a jury issue, potentially, cross-examination or direct examination issue. So I'm going to grant the motion. Again, Mr. Petratus, the same thing. If there is anything contained in the raw data regarding defendant's statements as to the facts of this case or as to any defense strategy, that does not need to be conveyed to the state's expert, but you would need to create a privilege log. Okay? All right. Very good. All right. So Mr. Chance's motion in limine. And state, do you object to this motion?
Yes, Your Honor. The state this morning filed a response with its motion limited. It was filed yesterday, provided courtesy copies via email to the court, and provided physical copies to the defense attorneys as well as a courtesy email this morning. We included the argument from Mr. Petratus as well as the argument on behalf of Davion Murphy for the YouTube videos that were listed. Mr. Petratus filed...
Well, this is all I've got. This is all I've got. Mr. Chance filed a motion in limine and wishes to have excluded any allegation, mention, inference, or indication, whether through witness testimony, picture, video, or attorney statements to the jury of music video or stills from the video, quote, "Blood on My Pradas," close quote, by Isaiah Chance. Said video has no direct connection to the murder of Charles Jones and has imagery, firearms, dead body, etc., that would be unduly prejudicial without any probative values. That's what I'm referring to.
Yes, Your Honor.
Okay, so you're objecting to that?
Yes, Your Honor.
And what's the basis of the objection?
The evidence, there is items or are items of evidentiary value contained within that YouTube video presented at the state's evidence view. The state did decide to utilize screenshots in lieu of the video itself. Those screenshots depict the defendant only, not the dead bodies in his videos, and all of the violence from the videos. We actually limited the exhibit itself to several screenshots, many of which prove up elements that are required for the gang enhancement.
Okay. And what's your response to that, Mr. Petratus?
Judge, not withdrawing my previous objection to the gang.
Right.
But if it's just photos of him with the, I assume, the 23 chain, stuff like that.
Do you have the still shots here?
Yes, I presented the still shots we'd use at trial at the evidence view to defense.
Okay.
I have them electronically as well on my computer, Your Honor. I can pull them up if necessary.
I have the 3 photos, I believe. 2 of them just Mr. Chance with a 23 chain. There's no other imagery that we would object to. The other issue is, though, the name of the video is one of the pictures, and I would object to the name of the video we did.
Okay. What's your response to that?
The state, in admitting the evidence, is proving the authentication of the video and the source from which the video derives. So, identification of the defendant, number one, given that the subscriber information records linked to this defendant, the title that's used or the name that is used by the defendant is not his legal name. So it's more than just authenticating the video, but also identifying the defendant for purposes of this exhibit.
Okay, for record purposes, we probably need to identify exactly what it is we're talking about. Can you either display it so I can see it and Mr. Petratus can see it, or you can...
Yes, Your Honor.
Also, while you're doing that, we had a superseding indictment, correct?
Judge, that is correct. The only thing that has changed is count 2, which is the conspiracy count. We expanded the time frame of the conspiracy back to June 6th of 2024. That's the only change to the indictment.
Okay. Mr. Gonzalez, on behalf of Rashad Murphy, how does your client plead?
We would plead not guilty, Your Honor.
Okay. Mr. Sonardi, on behalf of Davion Murphy, how does your client plead?
Not guilty.
All right. Mr. Wise, on behalf of Mr. Gathright, how does your client plead?
Not guilty.
All right. And finally, Mr. Petratus, on behalf of Mr. Chance, how does your client plead?
Not guilty.
Okay. Very good. Thank you. All right, and while we're waiting on Ms. Ismer, let's just talk a little bit about jury selection, okay? So, while I spoke with jury services, and they're summoning enough people, they hope, to at least get 150 in here, okay, 150 people. Actually, let me back up. We're not doing jury selection in this courtroom, okay? So we're doing it in courtroom 1. So we have, just because I'm going to need to be able to utilize the lobby outside to seat people, and there's no lobby outside of this courtroom that would be large enough to accommodate 150 people. So we're going to do all of the jury selection in courtroom 1. We're going to try the case in here, all right? So I know we can get 150 in the audience on the benches. My bailiffs also determined that we could get an additional 25 in the jury box with some chairs in front. So conceivably, if 175 people show up, we can get 175 in courtroom 1. My inclination is if we have the space and we have the people, we should just bring them in. So that's my initial thought on that, is that it actually would be 175 people, assuming we get 175, Wednesday, Thursday, Friday. So then my question to you all is, as far as numbering them, my inclination is to do 1 through 150, like normal, like what I normally do in the audience, in the benches. And then do 151 through 175 would be on the side where the jury box is. And remind me, Ron, Reggie, how many chairs do we have to put in the front?
In the jury box?
Yeah, outside the jury box.
7, 6, 6, 6.
Okay, so what I will do is I will have my JA come up with just a general seating chart, so you know the numbers of where the people are going to be, all right? And then, starting the next day, then we would start with 176, put 150 out there, and then if we get the extra 25, again, put them on the side, and the same thing with Friday. All right, so I will do seating charts for you all with that anticipation, and you can at least use that. Okay.
Penalty involved in the length of the trial, I suspect a lot of individual work on it. How do you plan to do
So
that?
this is what we do. With regards to this first round, and I think we discussed this before, but you may not have been here with Mr. Hernandez. So how this is going to work is phase 1 is going to be questioning with the jurors about hardship and whether or not they can serve, and then pretrial publicity. So what I'll do is, when we get the list of...
Sounds like somebody's scratching some records in the back there. I don't know what the heck that was, you guys. I'm trying to give you a heads up when that comes through, but wow. I have no idea what that is. That's definitely on their end. So anyway, I try to give you an audio alert when that happens. Yeesh.
175 names. All you all are to do is simply write down the name and the number. That's it. Don't start looking at slips. We're just get down the name and the number. I will give my introductory speech that I do in all death penalty cases. Plus, I normally don't instruct them on the death penalty at this phase. However, in this case, I am going to give a preliminary instruction because, unlike my normal practice, I am going to break down the people that can serve into smaller groups for death penalty voir dire. And the initial instruction on those jurors normally takes a while because I know I have a long speech I have to give. The state normally gives a relatively long speech, and then the defendants can give whatever speech they would like to. And I don't want to have to repeat that every morning during voir dire of the penalty phase, which would be phase 2, because it just sucks up time. So I'm going to give my preliminary instruction on the death penalty. I will then allow the state to give a preliminary instruction. You all can give a preliminary statement if you wish. And then what I will do is I will then ask the jurors 2 separate questions. I'm going to ask them first to raise their hand if they're going to claim a hardship for while they cannot serve. And then I'm going to read a statement, and I need to get an agreed-to factual basis from you all to read to the jury and ask them if they think they know anything about this case. I will probably, so for those individuals that raise their hand as to knowledge about the case, pretrial publicity, I will do individual voir dire, and we'll do that first. We'll bring them in one at a time. For those that are claiming a hardship without pretrial publicity, I will do those in groups. So I'll bring them in, probably have enough to seat in the first row of the audience, and then I will ask them the initial question as far as what their purported hardship is, and then I will allow each of you, if you wish, to do any follow-up questions. And then once all of those individuals have been questioned, then we will determine who can be excused. And at the outset, just so you know, I will excuse people for cause at mostly at lunchtime and at the end of the day, but only if everyone agrees. So if anyone objects, either the state or any of the defendants, to any of the prospective jurors being excused for cause at that juncture, I'm going to leave the person in the pool. So, because you may want to rehabilitate them, I don't know, okay? So the individuals who do not raise their hand at all, who don't know anything about the case, and who are not claiming a hardship, they will be excused until Monday. And then they will come back to begin the first smaller group for death penalty questioning, which is phase 2. So my goal is to hopefully have smaller panels of 30 to 40 people just for death penalty voir dire the following week, which would be Monday through Friday. And then once that is finished, then the following week, Monday and Tuesday, will be general voir dire for those that remain. All right?
So that's where we are right now. So that statement right there where she said Monday and Tuesday the following week, that's where we are right now. So first of all, they have to ask them, are you okay with the DP? And it goes from 0 to 10. 0 being no way, I would never ever vote DP ever, to 10 being yep, they deleted somebody, DP for them. So first they have to get through that. Then they have to whittle it down, asking specific questions on the case, and then whittle it down. So that's where we are right now, the Monday and Tuesday. Today is Tuesday, so that's where we are right now. So I'm going to go ahead. I'm just going to rewind that just a bit so we can hear that again. But this is literally where we are right now.
I am not opposed. And at the outset, just so you know, I will excuse people for cause at mostly at lunchtime and at the end of the day, but only if everyone agrees. So if anyone objects, either the state or any of the defendants, to any of the prospective jurors being excused for cause at that juncture, I'm going to leave the person in the pool. So, because you may want to rehabilitate them, I don't know, okay? So the individuals who do not raise their hand at all, who don't know anything about the case, and who are not claiming a hardship, they will be excused until Monday. And then they will come back to begin the first smaller group for death penalty questioning, which is phase 2. So my goal is to hopefully have smaller panels of 30 to 40 people just for death penalty voir dire the following week, which would be Monday through Friday. And then once that is finished, then the following week, Monday and Tuesday, will be general voir dire for those that remain. All right? So I am well aware of the number of peremptories, 40 total for defense, 40 for the state. So I'm hopeful that we will have, at least 150 come back for the final phase. We'll see. So this is just going to be a situation where as we go along, we will see how things are going. All right? So then if I get, let's say, more than 30 people who can come back the week 2, I'll push some to Tuesday. And then same thing, Thursday people will come back either Tuesday, Wednesday. Friday people that come back will come back Thursday or Friday. I won't know until I know what the numbers are. exactly what day they're going to come back. But just so you all know, it will be smaller panels, week 2, 30 to 40, just on death penalty. Okay? So, Mr. Hernandez, is that a long-winded way of answering your question? Okay.
Judge, one question I have.
Sure.
The statement that the court's going to allow defense and state to make after your initial inquiries, what is the court anticipating with regard to that statement?
I'm assuming it's just pretty generic, just enough to trigger their memories. We had a statement in the Alicia Andrews case that you all may or may not agree to, but it's kind of just basic parameters, things like that this was a shooting that occurred up near USF on the date in question, and that it involved an allegation of potential gang involvement, and the victim was Charles Jones, known by his rapper name Julio Foolio, something like that.
And that's, though, a statement that's going to be given by the court.
Correct.
What about the statement that you're referring to that you would allow both the state and the defendant?
That is the statement. No. The statement
You're talking about something that we are allowed to get up and do with that.
Yeah, no. No. There's two separate, I guess, statements. So the first one is the one I would make in anticipation of my question about pretrial publicity. Okay. The next would be with regards to the death penalty information. And again, just from experience, Mr. Harmon has a script that he uses, and I don't believe in any of the cases I've done defense actually said anything in addition, really. So you don't have to. I'm just letting you know that if you would like to stand up and just give because I'm allowing the state the chance to do it, to give a general instruction or information about death penalty qualification.
Fine, Judge. I need some clarity on that.
Yeah, it's just, I don't think any defense attorney has ever done it, and you don't have to. I'm just giving you the opportunity if you so wish.
Understood.
Okay, but normally between myself and Mr. Harmon, we cover pretty much everything. So, okay. And I'm also considering, and you guys tell me if you think it's a good idea or a bad idea. Once we get our jury picked, so this would not include next week, I'm considering giving the jury Fridays off. Mr. Sonardi gave me the thumbs up. What do you guys? I'm hoping that will be some sweetener to encourage people to want to volunteer to serve, since they know they at least will get Fridays off to handle their personal affairs or do what they need to do, but you all tell me.
Certainly always a good situation with regard to getting people to want to serve, and certainly allowing lawyers to do what they do. I don't know if the state has any indication. We haven't gotten a final witness list yet, which of course no one's obligated to do.
Right.
But to the extent, would the state have any indication as to what they think their case in chief, short of a catastrophe, might take? I'm just more looking about, quite frankly, Judge, my calendar beyond the 15th. And there are some challenges there, and I need to know whether the state has any idea as to what they might.
So let me ask you this. So let's just talk about this a little bit. So hopefully, if everything goes smoothly, jury selection will be concluded by Tuesday, April 21st. Okay, that's my goal. I will be working very hard towards that goal. That means we do opening statements on the.
So April 21st, obviously that's today, and she is doing her best to make sure that they have opening statements tomorrow.
22nd, okay, that's my goal. I will be working very hard towards that goal. That means we do opening statements on the 22nd and begin with the presentation of the evidence, the 22nd and the 23rd. I can tell you right now, we will not have court on the 24th of April. So then the guilt phase portion would begin again April 27th. And we'd go through that week. And then depending upon things, and depending upon if there's a finding of guilt as to first-degree murder, penalty phase would begin May 4th or thereabouts, and last most of that week.
Does that comport potentially with what the state would anticipate from a case in chief standpoint? And again, I'm asking a question that they may not have the answer to, Judge. I'm just inquiring.
I think that in general terms it does. I know that this trial will be somewhat longer because there's more attorneys, but
Sure.
I think that that's a good general guideline.
So I'm trying to remember how many days did it take us in the Andrews case? 7? Well, remember we picked a jury though.
Correct.
Starting, I can't remember, did we start Wednesday or Monday? I think it was Monday. Did we start Monday?
Judge, I don't remember.
Yeah, I don't
I'll have to go back and
know
look.
either. Let me look. I don't know. What month even was that? Who could even?
It came in on October, on Halloween.
Okay, let me look.
5 years ago now?
Yeah, it feels like it. Yes, it was. Yes, it was. Okay, well, I don't have that with me. So anyway,
That gives me a much better indication, Judge, without nailing anybody down, that actually answers my inquiry, truthfully.
Yeah, it took us a couple days to pick the jury in that case. It took, 2 to 3 days to get the jury picked. So it took us, I'm going to say, about 7 work days to get it tried. So maybe 8 or 9, just because we have more lawyers. But I would say 8 or 9 for guilt phase portion of the trial.
And there may be a few more witnesses in this case.
Okay. Okay.
And probably a little more extensive testimony from those witnesses, because I think there were some limitations
Sure.
in the Andrews case that probably don't exist here.
Sure. Okay. So, yes.
I guess along those lines, I think it's safe to say that I should, if there is a need for a penalty phase, I shouldn't have any witnesses ready in April. It should be May.
Yeah, it'd be May. I would say May 4th at the earliest. May 4th at the earliest. And I'm going to ask Mr. Hernandez, what's your absolute need to be done by date? Mr. Gonzalez, what's your absolute, and Mr. Hernandez, what's your absolute need to be done by date?
Judge, preferably the 18th or 19th of May. I don't know whether any of those days fall on the weekend, but...
Yeah, we'll be done by then. Okay? Mr. Sonardi, what about you? Any?
Fine.
Okay. Mr. Wise?
Your Honor, my only, sounds like I'm on the same boat as Mr. Gonzalez. I had everything blocked off through May 15th, so starting May 18th, I had
Yeah, we'll be done by then.
So.
We'll be done by May 15th.
Okay.
Okay, we will. And Ms. Petratus? Okay, yeah, we will. So, okay. Very good. So now that we've discussed the calendar, so at this point, I won't commit to the jury taking Fridays off. I will tell them Friday, April 24th for sure. And that if we're making good progress and it looks like I can give them a Friday off, then I will. But at this point, I'm going to be conservative because it's more important that the trial gets completed in a timely fashion. So, okay. Okay, Ms. Ismer. Yep.
So yeah, the seat of charge, can you pass this out to these guys? That's what it looks like. And Connie made that
Yeah.
sheet in the back. Do you want me to just make a copy and give it to
That'd be
them?
great.
Okay, Josh.
Excellent. Okay, so this would be, the state is displaying, this is a still shot, blood on my Pradas, and that is Goudaze, which I believe is a name that Mr. Chance goes by, correct?
Yes, Your Honor.
Okay, and when was this distributed, or?
I'd have to look back at the original motion for the date.
Okay, or posted? September 2023?
I
Okay,
think the 8th of 2023.
okay. So this is the one you object to,
This specific picture, Judge.
this specific
And
picture?
I'll say, we're not going to be objecting to Detective Meter or someone who knows him saying that that is Mr. Chance, and we're not going to be objecting that is the name, the top Kaze that he uses. But I don't, and we're not going to be objecting to this, but based on your ruling, the other two pictures, which is him wearing a 23 chain,
Okay.
shown in this picture. So I'm not going to object to this and then try to jam up the state later, but it's this specific picture. I don't think it's necessary to show blood on my product.
Well, yeah, so what if they just redacted blood on my Pradas?
Well, I would say that what he's doing in that picture could be interpreted negatively, whereas they're just trying to show him wearing the 23 chain in a music video. I don't want to say stipulate, but I'm not going to object to suggesting this was a video he made on September 8, 2023. That is Mr. Chance, and he's wearing, it can be very obvious in the other two pictures, a chain, number 23 on it.
Yeah, well, it looks like, just for the record, it looks like he's maybe mimicking shooting a gun or shotgun or something. It's what he appears to be doing. So why do you need the title "Blood on My Pradas"?
All of the other exhibits from YouTube include the title and the account name for the individual who posted them. So to redact only this screenshot or only this defendant's music video, which indicates obviously still images for at least this exhibit of the defendant wearing his gang chains or talking about offenses or crimes that are linked back to the gang that he's affiliated with, I think it causes a discrepancy in what evidence is being presented. The defendant would, in this instance, be the only person whose music video title isn't also displayed alongside of all of the other videos which are establishing his gang enhancement.
All right, let me see the other still shots, just to make sure, for the record.
This is still shot 1 and still shot number 2. Both have been redacted to remove the guns or body parts that were depicted.
Okay. And this is going towards the gang enhancement, correct?
That's correct, Your Honor.
Okay.
We'll see testimony as to the lyrics because in playing the video, obviously, we knew the defense would have an objection to all of the content, which is why we redacted to these specific images.
Okay, very good. All right. So based upon the state stipulation to limit this exhibit to the 3 screenshots, I'm going to overrule or deny the motion in limine, followed by Isaiah Chance. I find that the evidence the state seeks to admit that its probative value outweighs any prejudicial effect. Okay, and next would be the motions I have a copy of. Defendant Rashad Murphy's motion limine is to Robert Howard.
Judge, this is an all-encompassing motion, as the board can see, regarding several different areas. And it is buttressed on the statement provided and ultimately made confidential, made by Mr. Howard in August of 2025, as well as his deposition taken on February 4th, 2026. It seeks to limit, based on what I believe is hearsay, improper speculation by Mr. Howard, and pre-conspiratorial statements that are attributed to other defendants. Certainly understanding the court's ruling with regard to severance, I still have concerns about evidence that may in fact be admissible against one defendant and not admissible against others. As it relates to the hearsay statements, Your Honor, any statements that Mr. Howard alleges Mr. Murphy made
as it relates to threats to him or his family are statements that he heard from other individuals. And that's based on his testimony at both his statement and his deposition. He talks about things allegedly stated by Mr. Murphy that were told to him by others, and goes on to suggest that in his alleged conversations with Mr. Murphy on multiple occasions, he didn't consider those conversations either threatening nor friendly. So certainly buttressing that feeling and that speculation and that statement being what he's been told by others.
Okay, so maybe it'd be helpful if we just went through these statements. You've broken out the different statements per category, right?
Yes, Judge.
So let's just start with the hearsay statements, beginning at page 2 of your motion. Specifically, you allege that Mr. Howard testified that he heard from other individuals that Murphy had made threats.
That's correct.
Okay. State, were you intending to elicit that from Mr. Howard?
Is this as to paragraph number 5, Your Honor?
It is.
No objection as to statements he heard from other individuals, only statements that Mr. Howard heard directly from Rashad Murphy would be suffered.
Okay, so as to paragraph 5, it's granted. And then paragraph 6, Mr. Howard further clarified that he spoke with Rashad Murphy on multiple occasions. Oh, so that's
just
different.
providing context.
Okay. And then the next would be paragraph 7. Mr. Howard testified, subparagraph A, that he communicated with Isaiah Chance, who told him that Murphy was hot about Adam's murder. State, are you seeking to elicit this from Mr. Howard?
Yes, Your Honor. Any statements that were made by any unaffiliated party with the case, the victim, as listed in this motion, the state's not seeking to introduce. But statements made by the defendant or co-defendants in this case, the state is seeking to introduce. Not as statements of hearsay, they're not being offered for their truth, but to establish intent and premeditation and motive in this case.
Okay.
Judge, it also goes to admissibility statements as it relates to Mr. Murphy, and the argument would be it's not a co-conspirator statement based on when it is said, and in fact, I think the state would have to establish when that statement was made to determine whether or not it was in the course or in furtherance of any conspiracy, and I don't think they can do that.
So state what your argument is as far as why this is admissible if the statement was made not during the timeframes of the purported conspiracy.
Because Mr. Gonzalez's argument reverts back to a co-conspirator admission, which is a hearsay exception. The state's position is that it's not being offered as hearsay. So understanding the limitations of a co-conspirator hearsay statement, we're not offering it as a statement of hearsay in the case. It is strictly being offered as proof of other elements, so knowledge, intent, premeditation. The state has filed in its initial response to the court and had previously provided to the court the case law on this before Mr. Gonzalez's motion. So the March 5th response gave the case law for all of the reasons that the state sought to introduce each of these statements, Your Honor, and we would rely on that case law.
Okay, I'll come back.
Mr. Howard can't testify to what Mr. Chance told him about Mr. Murphy, and I don't think it's admissible based on any theory of motive.
Isn't it double hearsay?
The statements that Mr. Murphy was hot are statements that are made from Mr. Chance to Robert Howard telephonically. Is that what are these the ones you're referring to, Mr. Gonzalez?
Yes.
Okay. And so the state's not off, again, the state would just reserve the same exact basis as for why the evidence is being offered. It's not being offered for its truth. So continuing to indicate that because it's an out-of-court statement, it invokes co-conspirator hearsay when the basis for why the state is offering the item of evidence is strictly the defendant's knowledge of what was to occur, the premeditation of the act of what is to occur, because the context of that conversation is in telling the person listening, which is the witness, Mr. Howard, to be careful, essentially, when he goes to Tampa. These things are, in context, being offered for a different purpose than a hearsay or co-conspirator statement or admission.
Let me think about it. Okay, the next one, subparagraph B of 7, Howard testified that Charles Jones told him to watch out for Murphy because of Murphy's purported threats.
No objection to the statement.
Okay, that one's granted. Subsection C of paragraph 7, Howard testified that he heard rumors that Murphy was riding past the prison that Howard was at.
No objection to the statement.
Okay, granted as to 7C. Okay. So I think that takes care of all of the statements identified in your subsection under hearsay. Is that correct?
That's correct.
Okay, moving on to opinions, speculation, beginning at page 3, paragraph 13. Howard testified about a Bill Belichick and Tom Brady social media post, which he attributed to Isaiah Chance following the murder. Howard speculated that the post referred to Charles Jones because Brady is the GOAT of football and Charles Jones is the GOAT of rap music. State.
The witness's impression or his specific observations, I don't expect he'll be testifying about what Isaiah Chance meant, but only about what he understood the post to be.
Judge, I think that's inadmissible. It's asking Mr. Howard to speculate, give his opinion as to what he thinks something might mean.
Well, what was the
Not an
actual?
expert.
Yeah, what was the actual? What was it that was posted, and what was the content of the post?
A photograph, so it was not a part of our hearsay argument that we previously provided to the court of Bill Belichick, a coach of the New England Patriots team. There were consistent photographs of either Tom Brady or Bill Belichick posted by the defendants. Or
So Isaiah Chance posts photos of Bill Belichick and Tom Brady.
Yes.
Is there any words attached to the post, or just the post?
No words on the Bill Belichick photo. I think hands up. I'm not sure how to describe the emoji, but an emoji on the photograph, but not words associated to that post. There were other Bill Belichick posts in the co-defendant's devices, so I'd have to pull them up to check for language. But to my knowledge, having discussed that with the defense attorneys, I didn't believe there was any other language that was on those photos.
And this was post-murder of Charles Jones?
Correct. These were posted, some within minutes and some within the first couple of hours after the homicide.
Just for context too, Judge, some people may think Tom Brady is the GOAT of football. That's your opinion. Some people may think that Charles Jones is the GOAT of rappers, and that's somebody's opinion. And I think that that needs to be considered in its totality along with the other arguments.
Yeah, I'm just trying to figure. And so what's it relevant to?
I believe, if I recall correctly, the specific testimony that was provided by that witness in trial 1 was that while he was on scene of the homicide, within minutes, he logged onto social media, saw that post, and immediately knew that the poster had done it. Like that was the testimony that was provided. There was nothing specific as to the defendant's state of mind or what the intention behind posting the photo was. It was whatever the witness had observed on scene in that moment as he was checking social media and before they were able to notify the family or the media having arrived. That was the testimony that was received, and that's what we anticipate will be the same in this trial.
Okay. So within, how quickly did the post happen after the homicide occurred?
I have to check my timeline, Judge, because there are several across all of the devices that we have received. 6:13 a.m.
So is that the morning of the homicide?
Yes, Your Honor.
Before?
No, this is just after the homicide. So the homicide occurs about 5 a.m.
On June 23rd, so this is right after?
This was the...
Okay. 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 So I'm going to deny the motion in limine as to the social media post. However, grant it as to any speculation on the part of Mr. Howard as to what Mr. Chance meant.
Judge, although I can't be positive, I looked at Mr. Petraeus' screenshot, and it looks like the post was made on 6:13 a.m., and I think the murder occurred at 4:37 or 4:38, so it's a couple of hours,
Yeah.
an hour and a half, 2 hours, somewhere in that neighborhood.
Right. So I've denied paragraph 13 as to the post itself, but granted it as to any interpretation by Mr. Howard as to what Mr. Chance meant by it. Okay, next up, paragraph 14. Mr. Howard testified that Rashad Murphy texted him after the murder stating, "I forgive you."
And Judge, what we're talking about is not a text that the jury would be viewing. It would be Mr. Howard's testimony that Mr. Murphy texted him and said, "I forgive you," and then speculating that that is a result of Mr. Howard having been convicted of the murder of Joe Rod Adams in 2018.
Okay, State, are you going to seek to admit this?
We are seeking to admit it, Your Honor, for the same basis, the motive and intent behind the defendant having committed this crime. The testimony from Mr. Howard is that that message comes in within either the same day or the next day. I believe this is testimony at depo and trial that he receives from the defendant.
He doesn't know when he got it, really, at the end of the day. Although he does limit it to within a day or so.
Okay, I'm going to deny as to paragraph 14, but granted as to any speculation on the part of Mr. Howard. Okay, paragraph 15, Mr. Howard further testified that, is that Rashad Murphy?
Yes.
Okay, spoke with him after the murder and that the two discussed their respective whereabouts. Mr. Howard testified that Rashad Murphy stated he was in front of Julio's car. Okay?
Yes, Judge. Mr. Howard speculated that what Mr. Murphy meant is that he was present at the shooting. But actually, Howard admitted that Murphy never stated he was present at the scene, nor that he participated in the murder, but the context of what he was alleged to have said was he was in front of Julio's car. He previously testified during his statement that in talking about the same discussion that Mr. Murphy alleged he was present at the Truth nightclub, not at the scene of the murder. And so, obviously, the inconsistencies are something that can be
Sussed out in cross-examination, yes.
But as it relates to him testifying that Mr. Murphy was in front of Julio's car and then testifying that what Mr. Murphy meant was that he was at the murder should be limiting.
My only concern with this one is it gets a little bit convoluted. It is a part of the conversation that Mr. Howard is indicating that he's having with the defendant, whereas the defendant is completely describing the scene. You had your head on a swivel. You were looking here and there at each of the locations. And so certainly the state is seeking to admit it as identification, but I think this one, if the court is inclined as it relates to the speculation, may be one that we ask if the court would allow that we wait until we get to that point in the presentation of the evidence. I don't know how we can splice that up, if that makes sense, based on the context. of the full statement that he gave for that.
I just don't want during the course of direct testimony for Mr. Howard
To draw an opinion.
to speculate that what Mr. Murphy's talking about is he was in front of the car during the course of that murder.
Okay. So, again, I'll deny paragraph 14. It's admissible. But, again, Mr. Howard cannot draw opinions. He can only testify as to what was said. And then that's why we have closing arguments, and you guys can argue the meaning.
Did you say 14, you mean 15?
I'm at 15, yeah. All right, paragraph 16, Howard also testified that Rashad Murphy later told him, "It is all good, we good now." State, are you intending to introduce that statement into evidence?
Yes, Your Honor, but no objection as to limiting without speculation on the part of the witness.
Okay, very good. Then the paragraph 16 will be denied, but again, no speculation or opinion as to what Mr. Rashad Murphy meant. Okay, paragraph 17, Howard opined that social media posts referencing Don Julio were intended to disrespect toward Jones because Julio appears in Jones' Instagram handle. State, were you intending to solicit that opinion from Mr. Howard?
Not as it relates to disrespect, as it relates to Don Julio or Julio. If he has specific knowledge in this case about the fact that Julio and Don Julio are linked because of his relationship to the case, I would ask that that be admissible.
And Judge, I guess, just for clarification, Mr. Howard's not going to be testifying to his opinion that it was done in a manner of disrespect.
Right, he's just going to say that
I saw bottles of Don Julio.
And to me, and based upon my knowledge and experience or whatever it may be, that is a reference to Charles Jones, right?
Understood.
Okay, so it's denied with that understanding. Again, as to paragraph 17, Mr. Howard can testify as to the facts or what he knows, but he can't speculate on the intention of the poster. Okay.
It's the end, Judge, of those that.
Okay.
category.
Moving on to co-defendant statements.
And again, I'm going to preface before the court goes any further. Again, understanding the court has ruled
Right.
as it relates to severance. I just want the record to be very clear.
Yes, you're not.
Have concerns.
Yeah, you're not waiving any objections that you've previously made. Okay, let's see. Paragraph 25, Robert Howard stated that he had multiple conversations with Isaiah Chance in which Chance expressed his dislike for Charles Jones. He emphasized that Chance and Jones engaged in multiple social media arguments in which they disrespected one another. Are you going to be attempting to admit this evidence via Mr. Howard?
Yes, Your Honor. All of it will come in through the experts, except for one interaction which occurred between Chance and Charles Jones that Mr. Howard was the primary witness to. Otherwise, law enforcement witnessed the exchanges.
And certainly my argument has to be, notwithstanding other motions and other rulings, is that Mr. Howard not testify to that if it's coming in through a gang expert.
Right.
And as it relates to his direct interaction in seeing something occur, then of course I don't have a legal objection to that.
Okay, so it's a paragraph 25. It's sort of a general argument. I'm going to deny the motion in limine as to paragraph 25. However, you reserve the right to make contemporaneous objections at the time of trial. So if something's coming in through the gang expert, then at that time, if you want to raise an objection, you can, but generally speaking, it's denied. Okay, and then there's a more specific statement at paragraph 26. According to Robert Howard, Isaiah Chance allegedly stated that Charles Jones was going to die. Do you seek to admit this through Mr. Howard?
We seek to admit the conversations that occurred within the time frame of the conspiracy that's listed as it relates to these conversations, but not from before that. The motion, though, is not clear because there were conversations which occurred outside of that time frame discussing the same type of comments or threatening remarks. Mr. Howard and Mr. Chance had some type of relationship which was jovial enough for them to speak often about this issue, but there are specific exchanges which occur which indicates that there are threats on the victim's life and for Mr. Howard to kind of avoid that danger when they come to Tampa. We know that's within the time frame, regardless of whatever testimony Mr. Howard was able to give in his deposition about the specific dates, because they reference the posts that Mr. Jones made to social media of the flyers for the events that were occurring in Tampa, and that occurred on June 14th of 2024.
Judge, I would only point out that certainly we have to rely on Mr. Howard's testimony as to when he heard these things. We have no other way.
I know.
To do so. And to the extent that he testifies under oath that he believed that it occurred at the end of 2023 or beginning of 2024, it would have been long before any conspiratorial time frame. And again, as it relates to Mr. Chance, that argument can be had in another way. So generally, it occurring within late 2023 or early 2024 is a problem. And again, I would reiterate, as it relates to evidence that a jury's going to hear that they can consider against Mr. Murphy, it's a problem.
Okay. So there's two separate things going on here. So let's first discuss, if I'm hearing you correctly state, you're only intending to seek these conversations between Mr. Chance and Mr. Howard during the time frame of the conspiracy, correct?
Correct. The content of the conversations during that time frame.
Okay.
Otherwise, it is just generally the relationship between the two. Did you speak on the phone previously?
Right.
What was your relationship, but not the content?
Not the, okay, so with that understanding, that's what the state is saying. So it would appear then as to paragraph 26 and 27, because Mr. Gonzalez is alleging that Mr. Howard stated that this specific comment that Charles Jones was going to die occurred sometime at the end of 2023 or the beginning of 2024, which would be outside of your conspiracy timeframes, correct?
Agreed, Your Honor.
Okay, so as to specifically paragraph 26, that will be granted. Paragraph 28, Howard further testified that the ongoing dispute between Charles Jones and Isaiah Chance had escalated to the point that if they would have seen each other, they probably would have wanted to do something to each other. That appears to be Mr. Howard speculating. Are you going to seek to introduce that?
No, Your Honor.
Okay, so granted as to paragraph 28 is that statement. Yep. Well, 27 is not, it's just a historical fact. Okay.
The finding, though, Your Honor, if I may, as to 27 and 28, they really should be together because the other remarks about Mr. Jones dying do occur within our conspiracy time frame, so I don't want the record to be unclear. There are several remarks made within our conspiracy.
Right. So, okay. So as to 27, it's granted as to anything outside of the time frames of the conspiracy, denied as to any statements made during the time frame of the conspiracy.
And certainly, Judge, subject to later potential objections, I would certainly having no reason to dispute what Ms. Isber saying. The state's going to have to, in order to admit those statements, lay a foundation as to when they occurred and whether they occurred within the conspiratorial time frame. Anything that Mr. Howard can't tell us when it happened, if that turns out to be the case, certainly I think should be excluded.
Okay, yeah. So again, subject to contemporaneous objections at the time. But the appropriate foundation needs to be laid. Okay, paragraph 29. According to Mr. Howard, Davion Murphy confronted him regarding Howard's involvement in Adam's murder and stated, "Bro, I'm going to catch up with you. I'm going to deal with you." This allegedly occurred at least 6 years prior to the conspiracy. State, are you seeking to admit this?
We are seeking to admit it, Your Honor, for identification purposes and for motive evidence. These statements were made specifically as a part of this quote as well, following Mr. Murphy's mention that Spaz, or the person that Mr. Howard was incarcerated for killing at the time, was his relative. And so he's shouting that at Mr. Howard at the time. Mr. Howard also being present with the victim in that parking lot on this evening would be a basis as to why we're seeking to introduce this.
Okay.
It occurred allegedly 6 years prior to Mr. Jones' murder. Number one, again, just so we're clear, there is problem number one, its admission of a statement 6 years earlier and how it might affect the jury as it relates to Rashad Murphy, since we are not severed, number one. And number two, it again falls, based on the prior arguments, far outside of the conspiratorial timeframe.
All right, let me think about that one. Reserve ruling. Okay. 30 is just a statement of law. Paragraph 30.
One more thing, Judge.
Sure.
Also, as it relates to the fact that there are two Murphys here, and these Murphys are cousins,
right?
I think there's a even more complex and complicated issue in allowing that statement to come in and how the jury may perceive it, and its prejudicial effect outweighing any probative value.
Okay, thank you. I reserve ruling. 30, paragraph 31, Howard attributes several statements to co-defendant Isaiah Chance. We've already discussed it. Okay, same ruling. 32 is just a legal argument. Okay. I think that takes care of your motion. Okay, so I'm going to think about 7A and then paragraph 29. Okay, I'll let you guys know.
Thank you, Your Honor.
Sure. And again, when we talk about the severance issue, again, just to clarify, we don't have a brutal problem here. And then the only issue would be if there's evidence that would, quote, improperly influence, close quote, the jury, with evidence that would be admissible against one or more co-defendant and not all of them, which is kind of an amorphous standard. So it's kind of beauty in the eye of the beholder. So that would be the determination, whether that evidence would rise to the level of improperly influencing the jury.
And Judge, it goes without saying that the state would not be opposed to a limiting instruction from this court, specifically with instructions to the jury as to which defendant the evidence applies to at the time when we introduce those portions.
Sure, I understand. And it is a different, I did find really in an abundance of caution, the two statements or the two text messages that the state agreed not to introduce were I think it was 2023, a set of text message exchanges between Isaiah Chance and Alicia Andrews. While those, in my opinion, are admissible as to Miss Andrews and Mr. Chance, it does predate the conspiracy, so in abundance of caution, those should not come in. The state agreed. The other one was, I guess, the celebratory comment made by Mr., I think, Davion Murphy that was sent to Sean.
Judge, I don't believe we know which Murphy
Right.
specifically sent it, but it's
Okay.
signed Murph.
Right. So for those reasons, and including the fact it was post-conspiracy and an abundance of caution, I didn't think it should come in as at a joint trial, and the state agreed. These statements that are made by the defendants during the conspiracy time frame in particular are distinguishable from those that I thought should be excluded in an abundance of caution. As I'm trying to not tiptoe close to, quote, improperly influencing, close quote, the jury, as that phrase has been utilized in specifically second DCA precedent.
Judge, and just so the record shows, notwithstanding the court's ruling, as it relates to the celebratory messages that are not coming in, there was testimony from Detective Ramos that, in fact, the witnesses he spoke to indicated that they didn't know Rashad Murphy. It was Davion Murphy that they were aware of, and that's who they believed the text messages were sent by.
Right. So we had two issues with those messages. One, it was post-conspiracy, and two, the foundation of who actually sent it, which of the Murphys, is less than crystal clear. Right? Right. Okay. 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 So, and then the other motion was with regards to the Andrews verdict during penalty phase.
Yes, Mr. Harmon filed that, I believe, yesterday afternoon. He is out today, but I said that I could cover it. Do you want to handle that now, or I don't know if you received it or not?
If I received it, I haven't seen a copy yet. So do you have a copy I can look at?
I think I do.
Okay, thank you.
And Judge, we did briefly touch upon it. I believe that Mr. Pretrial had filed a judicial notice of the verdict of Alicia Andrews, and we had spoken, and I think that you had previously said that obviously it would not come in during the guilt phase, that it did not have a relevance. I think that Mr. Pretrial had made some indication that he thought it might be relevant for penalty phase, and I think that is Mr. Harmon's objection. He filed a formal motion in limine objecting to that, as it would be improper and have no bearing or relevance to the jury's decision with regards to mitigation. It's improper character. There's no reason or way to tell this jury why the jury in Alicia Andrews made the decision that it did. There could be a myriad of reasons, including mercy, jury nullification. We don't know why they made the decision that they did. So what happens in one defendant's trial, verdict, or sentence doesn't have a bearing, or should not have a bearing, in the current defendant's penalty phase. And so that was the basis of his motion.
Well, and it looks like there may be precedent, United States Supreme Court opinion, Lockett, right?
Yes, there was some case law that he filed as well.
Okay.
In support of his position.
Okay, so I tell you what, I'm going to take it under advisement. Let me take a look at this Lockett case, and then, Mr. Pretrial, do you have any additional, or does anyone have any additional case law, or do they want a chance to submit it?
I don't have any additional case law right now.
Okay, so I tell you what, I'm going to take it under advisement. I'm going to look at Lockett.
Could we have a chance to submit?
Yep. How much time do you need?
Briefly address something on that?
Sure.
I just looked up the motion this morning, but I think we're just dealing with sentence, not involvement, correct? Because
Correct.
I think that Alicia Andrews' involvement in a penalty phase can be compared to another particular defendant's involvement. But I'm trying to make sure that the state's motion is only dealing with sentence, not Alicia Andrews' actual involvement in this case.
Well, it says specifically in the motion, the subject matter in question is any argument comparing or regarding the verdict rendered by the jury to the Alicia Andrews case to the defendants, or otherwise arguing that fact as mitigation.
The point I'm making is that I think that her involvement, any defendant's involvement, which can be a problem when you have multiple defendants, but the involvement of one defendant versus another can be relevant for a penalty phase.
Okay.
Not verdict, as in the Andrews case maybe, or the sentence, but certainly one person can be more culpable than the other. And again, the problem is suggesting that maybe one defendant should get life and another defendant should get death.
Okay, so I'm going to give you guys a chance to research the issue and submit case law, okay? So how much time do you need?
You have at least a week on it.
Sure. Okay, so I tell you what, I will give you guys until Friday, April 10th to submit any case law to me on this topic. Okay. Any other motions we need to discuss?
Your Honor, as a part of the state's response from this morning, the court had previously asked the parties to submit to the state any additional YouTube videos they intended to use or additional items of evidence that the court needed to consider, so the state did also address those things. I can tell the court that I've reviewed the videos that were provided, and the state does have some objections to those videos. I know Mr. Chance, on behalf of Mr. Chance, that there were 4 videos provided, and on behalf of Mr. Murphy, there were 4 videos provided.
Davion Murphy.
Davion Murphy. I will defer to the court as to how we address those, or if the court just wants to hear the state's objections as to those.
But do you have them identified?
Yes, and with a link in the event that the court or the other parties wish to see them as well in the motion.
But you haven't filed a motion in limine?
I have filed a motion, yes.
You have?
Yes, Your Honor.
Okay.
I filed it this morning because we received the defense's motion in limine on their videos yesterday.
Okay. Well, can I take a look at your motion?
May I approach, Your Honor?
Sure.
So kind of just email the judge, I'm going to print this for you.
Okay. Okay. All right. So according to this motion, the state wishes to keep out, as to Isaiah Chance, a video titled List of Dead Ops that was posted on YouTube. A block party invasion went to Yungeen Ace block. It's a YouTube video. 3, God Don't Know by Julio Foolio. And number 4, Demigod by Julio Foolio. So, are any of the defendants seeking to actually introduce these, and why?
These would be, these were somewhat in abundance of caution, but these would be rebuttal, depending on what is testified to by some of the state's experts, the gang experts.
I see.
And they would be authenticated through that expert, if at all. It may not be necessary depending on direct cross-examination. And possibly only if it needs some still shots from some of these videos.
All right, so you're not intending to utilize these, and in your case in chief, seek to admit them in your case in chief. It would just be potentially as impeachment or rebuttal as to the testimony of the gang expert?
Correct, Your Honor, for a variety of reasons. Based on gang certification and issues with Mr. Jones.
Okay, so then as to these 4 identified videos, I'm going to grant the motion without prejudice to revisit. If you think that you actually need to introduce them, we just need to talk about it before you do it.
Yes, Your Honor, I understand.
Okay? But generally speaking, the videos are not to be referenced or discussed in front of the jury until I've given permission for any party to do so. And then as to Davion Murphy, the videos listed are When I See You by Julio Foolio, again, the List of Dead Ops, YouTube video Certified Killer by Julio Foolio, and God Don't Know by Julio Foolio. And why is Mr. Murphy going to seek to introduce these, or what are you going to do with these?
Would be the same position as Mr. Chance, Judge, becomes.
If you think they become relevant, then you would seek to introduce them.
That's correct. We'd ask the court just to.
But you're not going to be submitting them as you don't anticipate at this point as part of your case in chief.
Correct.
Okay. So that'll be the same ruling. Generally speaking, these videos 1 through 4, as to Davion Murphy, the state's motion is granted, however, without prejudice to revisit, and during trial and defense, you just need to confirm with me ahead of time before you start showing them or discussing them in front of the jury.
That's fine.
Okay, very good. Then we've got unrelated officer conduct. Counsel for Davion Murphy has filed a notice of intent to rely and listed a witness and records from the Jacksonville Sheriff's Office to include the personnel history of Detective Craig Griffin and Trey McCullough. Are you going to actually seek to utilize these records as impeachment?
Yes, Your Honor. I believe that's Ms. May's motion.
She filed a motion as to these?
Yeah, I thought that was what it was correct.
Well, 'cause I don't have that motion in front of me. So did Ms. Tomei, did Davion Murphy file a motion in limine specifically to include this information?
She did not. She sent us an email with a notice of her intent to rely on the information, and she did file an amended discovery list with instructions that she would seek to introduce or admit the following videos and evidence, and then listed the witness as well.
Okay. So, Mr. Sonardi, is Ms. Tomei, is she handling this argument, this issue?
I said I was not aware that Ms. May was not going to be here. I'm really not in a position to argue that motion.
No, I understand. I honestly would like to see what we're talking about here, as far as what the actual evidence is. So,
They were not filed, Your Honor, but I do have 2 copies of the investigation history. I do not have copies of the civil lawsuits that were filed against the Jacksonville Sheriff's Office for the court because they were pretty lengthy, but I can provide these copies if the court wishes.
I don't think that was actually filed.
okay. So here's what we need to do. Are you able to contact her this morning, Mr. Sonardi?
Right. I got her number, obviously.
Your Honor, if it's okay, I have a warrant in Polk County if I could.
Yes, you're free to go. So I tell you what, let's do this. Mr. Sonardi, let's just take we'll recess as far as Davion Murphy, and I'll give you a chance to, because we're going to need to set another date, because I'm going to need to actually physically take a look at what these records are, and we need to have further discussion on this, and whoever needs to be able to argue the motion. So why don't you find out her availability for the remainder of this week and Monday and Tuesday of next week, so we can get that done. Are there any other issues as to Rashad Murphy, Sean Gathright, or Isaiah Chance?
You know, Your Honor, the only thing, and this may not be the time, but I know we were talking about with the deputies, they want to talk logistics as far as how we're going to plan on fitting everyone.
I was going to bring that up, Judge. There's a small army on the side of the fence.
There's only about half of us, I think, now.
Okay. Well,
You're just going to leave that up to us and the court staff?
yes.
Do you have anything you don't want? Because
No, I really don't. As long as you guys can get to the podium without having to create a distraction, that's all I care about. So
and certainly having ingress and egress without the staff being concerned about
correct. So I do think anybody that's not going to be speaking on the record, okay, staff that's not going to be speaking on the record, do you want them in the well, or are they okay in the audience, or what do you think?
Judge, in previous experience, I could tell the court that, for me personally, my investigator is critical.
Okay.
In a number of different ways in a trial this big.
Okay.
So I would suggest to you that I would need my investigator at counsel table.
Okay. So how many people total? You have yourself, Mr. Hernandez, your investigator. Who do you need at table in addition to your client?
Mr. Hernandez, myself, and the investigator.
Okay, so you need 4 people.
Correct.
Okay, Mr. Sonardi, how many people do you need at counsel table?
Your Honor, obviously, myself, I'd like to have my investigator, but as possible, that she could sit behind me so she's not at
Okay.
the table.
Could your investigators sit behind you, Mr. Gonzalez?
I'd rather not, Judge.
Okay.
I mean, unless it's a crisis situation, because he does work very closely, not only with me,
Okay.
but with Mr. Murphy.
Okay, so they want,
And I would like Scotty Sinardi, the other
yes,
attorneys with me.
and Mr. DeLauder.
I don't know.
Your Honor, considering I'm the smallest fish in the pond and the last man on the totem pole, I'll go wherever I need to facilitate.
You could-
It'd be nice to be at the table.
Right.
But wherever I.
Need be, we can throw you off the island into the audience, right? Okay. But 5 preferably in a perfect world. Okay, Mr. Wise?
Here we have Ms. Finkelstein. You may recall Mr. Mendez is third chair counsel as well. He's been here for some of the proceedings. And then I would like our investigator/mitigation expert, at least during jury selection, and if there is a definitive phase.
Okay, so 5
Yes.
people. Okay, Mr. Petratus?
5, Your Honor.
5.
We
Okay.
can at least 1 or 2 times.
Yeah. Okay. 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 Very good. So we are.
Not very good at math. I think that's 19.
Yeah. Okay. That's fine. We'll figure it out. Maybe we need to change the setup as opposed to an L shape, because once we get the jury in here, it's going to be much more important that you all are facing the jury than me. So what I may do is have the bailiffs, we'll work on it, but maybe move the tables so they're actually facing the jury, and during jury selection, turn them so they're facing out towards the jury, something like that. Okay? So we'll make it work. We'll figure it out.
Your Honor?
Yep.
Hi, I'm Nixon Ice investigator. I have Deborah told me, she said she is available April 2nd in the afternoon at 1:30.
Okay? State.
Does that work for your Honor?
It is for me, but I don't know does it work for the state.
Sorry, what was that? April 2nd at 1:30.
I could, could we make it 2 o'clock?
Okay for the state.
Okay.
I will say yes on behalf of Mr.
All right. So, and then as to,
Judge, I also think, just from speaking with Ms. Toomey and myself, there's one other matter that we may not be in total agreement about, the defendant's reported statement that she may want to bring to your attention. We have worked out most of it.
as to Davion Murphy.
Yes, ma'am.
Okay. That's fine. So I will hear those matters at 2 o'clock on April the 2nd. If the other defendants wish to be present for that, you're welcome to. It's up to you. Mr. Gonzalez?
Nothing further, Judge, and thank you for the offer. I'm not sure we'll be attending, but
Yeah, that's fine. So for now, I'm going to tell the sheriff's office not to transport your client, but if something changes,
that's fine, Judge, yes.
okay, so do not transport Rashad Murphy on April 2nd in the afternoon. As to Mr. Gathright, Mr. Wise, does your client wish to be here for those motions?
I have a conflict, Your Honor. Mr. Gathwright's fine with waiving.
Okay, that's very good. So do not transport Mr. Gathright. And as to Mr. Chance, Mr. Petratus? Okay, very good. All right.
The only one that's going to be said is
Davion Murphy. Okay? And that is so that I can hear I know you just gave me the motion. I know you just gave it to me, now I can't find it. The motion with regards to the personnel files of two of the detectives from the Jacksonville Sheriff's Office.
And any objections from the defense if we just as a courtesy, just print out the exhibits that were provided to the state and hand deliver them to the court at some point today? The attachments that were all sent to us with this personnel file, those lawsuits and such, everything that we attached. Is there any? Sure. Is there any objection to us providing that in advance to the court for review before Thursday?
No.
Okay, and for the record, it's the state's 7th penalty phase motion for order in limine? No. That's the,
Yeah, that was the one with,
yeah, that's the one I gave you all until, gave
April 10th.
April 10th to the defense to submit any case law. Oh, okay, so it would be, we're going to, as to Davion Murphy, the motion for, it would be part of the state's motion for order in limine regarding improper character evidence as to unrelated officer conduct. That's what we will hear Thursday, April 2nd at 2 o'clock. Yeah, let's just go ahead and use in my regular courtroom for that since it's just one of the defendants. All right, so please let Ms. Toomey know, Mr. Sonardi, that I'm going to hear that motion in my regular courtroom. Okay? Okay. Is that it for today? Oh, and on the raw data, I need, how quickly do you think, how much time do you think you need for your experts to get that information over to the state's expert? A week? What are you asking for, state?
Judge, I think that as long as they get it to us within the week, I think that should give Mr. Harmon's experts the opportunity to be able to review it. I don't believe they have set Mr. Harmon's expert witness for deposition yet either, so I think that that's fine.
Judge, I probably should not let Mr. Hernandez go, but, and I don't, because I don't know the status of the way that train is rolling, certainly I'm going to just defer to whatever the court thinks.
All right, I'm going to say by April 8th, by the time we begin jury selection. Okay?
Judge, and just that reminds me, I know that Mr. Pretrial listed an expert, a gang expert as well, that we attempted to take the deposition of, but that expert is Dr. Leap, had not actually finalized her opinion, and she said that she would have it finalized by the 8th, and we would be able to take her depo in a couple of days from that time frame. I just wanted to put that on the record just to make sure that she has her finalized opinion by that date.
I let her know, because we scheduled it for April 9th at 5:30, and I let her know that. She responded, she's under the weather right now.
Okay.
Won't be a problem for April, but I did let her know that demo date, and she hasn't sent me any pushback.
So that, what's the expert's name again?
Dr. Leap.
Leap? Okay, Dr. Leap's report needs to be submitted to the state by the state's evidence.
Discovery.
Okay.
She will, but by the depot date, she will, when she gets a depot, she will have to have it.
Okay, so she's not going to issue a report, so, but, okay, very good.
Just, I have a question.
Yep.
The state's motion regarding the improper character evidence.
Yep.
As to Gathright.
This just says to Davion Murphy.
Right, because I thought you had said with,
Well, no, part of it was.
Part of it, okay.
So I've ruled on the motion for order in limine regarding improper character evidence and the state's response. I ruled on the video portion. Okay, that's I've ruled on. I've granted the motion without prejudice to revisit if necessary. And then unrelated officer conduct as to that part of the motion, that's being set for hearing or continued for hearing for April 2nd. Okay? Okay, and I'm going to hold on. Ms. Ismer, you gave me a copy of the state's response and motion for order in limine regarding improper character evidence. I'm just going to hold on to that. That's okay. Okay. Anything further? Okay. So, if you don't hear further from me, or if you do need anything, by all means, make sure you contact me and let me know. I'm available to do whatever I need to do to help you guys get ready for trial. So for those other than Mr. Davion Murphy, if you don't need me in the interim, then I will see everyone. You need to be, I would say, courtroom 1, I would be there by 8:30 in the morning. So as soon as jury services gets 175 people to walk through the door, they will send the list over to us with the names and numbers. You guys can begin filling out your seating chart, okay? So be it in courtroom 1.
Number only, we're not
Only.
jury sheets.
Yeah, because at least half of those people are going to be gone by the end of the day. So there's no point reviewing juror slips for people that are going to be discharged. There's no reason. So, and then you'll have more than sufficient time to, you'll have over the weekend to begin reviewing the slips for any and all that are coming back for phase 2 voir dire the following week. Okay?
But we'll be trying the case in here, just jury selection.
Correct. Just jury selection in courtroom 1 because I need the lobby. Okay? Okay, very good. Thank you all.
All right, that was a really, really good hearing. That was a great hearing from March 31st. And we heard, she says the penalty phase, she's thinking May 4th for 1 week. They are definitely going to be done by the 15th. And as we know from Florida PI Sam, who is joining us, they are part of the team that's representing Davion Murphy. They're going to have a jury seated by tomorrow, which is Wednesday. And the judge said that they were going to give them, she wants to give them Fridays off, but she's going to at least give them the first Friday off, and then she's going to see how the rest of the trial goes. But they're definitely going to go Wednesday and Thursday of this week, which is tomorrow and then Thursday. And then they're going to take off Friday. And then they're going to come back the following week and maybe take off the following Friday. But Sour OG, as we're talking, it didn't even dawn on me. So Who I Smoke, I had it as April 28th. And we did a deep dive between ATK and KTA last week. So if you guys want to check that out, it's in our playlist. Here, I'll drop it here if you guys want to check it out. We're not going anywhere anytime soon, so stick with us. Hit the like button, you guys. We're at 306 likes. If you hear my voice, please, please, please show us that you are not a robot. Show YouTube that you are a real person. Hit the like button. So, so we did this. We did a history on ATK and KTA last week, and then we also did a deep dive into Charles's just his life alone. And I had it as April 28th, Who I Smoke. But then it said, well, Julio dropped it in April as well. Well, there's only a couple days left in April. So what happened is, and again, I don't know if this is real or true. Again, it's just based on a Google search. But I've got Who I Smoke dropped on April 16th of 2021, and then When I See You, April 22nd. So I think by all accounts, Julio did drop his a week or so later, so that kind of makes sense. But if you guys have any other information to the contrary, let me know. April 22nd. Today's the 21st, so literally the first day of trial is going to be the 5-year anniversary of When I See You. Oof, that's like mind blowing, right? Hey Renee, how are you? Welcome in. Just crazy how that. And I don't know, for those that followed us on Corey Richens, she's going to be sentenced on her husband's anniversary of his passing, that she was found guilty of poisoning him. Again, how just it's weird how these, and that's happened before too, but it's really wild how these things work out. So, again, to recap, for those that are coming in new and fresh, we have this timeline that we created. The state is going to bring in 6 incidences. And so we went back a little bit. We thought, we didn't want to we wanted to include their 6, but then we also wanted to give you a deeper understanding of where this all began. And by all accounts, from what I've been able to find, Eric's birthday. I'm sorry. Yep, Aaron's right. It's Eric's birthday, not his passing. Yep, it was his birthday. It's his birthday, not his passing. My bad. His birthday. So by what I've, thank you, Widespread. Got it. His birthday, not his passing. My bad. Let's get back to this trial. So by all accounts, from what I've been able to find, it was a Kodak Black concert that these two groups got together, and somebody was supposed to shake hands, and then one person didn't, so a fight ensued, and witnesses were saying instead of just fighting, they were shooting. And then after that, it was Aiden McClendon that was an innocent bystander, but he, as it turned out, was the cousin of Reginald and Noah Williams there. Then Zion Brown, and I've gone over this a couple times, so I'm not going to go over it in detail. I just want to show you guys this. So then Zion Brown in 2017, and then Ace and his brother and his two really close friends Ace survives, but his brother and 23 and Kobe get taken out in 2018, and then Corbin Johnson goes missing in 2018, but then he's found in 2019. But then here's where the state kicks in. So the state kicks in with Bibby, or Adrian Gaynor, in 2019, and then they continue on with Gerard Adams, but they don't include Tiki or Lil Nine, and obviously Bibby, Tiki, and Lil Nine are huge in the Who I Smoke video. If you guys watch that, then you know that's the famous or infamous, I suppose, moment where they're calling out them. Then the state goes to 2013 with Jaquan Pickens, and he's driving down I-95. He gets shot, runs into a semi truck. Couldn't find any news on that. Still looking for news clip on that. Then you got Jacoby Beals. He's taken out the next day. Then you got Antonio Tilley. He goes to a house. He's got an Uber driver, goes to a house, and he gets shot as well as the Uber driver. And then Charles gets shot literally a couple hours later. I have it the next day, but I think it was like 5 to 6 hours later. This obviously was not the first time Charles was shot. He was shot in Houston. He was shot coming out of a session at his music studio. He got shot at. Didn't catch any bullets then, but according to him, don't know how he made it through that. And then of course that's where the state's gonna end, and then they're gonna end with his shooting. So I just wanted to show that to you guys for those that are coming in new to this case and or our stream today. All right, so let's move on. We've got one more before we get to. I'm going to show Alicia's openings and then her testimony, because everybody's asking about Alicia. She's all over this trial. So let's just check this out. I'm not sure what this is. If this is a news report, or let me see what this is.
Okay, very good. Davion Murphy is present.
All right, so this is a hearing. This is from just a couple weeks ago. So this is from April 5th. So this is from. All right, so this is from April 5th. April 5th. All right. Oops, nope, not that one. This one. All right, so this is from April 5th. Let's check this out.
Okay, very good. Davion Murphy is present. Good afternoon. Is it Miss Toomey or Toomey?
I've been called both, but it's Toomey.
It is Toomey, okay, because I believe I heard Mr. Sonardi, Senior, refer to you as Toomey, and I'd been calling you Toomey, and so I just want to make sure I get it right.
I appreciate it.
To the extent I'll remember this entire conversation. Okay. All right, so we're here on, basically the state filed a motion for order in limine regarding improper character evidence, and I already ruled on the YouTube videos that were contained or listed in the motion, and so now we're here regarding the personnel files of Detectives Griffin and McCullough from the Jacksonville Sheriff's Office, and the state did send me a copy of what the materials were, and it looks like there were claims of excessive force against these officers in unrelated cases. And so my question to you is, why is that relevant in our case?
And Judge, I believe I also provided the state with basically an employee administrative investigative history for both Officer McCullough and Officer
Yeah, I looked at that too.
Griffin. Okay, so the court has those.
Yep.
The state is going to be planning to elicit opinions from these three detectives. Detective Griffin, who is supposed to be a gang expert in 1200, McCullough, an expert in 6 Block, and Detective Maynard, who is a gang expert in the gang of ATK. So how these detectives, and part of being able to offer an opinion as an expert is by gathering information and data and then formulating an opinion. The basis and manner in which these detectives gather that information and gather that data in order to formulate their opinion is derived from cold contacts, which is just approaching individuals on the street, and also traffic stops, lots of traffic stops. So in order to be able to, and Your Honor has discretion, obviously, regarding the cross-examination of witnesses. In order to be able to attack their credibility and the reliability of the data and information that they're relying upon in order to have rendered or reach their opinion, I think it's fair game for cross-examination. I'm not intending on introducing the lawsuits themselves, but I think at least questioning them about the fact that there are these lawsuits that are pending, of which deal with Detective Trey McCullough, Daigle, who is a supervisor of the gang unit. He is the supervisor of both Detective Craig Griffin and McCullough, is my understanding. And Doug Howell is also in one of those suits. I believe it's the second suit, the 2025 suit involving Jamari Brooks. And with regards to Doug Howell, and I believe the state can correct me if I'm wrong, but he was listed at some point in the state's witness list as a witness for the state. And this Doug Howell, who was I believe still is, a detective in the gang unit. There was a big to-do about this detective in the gang unit tweeting, making biased racial tweets, and therefore the public finding out about this, basically calling for the disbandment of the gang unit in Jacksonville. It also would go to the fact that our client was essentially on the run, if you will, for about 6-7 months. Mr. Murphy was born in Jacksonville. He's very familiar with how the Jacksonville Sheriff's Office operates, how the gang unit operates, how its detectives operate. And it would be relevant to why he was hiding out from law enforcement, because he was afraid. So on those two fronts, I think it goes to the reliability and the credibility of the state's experts' opinions and the underlying reliability of their opinions, which is fair game for cross-examination, as well as relevancy as to Mr. Davion Murphy's being on the run for 6 or 7 months. The state's most likely going to argue that that's consciousness of guilt when it is the opposite of that.
Okay, just to be clear for the record, there were two, looks like there were two civil complaints Yes. Filed in the Middle District of Florida, the United States Middle District of Florida, and I only see Detective McCullough listed as a defendant, correct?
He is listed as a defendant in the Jamari.
Yeah, in Brooks and both, McKeon, Woods?
McKeon Woods, in both.
Yes, listed in both.
And Bo Daigle is in Brooks as well as McKeon Woods, the first case.
Yeah, but you indicated, I think, in state, okay, so state, the Detective McCullough is going to be a gang expert with us?
He is, Your Honor, and Bo Daigle is not with the gang unit any longer, was not in the gang unit at the time. That several of these, I guess, complaints were made. I don't expect that the state would be calling Mr. Daigle in any capacity in this case. So obviously, any of the actions that were just mentioned relevant to Mr. Daigle as one of the persons as the subject of these lawsuits, the state would ask that the court dismiss. As to, would you like to continue or do you want to go?
Well, no, and so Detective Griffin, again, he's just testifying as a gang expert?
Correct.
Okay. And Daigle's not testifying at all?
No.
Okay. All right. Anything further?
McCullough is testifying, Your Honor, but Detective McCullough was also not in the gang unit at the time of the text message that was just brought to the court's attention. I did cite very well-established case law, and for the record, there are no instances in this particular case where Detectives McCullough or Detective Griffin would have had direct contact with the defendant, nor any claims from the defense of excessive use of force.
Okay, so, the case law is pretty clear. And it is as follows: when the matter is wholly unrelated to the case at bar, the evidence should not be admitted. And that would be the Florida Supreme Court opinion, Pretrial versus State 580, Southern 2nd, 605, Florida, 1991. In this case, I'm not alleging, I haven't heard it, excessive force, so that's not the issue. These detectives are going to be testifying as gang experts, so any rationale for this to be used as impeachment evidence before the jury is pretty remote kind of nexus. So I'm going to grant the state's motion in limine as to the personnel files of Detectives Griffin and McCullough.
Judge, if I may, just for clarification, with regards to the summary or the history of the employee administrative history for these two officers, McCullough and Griffin, there are times where McCullough had to receive remedial training as well as
right, but for unrelated stuff that's got nothing to do with this case. So even looking at these, the employee administrative investigation histories of McCullough and Griffin, there's nothing in here that has anything to do with anything that's an issue in our case. So, as indicated, I'm going to grant the motion limiting. Okay, anything further today?
Judge, there was, and I know that Ms. Toomey and I have gone a long way in reviewing the defendant's statements about retractions that we can agree upon. I think we're almost like 95% there.
Okay.
So I don't know if you want to, if they're prepared to address it now, or we did bring the transcript. It's up to Ms. Toomey.
I'm at the pleasure of the court if you want.
Is there stuff you don't agree upon?
There is, Judge. And I believe that Ms. Toomey wanted some additional material taken out. Is that correct?
Yeah, we went through the main objection, or the main...
Judge, I did bring a clear copy for the court as well.
Okay. Portion of the interrogation that we would want out would be anything said or asked or stated prior to Mr. Murphy being ready to terminate her rights. I believe that ends on page 13.
State what's your response to that?
Judge, I don't believe there's any reason to take it out, and there were, in a lot of the portion while he's in the room himself, he is talking audibly out loud. He's rapping, and there are statements in there that specifically go to consciousness of guilt. I don't want to go into all the language that he uses, but he says how to hide in plain sight, and he has been on the run for months.
And is that him just talking to himself?
Yes, Judge. He's rapping out loud to himself. He's talking. It's before there. A lot of it is when he is alone in the room by himself, but the audio is
not
playing.
interrogation, so why isn't that admissible?
Judge, I would agree that part is not interrogation.
Yeah. So as far as that goes, that being the objection, if it's pre-Miranda, if it's not custodial, and it's not, he may have been in custody, but it's not an interrogation because he's talking to himself. So there's no Miranda problem. So, okay?
But with regards to any questions that are asked by the detectives to...
Well, like what specifically?
Just anything. And it's really not even relevant. You want a water or anything, bud? No. You want a cigarette? What kind of water? What kind you want? It's just going back nonsense. It's really just not relevant.
Just state what's your position on that.
Judge, obviously, we do have to show that this is voluntarily, and they are making concessions to him for bathroom breaks, whether he wants something to drink, whether or not he wants, and they do promise that after all of this, they actually do walk down the street to get him, they can't smoke it in there, but they are talking to him and trying to make accommodations for him.
Okay, yeah, that's admissible too, because that is right. The state's got to prove it's voluntary by the jury. Okay. Anything else in the interview?
Did you want to address the ones that we agreed on, or
the ones that we agreed on?
You need to address them. I'm over here to resolve disputes.
There's no issues.
Just to resolve disputes, not to babysit. Okay, well, take a look at it, just make sure if there's any, and we can address it, we're going to be picking a jury for a week and a half, so we'll have plenty of time.
It's just a few.
I'm just trying to make sure I have all the redactions done.
You guys get together, just make sure, and if there's any other disagreements, let me know, we'll talk about it, but it should not take too terribly long. Okay. So I'm going to give this back to you, and I'm going to give the state back a copy of the personnel files of the detectives. Thank you. And I'll see you all Wednesday. Yes, Your Honor. Okay. All right. Thank you.
All right, so that is all we have for our pretrial hearings. Now we're going to shift gears just a bit, but not too much, because we're gonna check in on Alicia Andrews.
Okay, with that,
we're going to check in on Alicia Andrews. All right, so this is from, she was found guilty Halloween night. Let me see when she started. Alicia Andrews, day one. When was her day one? So we're going to do opening statements. All right, so this is from October 25th. I'm sorry, October 22nd. October 22nd. Now, let me post this for you guys, because I think this is going to give us a lot of insight into how the state is going to be, and then I want to see her on the stand. And let's listen to this. This is going to be openings, and then I want to I definitely want to see how much the state is going to bring from this into the Charles Jones trial. All right, so this is Alicia Andrews opening, October 22nd, 2025.
Practice for a wedding at 2 o'clock on Friday, so we will break no later than noon on Friday. Just so you all know, the rest of the jury knows, Friday afternoon you'll have free. All right? Okay, with that, State, do you wish to make an opening statement?
We do, Your Honor.
Okay, very good. You may proceed.
May it please the court?
Yep.
Counsel? He didn't know, because there was no way he could know, that his time here was limited, very limited, that he was in fact breathing his last breaths here on earth, living the last moments of his just barely 27 years of life here on this planet. He didn't know, as he was out with friends celebrating his birthday, that he was being watched, that he was being followed. He was being stalked. Stalked and observed while he was celebrating. Stalked and observed by a group of killers, a group of conspirators who were now executing a very premeditated plot that had been hatched and birthed days before. A plot that had been hatched between them with every single one of their collective evil intentions directed into one common purpose, one common goal: the premeditated murder of Charles Jones. This group's collective hatred and animosity, which drove the conspiracy that existed between them, this evil and despicably wicked conspiracy. He didn't know that now all of their planning, all of their surveillance, all of their advanced coordination was now coming to fruition. Coming into fruition in such a precise way that he only saw his killers for mere seconds as they rapidly closed in on him, dressed from head to toe in all black, like ninjas coming out of the dark. Disguises that included balaclavas and ski masks. Disguises that these conspirators had decided well before this moment that they were going to wear, to use to hide their identities from the ever-present and ubiquitous cameras that permeate our culture. As Charles Jones sat there in the front passenger seat of his Dodge Charger, their plan came perfectly together. He was now the perfect target, caught completely, entirely off guard, completely blindsided. As these gunmen appeared, seemingly, you will see in this evidence, out of nowhere. A perfectly planned ambush, and there's no other way to say it. The evidence will show you clearly this was an ambush, a designed ambush, one that they had carefully planned and now were orchestrating. Unable to run, unable to dive or even duck, basically caged in the front seat of his car. He was basically a sitting duck. And these killers, they didn't hesitate, not for 1 second and not for one moment. They moved rapidly into their pre-planned positions, into their firing locations. And then they immediately unleashed a hellish onslaught. affecting a precisely coordinated violence of action, sending a barrage, a wall of hot lead, crashing into the only barriers between Charles Jones living and Charles Jones dying. Those barriers, the automotive glass, the sheet metal of the front of his Dodge Charger, which were absolutely no match for the high-powered 5.56 and 300 blackout caliber rifle rounds, which were now traveling at him, directed at him at thousands of feet per second, each one of them carrying over 1,200 foot-pounds of energy, directed specifically at Charles Jones. A Glock 9mm handgun was being utilized by one of these conspirators, a handgun that wasn't just a semi-automatic handgun. It had been converted to a fully automatic hand cannon, and now it was running wide open, dumping all 30 rounds of its magazine through the front end and the windshield of that Dodge Charger. All of that gunfire filling the dark early morning hours with booming concussions and bright flashing muzzle flashes as these high-pressured and high-powered rounds flooded the atmosphere in front of that Dodge Charger. Charles Jones. You've heard his name in the indictment. That's his face. Just a few seconds of the mountain of evidence that you will see in this case of what happened that night. Evidence that will show you clearly that these co-conspirators hatched this murderous plot not minutes, not hours, but days before this, formulating in their hearts and minds this agreed upon collective and confederated plan with one common agreed upon goal: death, violence, and murder. A conspiracy motivated and hatched days before, hundreds of miles away from Tampa. A conspiracy that would span through those days and over 500 miles of travel. Reservations were made, uniforms, disguises obtained and selected, gear was obtained, weapons selected, weapons loaded, and weapons modified and made ready. Transportation was obtained, vehicles with specific purposes, and a plot that required advanced planning and logistics to include housing, communications, and transport would materialize and become reality. A criminal, murderous operation these co-conspirators leaving their homes in the northeast corner of this state, traveling here, traveling to their target, conspiring to murder Charles Jones, not in his home, not in Jacksonville, not on his home territory, not at his residence, but here in Tampa, while he was on a birthday trip, while his guard was down. And you will see in this evidence the clock-like precision of these co-conspirators, how they worked together as a team in this team effort. Principles. This is a law that you heard a little bit about. You'll be instructed on it at the end of this case after the evidence is given to you by the Honorable Judge Sisko. She will instruct you on the law of principles as well as the law on murder and all the other laws that you will need to render your verdict in this case. The law of principles, if a defendant helps another person to commit or attempt to commit a crime, that defendant is a principal and must be treated as if they had done all the things that the other person or persons did, if we prove this beyond a reasonable doubt, that they first intended that the crime occur and did some act or said something, anything, that was intended to and that did incite their co-defendants to commit this murder, cause them to, simply encourage them to, assist them or advise other persons to actually commit that crime. Now, incite, cause, encourage, assist, or advise the other person to actually commit the crime. For first-degree premeditated murder, we must prove that this defendant intended that Charles Jones be killed. It is not necessary for the principal to know every detail of how a first-degree murder will be committed as long as they intend that it occur. And they did some act or said something that was intended to help or did help the murder to occur. But almost more importantly, the principal, the defendant, does not have to be present when the crime is committed or attempted to be committed. But in this case, folks, you will hear that this defendant, Alicia Andrews, was right there, driving right next to that Dodge Charger in the seconds before this murder happened. If the defendant is found by you to be a principal, then she is legally responsible and accountable for everything that her co-conspirators, her co-defendants did. Alicia Andrews, these are her co-conspirators. I don't know if this laser is going to work, if you can see. In the upper left-hand corner, that's Rashad Murphy. Lower left, Davion Murphy. Sean Gaithright is in the upper right. And in the lower right is her boyfriend at the time, Isaiah Chance. These were the 5 conspirators. This was the assault team that took out Charles Jones, that took his life, that snatched it from him in the early morning hours of June 23rd. Isaiah Chance, Sean Gaithright, Rashad Murphy, Davion Murphy. To understand the murderous intent that existed amongst them, and to understand this conspiracy that dwelled in all of their minds and hearts, we have to go back and look at the lives and associations of Charles Jones and these defendants. What did Charles Jones do to these defendants that was so bad that would cause them to confederate, to conspire, engage in this coordinated, planned attack Charles Jones belonged to and was affiliated with a group known as 6 Block. He was a member of that organization. It exists in Jacksonville. It's known as 6 Block, and it is a street gang. It consists of several members. 2 other gangs in Jacksonville, ATK and 1200, were affiliated gangs. They despise 6 Block. They detest them. They abhor them. And the level of hate between these groups is a mutual hatred. The evidence will show that these gangs have been at war for several years. And when I say war, the evidence will show you this is a war going on in the streets of Jacksonville. The hatred and the dripping animosity of these defendants towards Charles Jones, it ran deep. And the evidence will show you that. In fact, you will hear that in October of 2023, just 9 months before this, before the murder of Charles Jones, he had left his residence in Jacksonville in that same black Charger about 6 o'clock in the morning. He came to a stop sign in his neighborhood, just a few blocks from his house, when a shooter with a high-powered rifle opened fire on his car, striking his car several times and striking him in his lower leg, spraying bullets all over that neighborhood. Mr. Jones at that time was able to drive himself to a local hospital, receive treatment, and be released. That bullet, or fragment of bullet, remained in his leg until it was removed by the medical examiner who conducted the autopsy on his body here in Tampa after his murder. Earlier that same morning, a member of ATK, a man by the name of Tilly, was shot and killed at a high school football game. This shooting of Charles Jones was clearly retaliation, but Charles Jones was not the shooter of Tilly. But that didn't matter. So why was he targeted? You won't hear any evidence to suggest that he had anything to do with that shooting. He was affiliated with 6 Block. And you're going to hear in the evidence that he wasn't just a member of 6 Block, he was a notorious member of 6 Block. Probably the most well-known member of that gang. In fact, he was the public face of 6 Block. The spokesperson, basically. He posted on social media, but most notoriously and notably, he wasn't just a spokesperson for 6 Block, he was a certified celebrity. Charles Jones had millions of followers on social media, if not tens of millions of followers, because he engaged in an activity that you heard a little bit about yesterday from one of your fellow jurors, and he was spot on. That's exactly what the evidence is going to show you in this case. This long-standing pattern of what is called drill rap. And it is an activity that Charles Jones embraced and that he engaged in under the name Julio Foolio, which was in fact his street name, Foolio. Julio Foolio. In this type of rap music, it's not just rap, it's disrespect. It's making fun of and disparaging not only ATK and 1200, the opposing gangs, but disparaging their members by name. Disparaging, and probably most incendiary you will find in the evidence, bragging about the death or deaths of other ATK 1200 members who have been murdered. As I said earlier, make no doubt about it, this is a gang war. Mr. Jones, you will see in the evidence, not only produced this music, he produced music videos. Videos where he would travel to the gravesides of these individuals, or a graveside that was used in lieu of their graveside, and do things during the video like lay on their graves and sing around their graves and use sarcastic lyrics in his songs, pour champagne on their graves, rubbing it in the faces of ATK and 1200. And ATK and 1200 were no better. They did the same thing. You're going to see videos from members of that gang. One young man in particular, Kenyatta Bullard, known on the streets as Yungeen Ace, who produced not only songs about 6 Block members who had been murdered, in the days after the murder of Charles Jones, he produced a song just within almost 48 hours and put it up, talking about the murder of Charles Jones, the specific facts of it. This created in those 5 individuals, in their minds and in their hearts, a vendetta. This was revenge. Because he ridiculed them, and he ridiculed their gang, which was their family. He ridiculed their friends, which were their family members. They were close, deep running bonds of loyalty in this organization. Because they have each other and they defend each other. They defend not only each other, but they defend each other's honors. And they defend their affiliations. This is the murder scene. Let me see if this will work. Home to Suites, McKinley, Fowler, USF is directly across the street. The USF campus lays literally feet away from this hotel complex. Over here you can see it's a Holiday Inn. This is the portico right here where the shooting happens. What you will see in this evidence is that these shooters arrive here and they come in and they go around the north side of that complex as Mr. Jones is sitting here at the portico with 2 other cars full of his friends and partygoers, people celebrating. His girlfriend was in the other car. He was a passenger. His friend Xavier Edwards was driving. His longtime friend Gino Norris was in the back seat. They pull in. The shooters come in this way. They go around. They come down here. And they park in this area here. And then they act on foot. And they come around here, surprising Mr. Jones. You saw Mr. Jones' car try to evade the shooting and go this direction. He goes straight up here. There is no road here, but they make a road in their desperate efforts to get away. They go right past this dumpster, and the Charger ends up here. This is Mr. Jones arriving. He's been out celebrating, you'll find in the evidence. That is Mr. Jones with that open passenger door. The vapor you're seeing is coming out of the hotel. That's some type of a dryer vent. Mr. Jones in the red stocking cap pulling up his shorts. He walks in the hotel. As you can see on the timestamp, which is slightly off by a few minutes, this is about 4:30 in the morning. They had been out through the night. They had gone to a couple of clubs. Mr. Jones appeared at one club and performed, and then he went to an after party at another club. He had attempted to make a reservation here, but because they appeared so late, it had been given away. You'll see him come back and get into his car. Video slightly sped up here. That car entering right there, that's the assault team. And as I said, they go northbound around the north side. They avoid driving near this entourage, Mr. Jones and his friends. This Nissan Altima that's pulling up is part of the entourage that was with Mr. Jones. The driver, Tafa McCrae, is a friend of his. You will see his girlfriend get out. And they go inside of the lobby to use the restroom. So Tafa and his girlfriend, Aaliyah Albritton, they walk in to the lobby, and they're actually inside there in the bathroom when the shooting happens. Now, you probably didn't see it, but when Tafa got out of the driver's seat of that Nissan Altima, Camilla Bentley slid right in behind him. That's another friend of Mr. Jones and friends with these folks. She's sitting in that car at the time of the shooting. She takes a round through the arm. This car driving by, that is the spotter car. That is the surveillance and reconnaissance vehicle. This is just before the shooting happens. And you're going to see that car come right back by. It goes down, does a three-point U-turn, and comes back. And now we're mere seconds away from the attack on the Charger, on the attack on Mr. Jones. You'll see the Chevy Cruze go southbound on McKinley. Down to the lower left, you saw the shooter with the automatic Glock. That's him in the lower part of the photo. So you see in this video, Xavier Edwards desperately trying to get them out of harm's way. But what he didn't know was that up on the top of that screen between that, I think it's a Mercedes and that yellow car, was the third shooter. So what he ended up doing was driving and you'll see it come to fruition here, directly into a vortex of high-powered rifle fire. Now, what you're also going to find in the evidence, and you can see the electrical charging station up here in the upper right, this is the edge of a Tesla that's sitting at another Charger. That Tesla has its, I believe it's called Centurion function on, and it is recording from multiple cameras around the car. And this is one of the recordings. You'll see several in the evidence. that picks up the third shooter running down behind that row of cars and taking up position by that yellow car. He is the shooter on the other side of the street that forms that deadly vortex of fire as the Charger goes by. And as the Charger, you will see in the evidence, runs down the side trying to escape down the side of the hotel, this shooter comes running up to this position by the charging station and is opening up fire down the west side facing north of the Home to Suites. That is the headlights of the Charger fleeing up the west side of the hotel, heading north. The third shooter. That's the Charger at the impound lot at the Tampa Police Department. You can see the impacts. Every one of those yellow stickers on the hood, the side, and the windshield are all impacts. That's the Altima that Camilla Bentley was sitting in. It took 2 rounds to the back window. This is Xavier Edwards, who was the driver of the Charger. That's him at the hospital. Gino Norris, Mr. Jones' friend, who was in the back seat. He was shot in the upper right arm. And Camilla Bentley, who was shot in the upper arm. These were the other party goers. Armani Turner is Mr. Jones' girlfriend at the time. Ms. Randolph, her friend. Robert Howard is an associate friend of Mr. Jones, who was in the car behind the Charger, which was a Hyundai. Tafa McCrae and Aaliyah were the ones in the Altima. You could see in that video that these gunmen acted with suddenness, they acted with speed and fury, and they brought overwhelming firepower. Not one shooter, not 2 shooters, but 3 to create that vortex that the evidence proves to you, with high-powered AR-style rifles and a fully automatic Glock 19, bringing all of that firepower to bear in a concentrated area easily, and rapidly, establishing not fire superiority, but fire supremacy, the evidence will show. Firing, as you saw in that last photo from the Tesla video, with absolute impunity and disregard of anyone that may be in that area. The majority of that fire you will find in this case was funneled directly into the passenger compartment of the Dodge Charger. And every single one of the rounds that were fired that night, every single one of them was dripping with the hatred, the malice, and the premeditated intent of all 5 of those conspirators. The evidence will prove to you. Mr. Jones attempted to evade the gunfire. He was leaning up against the dashboard. You may have seen in that photo, on those videos, but you'll see it during the trial. Look for it. His feet are up on the dashboard. He's leaning back. He's on his phone. The evidence will show trying to find a hotel, trying to find lodging for them. He barely has time to pull his feet down. The evidence will show he attempted to jump into the back seat, to go through and across the center console. Before he could do that, one of these rounds smashed into his chest, and that round tore through his heart. through his lungs and through the largest vein in the body, the aorta, a gigantic artery that supplies blood up and down your body. And when he turned and kind of flipped over to try to crawl into the back seat, he took 2 more rounds to his back. Those rounds ripping through not only the muscles of his back, but into his liver. These shooters, as you've just seen, leveraged, surprise, they leveraged it in this attack to make sure that Mr. Jones didn't stand a chance, to make sure he couldn't evade this attack. Not this time. This time he was going to be killed. They took full advantage of this ambush that they had planned. And you saw in that evidence the determination of these shooters, the assault team in this conspiracy. They didn't stop firing when the Charger went through that vortex. They kept firing all the way up the side of the hotel as the Dodge Charger fled. Almost a block away, that last shooter you saw in the Tesla video opening up fire, rapid fire. And as I said, firing with impunity. This was a perfect ambush spot because Mr. Jones' car was stuck. He couldn't go backwards because his girlfriend's Hyundai was behind him. To the left was a parked car next to the beams of the portico. On the other side was the hotel. A hotel. And on the other side of the wall in the glass of that hotel was high-density humanity. That didn't stop these killers. That didn't give them any pause for concern. You're going to see in the evidence impacts around that portico, numerous windows that are blown out in the front of that hotel. And not only in the lobby and in the front of the hotel, up and down the west side of that hotel, impacts. Impacts through windows that coursed through hotel rooms where people were sleeping, families. That hotel was packed with people. Parents there with their student children that were there for orientation at USF. People were there with their small children here in Tampa sightseeing. This overwhelming firepower and violence of action had an effect of confusion. Now, it wasn't confusing to the killers because they slipped away into the darkness. They were gone almost immediately. But it had that effect on the victims. Gino and Xavier. When that Charger finally comes to a halt, bullet riddled, they realize that Charles Jones is gone. And they also realize that they both have been impacted. They have both suffered gunshot wounds. They flee out of that Charger, and they flee immediately to the west into the Holiday Inn because now they don't know where these killers are. They don't know if they're there or not. So they flee and they run into the hotel. And you're going to see in the evidence, their flight leaves a thick blood trail and a very obvious blood trail. They run in, they get on an elevator, they go to the 3rd floor. When law enforcement respond, and I'll talk to you a little bit about that, the confusion that was caused, they go to the area where the Charger is. They see the blood trail. They don't know if that's victims. They don't know if that's shooters. They go into the hotel thinking that they're going to be coming face to face with shooters. They go up the elevator and they go onto the 3rd floor and they find Mr. Edwards and Mr. Norris laying on the ground bleeding. Camilla Bentley, you saw in the panic between her car, or the car she was driving, the Altima, and Miss Turner's Hyundai. One's backing up and one's going forward, and they collide going out onto McKinley. Camilla Bentley drives off, but then she turns around shortly thereafter and comes back and picks up Tafa and Aaliyah, who are inside of the hotel lobby. They then drive nearby to Advent Health, where Camilla is treated for her gunshot wound. Meanwhile, Armani Turner, the victim's girlfriend in the Hyundai, she ends up somehow on Fowler going eastbound and comes across a traffic stop being conducted by the University of South Florida Police Department, just a traffic stop. She pulls up and her and Mr. Howard get out, and they make contact with the police, who are having a hard time understanding them because they were so frantic and so upset. So they follow them. They try to follow them. They actually lose sight of them because she's traveling so fast. Meanwhile, Tampa Police Department are responding to multiple 911 calls of shooting at the hotel. An officer responding sees Miss Turner driving. She drives through the intersection of Fowler. McKinley goes right over the landscaping and into the parking lot. He follows her, not knowing who she is or what her part of this is, and they end up making contact with her. Officers end up driving down to the south end because it's brought to their attention that there are impacts and broken glass all over the south end of the home to suites where the shooting actually happened or began. And the first officer who gets there comes into the scene, and he notices all of these 9mm pistol casings laying in the scene. And he's looking at the impacts, and he's already seen the charger. And he's wondering, where are the rifle casings? Where are they? Well, you're going to hear in this evidence there were no rifle casings, even though 2 rifles were firing at a high cyclical rate in this attack. They weren't there because these conspirators modified their rifles. They put what are called brass catchers on the rifles to catch the brass, the shell casings being ejected from these AR-style rifles. They modified them, just like they modified that Glock pistol and made it fully automatic. That was confusing. That was beguiling to law enforcement, at least in the beginning, until they started obtaining the video that you've just seen. So how does this conspiracy unfold? How does all of this start? It starts with Charles Jones, Julio Foolio, you see his name on the top of this post on IG, putting out on his IG account this advertisement for June 22nd, which was a Saturday. The murders happened in the early morning hours of the 23rd, going into Sunday morning. And you see Mr. Jones in the middle, advertising he's going to be appearing, Julio Foolio, at Teasers on North Nebraska in Tampa, hosted by Kenny Kay. And he puts at the bottom, my Airbnb pool party, June 21st. And that's when he arrived here. He and party goers arrived here that Friday. They had rented an Airbnb in Holiday in Pasco County. And they ended up on Saturday night leaving the Airbnb because he had started sending out, telling people, send me messages and I'll message you back with the address. And so many people appeared that eventually the owner of the Airbnb pulled the plug and told them to get out. But you see down here at the bottom, my official birthday party, June 22nd at Club Teasers, and gives the address. So he is making it very well known when he puts this promotion out, where he's going to be, what address he's going to be at, and when he's going to be there. This is another flyer that he put up. 8 p.m. to 3 a.m., June 22nd, at Teasers. He even puts a photograph here of Tampa. My Airbnb pool party. DM me for address. And my official birthday party at Club Teasers gives the address again. So he's advertising his whereabouts. He's advertising his whereabouts. Now, Miss Andrews, the defendant, sitting right over here at counsel's table, this is a message that she sends, and you see on the top there, oh, that's red. That is her Instagram account. You will find that. You can see on the top right her registered email to that account, verified Alicia Andrews 72 at yahoo.com. She sends that this message on June 21st, that's Friday, at 10:52 UTC. That's early morning the 22nd, or earlier that day, sorry. UTC, if you're not aware of that, is Universal Time Code. It's Greenwich Mean Time. So you got to back up 4 hours. So she's sending that on the Friday night. Hey, could I book a B&B in Tampa? This is 2 days before the murder. To a Kiera Axe Marie. Hey, what's dates you need? Tomorrow, but what day do you have available? How many bedrooms? Like 2. Logistics. This is the beginning. She's trying to find lodging. Trying to find lodging for this operation. Now, a few moments later, a screenshot of an Airbnb message is documented. The message is addressed to Rashad Murphy, confirms his reservation at Lagoon Oasis 9703 Gazebo Pond in Tampa, June 22nd to June 24. And in the message of that message there from the owner of the Airbnb, our HOA requires for security purposes that all guests booking with us provide a valid ID, which he obliges and sends his valid ID. Now we go to the 22nd. This is the Saturday. Earlier in the day, before Julio Foolio is going to start appearing at clubs in Tampa. This is the residence of Sean Gaithright, one of the conspirators. That is Mr. Gaithright walking out with a large duffel bag. And Isaiah Chance walking out with bags. And you'll see they start loading that black car, which is a Chevy Impala. That is the car that goes north in the hotel complex. That is the car transporting the assault team. And they load the bags into the trunk. That BMW on the top of the video there is being driven by Mr. Chance. And you see him bringing out another large bag. They're kitting up and they're getting their gear into their transports. You'll see in the evidence that Mr. Chance ends up leaving in that Beamer. He drives and picks up his girlfriend, this defendant, Alicia Andrews, and brings her back to this residence. And then the three of them, Miss Andrews, Mr. Chance, and Mr. Gaithright, get into that Impala, and they drive here to Tampa, and they drive to the Airbnb, and there will be zero doubt about all of that, because that Impala, while it's en route, is being picked up on license plate readers. You will see in the evidence their cell phones are tracking, hitting cell towers as they travel in unison all the way down to I-75, coming across from Jacksonville and heading directly into Tampa. When he comes back, Mr. Chance brings his contribution to the assault team. The Glock pistol with the extended magazine. He tucks it into his waistband. You can see the extended magazine sticking out in the trigger guard and the slide and the dust cover of the pistol. Just a more close-up photo of it. And you can see it bulging out of the right side of his warm-up pants he's wearing. So these three, Chance, Gaithright, and the defendant, get in that Impala. And they drive. You'll find in the evidence that Gaithright in the middle and Chance, the defendant's boyfriend, are very tight. They were close friends. Mr. Chance calls Mr. Gaithright his little brother. And you'll see in the video when they are loading up, you'll see more video during this trial of Mr. Chance putting in the codes on the front door of the house that Mr. Gaithright lives at. Now, the second car, the one that I pointed out to you, the surveillance vehicle, this is a Chevy Cruze. This car is also picked up on license plate readers after law enforcement determined its involvement in this case. They go back and they find it. And if you can see in the lower left-hand corner, 7:46 p.m., June 22nd, it's on Bruce B. Downs at Tampa Palms, getting real close to where their Airbnb is. And by the way, the Airbnb they book is 1.3 miles from the murder scene. You will see in the evidence that the LPR, the license plate recognition systems that are picking up these two vehicles, show them traveling in unison, hitting on the same license plate readers at the same time, at the same locations as they travel from Jacksonville. That car was obtained by Rashad Murphy outside of the circle of ATK 1200. It was specifically located and utilized in this case as a car that would not be recognized. Now, this is the LPRs for that car, the Chevy Cruze. You can see it hitting where it hits Dolphin Drive. That's the day before in Jacksonville. On the 22nd at 6:01, Highway 441. At 1809 Highway 326, it's traveling through Gainesville. And then at 1947, 7:47 p.m., Bruce B. Downs, Tampa Palms Road, and then at 0342 Hillsborough. And then we get into the surveillance and the time before the murder. The ones at the bottom are the return. That's when they're returning to Jacksonville. This is showing you in these license plate readers the Cruze on the top and the Impala on the bottom, hitting simultaneously on the same dates, 1809, 1947, 1945, 0341, 0342, at the same exact locations. These cars are traveling in unison because they are part of a team. This is the Airbnb that they stayed at on the night of the 22nd, going into the morning of the 23rd. They didn't stay at a hotel that has a lobby with security cameras. They stayed at an Airbnb with one single Ring camera. Now, that's the front door on the right, or on the left, excuse me. You can see the Ring camera. You also can see that that lock has, like most Airbnbs, has a combination lock on it. That's the defendant when they arrive. And that day, she's the only one seen going through that door. You're going to hear in the evidence when she walks in, this is from a video, someone inside saying, "My bad." So they're already inside, but she's the only one that goes through the door that day. The other ones... The other ones, the evidence will show, this is back the back side of that same building, and down the back, and there's the back door. Must have entered, the evidence will show, through that entrance. Later that night at about 1:40, this is going now into June 23rd, 3 hours before the murder of Charles Jones, and less than an hour before they begin to hunt and stalk him at Teasers, where he's appearing. Her phone leaves the Airbnb and starts tracking by hitting off cell towers to a nearby McDonald's at 22nd and Fletcher, 2205 East Fletcher. You can see in the upper right-hand corner, if you've never seen these before, that's the cell tower. This is the area of the cell tower, or the part of the antenna that's being utilized, and it falls within that area. And you can see there Fletcher, Advent Health. That is her in the passenger seat. And there's not going to be any doubt about that in this case, because when she's later interviewed by police, she identifies herself. because you're not really going to be able to see her face, but she says, yeah, I'm in that car. That's me. You can see the driver, Davion Murphy, he's lighting a cigar. You can see a little flame. You're going to watch on this video as they proceed through this drive-through. You just saw her turn to her left. She identifies Mr. Chance as being in the back seat of that car. And that's Davion Murphy in the driver's seat. They eventually drive off, but what you're going to find in the evidence is they buy a lot of food. This is not food for one person, it's a lot of food. And that's significant because later she tells the police that they went there because she was hungry and wanted something to eat. She also tells them she doesn't know who the driver is. You can't give an explanation for how he even came to be in that car or how she came to be in that car. Now, this is outside of Teasers. As you saw, Teasers is a club that is on Nebraska, here in the city of Tampa. So, as you saw in the evidence of the shooting, the success of this conspiracy, this plot to murder, this attack hinged on the element of surprise. It absolutely hinged on that. And they leveraged the surprise that they had, catching Mr. Jones off guard. And to have that type of surprise, they had to act with a coordinated knowledge, and they needed intelligence. They needed intel. They needed real-time information. Where is he? What's his route? They needed to know exactly where he was. They needed to know his positioning, his routes of travel. And like any good operation, the key to success is intelligence, critical intel. Now, to obtain intelligence like that and to do so surreptitiously, secretly, the surveillance has to be done. In a surreptitious manner. Without that intelligence, without providing that real-time information to the assault team that's in the Impala, there would be no surprise, there would be no ambush of Mr. Jones, and this conspiracy would fail. It was that intelligence, that real-time surveillance and communication, the locations and routes that were provided by this defendant and her boyfriend, Isaiah Chance, operating alone in that Chevy Cruze, while the other three conspirators, the assault team, were in the Impala. And they were doing everything they could to keep that Impala out of the sight of Mr. Jones and his friends, because Mr. Gaithright drove that Impala. It was registered to his mother, but he drove it all the time. He was notoriously known for driving that car. This was a coordinated team effort. In order to remain secretive and to not alert the target that they were conducting surveillance, they utilized several different techniques. Number one, they parked away from the club, and they utilized disguises that you heard some about yesterday in jury selection, about COVID masks, you're going to see in this video, June of 2024, they're both wearing COVID masks. Now, interestingly, because it was suggested yesterday that there's many reasons people could wear COVID masks, it's the only time in this evidence you will ever see a mask on this defendant's face. You won't see it on her face when she returns back to Jacksonville through an Uber. You won't see it on her face any other time when she's entering into the Airbnb around her 4 co-conspirators. But they kept their distance, and you'll see that in this video, from the victim and his entourage. They attempted to blend into the background. They needed to get close enough to be able to conduct surveillance, to gather the information they needed, but not so close that they would be detected. They had to avoid that. So first they used an unrecognizable car, and then they used disguises. But what you're going to find, and remember the law and principles, she doesn't even need to be there to be part of this conspiracy or to be a principal. She's there. She drives there with Mr. Chance, and they park in the north end of the parking lot of Teasers. And she doesn't stay in the car. She gets out and she walks with him. You're going to see that. You can kind of see their images in the upper right-hand corner. This is a video. I'm going to play it in a minute. You're going to see him hand her phone to her and her put her code into the phone to open it so they could utilize it to convey what they were watching and seeing. And again, they're out in the parking lot. She was there with them in the field, shoulder to shoulder, in the thick of it, on the ground, in the action. So they're wearing these masks, and it's not just like some costume mask. Obviously, a COVID mask is not going to necessarily draw that much attention, but it is going to hide their identities. Mr. Chance has a hoodie up on his head, along with the COVID mask. They are clearly trying to disguise themselves. But again, she didn't stay in the car, she got out. And there was a reason for that. Because instead of allowing Mr. Chance to walk around in this dark parking lot with a hood on and a mask on by himself,
Objection, Your Honor. Argument.
walking.
Overruled, go ahead. Again, this is opening statement, members of the jury. It's just a chance for the lawyers to tell you what evidence they believe will be admitted in this case. But again, it is not the actual evidence, all right? Go ahead.
But instead of allowing him to walk around in that parking lot by himself, a single man with a disguise on, she went with him. Because now they would be a couple. They would fit in. They would be non-threatening. So she acted not only helping in conducting the reconnaissance.
Overruled, go ahead.
She acted as camouflage. She acted as a disguise in and of herself. Now they're a couple. Now it's not just a single person who may be seen as threatening or may draw attention. This is just a couple walking around in the parking lot in a club where a lot of people are milling about in groups. In groups. She provided that by being there in the field with them. She provided that cover and that camouflage. And she provided, obviously, a second set of eyes to watch. Both of them surveilling and watching Mr. Jones and his entourage. And then, as I just mentioned a minute ago, she provided the comms, the communication, her phone. Now, you're going to see in the evidence, Mr. Chance's phone is tracking all the way to Tampa from Jacksonville. And it's tracking at that Airbnb. It's hitting off a nearby tower, but it's her phone they're utilizing, you will find in the evidence. Now, you're going to find in this evidence that they were not utilizing the calling function of that iPhone or even its Apple text message app, the two ways that most people communicate. They're using some kind of a special application to be able to communicate that's undetected. But at some point, they have to break radio silence because the person they're communicating with, Sean Gathright, is not answering. He's not picking up his phone, so they actually send a text through the Apple text message app. Pick up your phone. And that's right around this time, just a few minutes later. You see the defendant opening the phone for Mr. Chance, and you can see their COVID masks. One is wearing the blue COVID mask that was so prevalent in 2020, 2021, and she's wearing a black one. This is Mr. Jones and his friends arriving at that club. And you can see the time there. 2:22 in the morning. That, again, is several minutes off, but it's about that time. 2:21, and there they are, and you see Mr. Chance on the phone in the parking lot at the same place. Now later, after Mr. Jones has gone into the club and been in there and done his thing in there with his friends, he's now leaving. You can see Mr. Edwards' head up there. It's 2:46 or about that time. 2:46, 59, almost 2:47. And what happens at 2:47? This car up here in the upper right, that's on that road, which is Nebraska, is pulling in to the north end of the parking lot of Teasers. This was an extremely orchestrated, well-orchestrated conspiracy, coordinated. He's walking out of the club on the other side of the club, and out of the blue, the assault team vehicle is pulling into the club. That is tight surveillance and intel. Now, in this photograph, that's 2:48. This is Mr. Jones' Charger. You can see the lights starting to light up because they're already inside the car. They're getting ready to leave. That's the Impala that has come in on the north side, gone down the west side, and is now passing in the front. Out of necessity, passing in the front. So this is just an aerial view of Teasers. You can see Nebraska over here to the right. You can see this little road here, South Castle. The defendant and her boyfriend come and they park here in the north end. They get out, they walk around, they come around this way, they stand here. The entrance is over here. So they're way down here. You kind of saw that in that photograph, which would put them down there to the west. They conduct surveillance, they walk back up here, they get back into the car, and then they drive out onto East Castle. The assault team comes in the red arrows, comes in on the north end. We just watched it. They come down this way and they go down Castle. And as you can see, before I move on, a lot of folks standing around out there. A lot of people. Potential witnesses. Now, from there, when Mr. Jones leaves with his friends in the 3 cars, they travel to another club, an after party. This is Truth 18 on Bush. The Dodge Charger, the Hyundai, and you'll see the Altima come up. Down here to the lower left, you can see some of the party, Miss Bentley, Miss Albritton, Tafa McRae in the light blue. And up on the top there where you just saw the flashing lights, it's Armani Turner and Miss Randolph getting out of the Hyundai. And there's Mr. Jones in the lower right with the red hat, very recognizable. So they go up to the second floor of this strip mall where this club is. That's Gino Norris in front walking up, his friend. And again, this is for an after party. And you'll see Mr. Jones will start live streaming with his phone. Again, advertising his location. This is from another location, and you can see the Chevy Cruze up in the top part of the screen. And now, in the top of the screen, the hooded individual, the defendant, and Mr. Chance conducting more surveillance. Walking as a couple, so they're not threatening, they don't stand out. With her phone to his ear. And now they walk back again past the club. Mr. Jones and his friends leaving. The Impala on the top of the screen. This is that's across the street. You'll find in the evidence that the victim and his entourage go down the parking lot, they do a U-turn, they come back out, they end up heading east and then doing a U-turn and going back west. The Impala just crossed the street. Now it's back up at that stop sign in the upper right-hand corner. And you'll see it'll just sit there for a while. Mr. Jones and his friends coming down the stairs. A lot of people milling about, a lot of cars. The evidence will show. And finally, they leave or start to leave. And they come back. Charger followed by the Hyundai. Followed by the Altima. On the top of the screen, Mr. Jones' Charger is going to do a U-turn and go back westbound, followed by the Hyundai and the Altima. There goes the Cruise, heading the same direction. Now, this is the intersection of McKinley. Well, let me let it play through. This is the intersection of McKinley and Fowler. This is the Home to Suites and Holiday Inn complex in the upper right-hand corner. Directly across the street is USF. There's an Embassy Suites there. That is Mr. Jones' car doing a U-turn and going back on McKinley, and you'll see it turn into the hotel complex, followed by the Hyundai and the Altima. And as you can see, there is no car visible except for those oncoming lights now coming up the northbound side. That is the Chevy Cruze. It goes eastbound. No other car on McKinley can be seen. It's not even in sight. The Chevy Cruze ends up going eastbound, then comes back westbound, turns northbound. There it is, into that parking lot. And now, several minutes later, comes the Impala, which, this is the assault team. Does a U-turn, you will see, goes southbound on McKinley, following the path of Mr. Jones and his entourage, and pulls directly into that hotel. That car wasn't anywhere to be seen when Mr. Jones and his entourage were going in there. But the Chevy Cruze was there with this defendant and Mr. Chance, providing critical intelligence to them with this defendant's phone. Once it pulls in, you'll start seeing cameras from different locations within the complex mounted on the home to suites surveillance system that'll pick up the Impala's path as it travels. So the Chevy Cruze, at one point after the Impala goes in, blows through a red light on Fowler to get over there and turn in to the hotel. By that point, the Impala is all the way around on the west side, you will find in the evidence, of the hotel, and setting up for the attack. But now the Cruze has to come, the evidence will show, to drive by and confirm where is Mr. Jones. The red marker is the Impala and its path. It comes in, it goes northbound, it goes westbound, it goes southbound around the Holiday Inn, down across the south end side of the Holiday Inn, back to the east, and then it parks. First it goes down, you can see that red arrow next to the home to suites on the west side. It kind of pulls down there and has to back up and pulls in. When the blue markers is the Chevy Cruze, when that pulls in and pulls around and does the three-point turn, you're going to see in the video evidence right here, they pass within feet of each other at the same time. And of course, the Impala never goes around or reveals itself past that point, keeping out of sight of Mr. Jones and his entourage. This is a camera mounted on the east side of the home to suites, pointing to the southeast, and it is picking up the Impala now, pulling into the complex and going northbound on the east side of the hotel. This is going to go to a camera facing north-northeast, showing it passing, still going northbound. And then it turns back to the west. This is a camera that's mounted on the north side of the home to suites that picks up the Impala as it passes and turns towards the west. And now the Impala is on the west side of the hotel. There's this pool and this patio area here that's on the west side of the hotel. Going around this way would be the portico. This is the west side of the hotel. The charging stations are right here. And you can see the Impala comes and stops. It does not go around that southern end of the home to suites. It's avoiding the southern end at this point. And here comes the Chevy Cruze passing directly past in the car that's not known by anyone, the victim. Goes to the north where the Impala is. Goes right past the Impala. Does a three-point U-turn and comes back. This is another camera picking up the Impala and the Cruze. That's on the Tesla, part of its security system. You'll see the Cruze kind of do a little turn there, back up, and come back to the south. I don't know if you saw that or not, the Cruze is turning around, but the Impala is pulling into a spot over here at the same time as it passes back by.
Objection, Your Honor. This is cumulative.
Overruled. This is opening statement. Go ahead.
So now the Cruze is coming back, doing one last pass, and now we're within seconds of the attack, the murder itself. You can see individuals at the top of the screen moving. You're going to see them run by the front of the Tesla, getting into position. There's the third shooter, Davion Murphy. And now they come around the pistol shooter, Rashad Murphy, and the shooter on the top of the screen right there is Sean Gathright. You see the collision between the Altima and the Hyundai as they're trying to get out of there. You see Mr. Murphy come out of hiding and Mr. Gathright opening fire. You'll see Mr. Gathright and Mr. Murphy running back to the north. And you saw this, there's the muzzle flashes of Mr. Davion Murphy's rifle. And you saw the Charger going to the north. That's the Charger picked up by the Tesla cameras heading north. There goes Mr. Rashad Murphy, there goes Gathright, and there's Davion Murphy. And you can kind of see the blocky image of the brass catcher on the side of that rifle. Another view from the Tesla of Davion Murphy running back to the Impala. This attack was relentless, as you saw. They weren't going to stop. They were going to make sure that they killed Mr. Jones, that he was not going to live, that they were not going to go back to Jacksonville without him dying. And you saw that relentless attitude of these defendants as they were shooting. This is the Airbnb. That's a photograph of, well, actually, this is a video. So this is the night they get there. This is Saturday, the 22nd. The defendant entering. There's no volume on this, but when she walks in, someone says, "My bad." Mr. Chance having maybe a celebratory drink. This is the next day around 2:30, 3. You can see he has to keep knocking. The person getting in that silver car is an Uber driver who they have called. That is how they returned to Jacksonville. The defendant, Mr. Chance, and Mr. Murphy this time returned to Jacksonville. Now they're unloading, bringing out all of their kit and their gear, their weapons. There's Mr. Davion Murphy. Now they're getting sloppy because it's the next day and all of the conspirators are visible. There's Mr. Murphy trying to go back in. Mr. Gathright walking out with gear. They don't they don't leave the way they came. They flee from this murder separately and in a different format. That's Mr. Gathright. He leaves independent of the others in the Impala.
Objection, Your Honor. Counsel's narrating the evidence, stuff that's not even been introduced, Your Honor.
Well, because it's opening statement. He's just telling the jury what he believes the evidence will show. So I'm going to overrule the objection.
You can see Mr. Gathright goes over to the side, to the back, and that's how they got in the day before. The evidence will show Mr. Gathright, Sean Gathright, whose house they all started at with the Impala. He leaves, but he doesn't go back to Jacksonville. Mr. Gathright drives across I-4 to Polk County, to Auburndale, to his grandmother's house, where he switches cars. He leaves his Impala at his grandmother's house, and he takes her Toyota 4Runner. And he drives that to Orlando, where he goes out that night to a club, and he posts a photograph of him drinking Don Julio tequila, which is a diss to Charles Jones. Charles Jones, Julio Foolio, was known in all of his social media to drink Don Julio. That's where the name came from. He was notorious for that. This Mr. Gathright drives over, switches cars, goes to Orlando, then he ends up in Jacksonville. That's Mr. Gathright being picked up on a flock license plate reader system. This is him coming. This is on June 22nd. You can see 739. He's in Hillsborough County. So 623, he's eastbound on I-4 at 413, eastbound on I-4. This is the Sunday after the shooting. 625, southbound Florida 559, and Fred Jones Parkway in Polk County. This is Mr. Gathright arriving at his grandmother's house in Opal Avenue in Auburndale. You're going to see him walk in. You see the Chevy Impala, the assault car, sitting in the driveway. Law enforcement go there later. They get this video of Mr. Gathright switching cars. You're going to see him wiping down the Impala before he leaves. And there he is leaving in the Forerunner, saying goodbye to his grandmother. That 626 date in the upper right-hand corner is wrong, 623. The defendant and her boyfriend, Mr. Chance, and Mr. Rashad Murphy, who had come there in the Chevy Cruze with his cousin, Davion Murphy. Now Rashad Murphy traveled with them in that Uber. There's the Uber receipt, $187, 3 hours, 25 minutes, 208 miles from Gazebo Pond to Chipperfield Lane in Jacksonville. You see the route on the left, they go up 75 and they cut through I-10. Heading up to Jacksonville. The Uber driver in this case will testify to you that he picked up 3 people at an Airbnb in Tampa and dropped them off at Sean Gaithright's house in Jacksonville. That this defendant and Mr. Chance sat in the back seat and the whole way they're on their phones and they're not wearing a mask. This is them arriving at Sean Gaithright's house. He's in Orlando or in Auburndale at his grandmother's house. Again, Miss Andrews is not wearing a mask. She's unloading along with Mr. Chance, and you're going to see Rashad Murphy here with some kind of a hat on, like a beret, with the same bags that were loaded up into the Impala. He's handing something now to the defendant. Down on the right through that crepe myrtle plant, you can see Chance in the driver's seat of the car. Mr. Murphy wearing the same jeans that he was wearing when he got arrested 2 days later in Gwinnett County, Georgia, northeast of Atlanta, driving the Chevy Cruze. He was with his girlfriend, Charmaine Steiger. They had picked up a hotel that morning, early in the morning. Law enforcement pick up the tag on flock cameras in Norcross, Georgia, and Gwinnett County. In Gwinnett County PD, you will hear from 2 officers from that agency who will tell you, the first officer being the one who arrests Mr. Murphy, that he came into contact in the hotel parking lot, pulls in behind the car, the Chevy Cruze. Mr. Murphy pops out of the driver's seat. He's yelling at him at gunpoint, "Show me your hands, show me your hands." Mr. Murphy doesn't hesitate. He takes off running. The officer chases him and tases him and knocks him down, where other officers stick guns to his head and then they cuff him, wearing the same torn up jeans or type of jeans that he's wearing in the photograph from Jacksonville 2 days earlier. That's a photograph of Mr. Rashad Murphy in a Walmart on June 21st that you will see in the evidence in Jacksonville, where he bought a burner phone and he's wearing the same clothes or clothes that are consistent in appearance to the Glock shooter, the person with the Glock switch shooter. You can see he's carrying it. You can see the similarities in the belt. You can see the similarities in the shoes. And you can see he's carrying it in his left hand, which is confirmed through investigation he is left-handed. The defendant's phone, 904-405-6748. This is a tower hit at 4:40 at the murder scene. She identifies herself as being in that Chevy Cruze. But you don't even need her own words. You can see it in this evidence. She's in that Chevy Cruze, providing the critical last minute, last second intelligence to the shooters, to the assault team, as they drive out of the parking lot. Those shooters, when they came around the corner, and the evidence will show, directed their fire directly at the passenger side of that Charger. They knew exactly where Charles Jones was. Now, this is 7/6. This is a couple weeks later. This would be what? 13 days later. This is the defendant, and she's messaging from that Ooh That's Red Instagram account with Tarnishe. He keep telling me to wait a week. That's why I've been sitting. She's talking about Mr. Chance, and she's sitting at his house. The person she's messaging, just have them bring you tomorrow. Okay, why wait a week? Down at the bottom, to make sure no police sitting around before I go there. Did you get your phone? No, the lady said, the detective said we have to wait, but if until his charge dropped. But that's weird, it was only resisting arrest. So Mr. Chance had been arrested for resisting arrest, and they had obtained during a search warrant of that house, they had obtained the defendant's phone, and this is about her getting her phone back. Ms. Tarnisha responds, oh, July 6th, well, let them keep that phone. And Ooh That's Red, this defendant texts back or messages back, yes, that's what I said, laughing my ass off, LMAO. It was a whole different one. Oh, well. Okay, now this is later, July 9th. Police here looking for you. The defendant messages back. Where are they at now? Waiting. Outside. Oh, okay. Oh, never mind. She texts back, WYM. I don't see them no more. And then the defendant, not text, messages back. They somewhere waiting, probably. So what is that all about? Why is she saying it's a whole different one? She's saying that because 2.5 days.
Overruled, go ahead.
2.5 days after this murder, after getting back to Jacksonville, you're going to find from the evidence that this defendant goes and gets a whole new phone. And she gets rid of the phone that she's had for years.
Your Honor, sidebar, please.
Okay.
Damn, I should know that. I couldn't remember. I looked it up, man.
Okay, thank you. Everyone have a seat. And Mr. Harmon, you may continue.
Please support. So the defendant disposes of her phone that she has had for years, the same phone that she and Isaiah Chance were utilizing to convey intelligence and information on the whereabouts of Charles Jones to the assault team. A phone that to this day has never been found or located. You will hear in this evidence that this defendant did everything that she could in the days after this murder to protect herself and to defend and protect the conspiracy that she was part of. On July 9th of 24, two detectives, homicide detectives, Aaron Campbell and Juan Ramos, the lead detective in this case from the Tampa Police Department's homicide unit, travel to Jacksonville and they meet with this defendant at the Jacksonville Sheriff's Office. You'll see a video recording of their interview of her. The first thing they do is read her rights, and they ensure that she understands her rights, and she says she does. And then they start interviewing her, and she immediately starts lying to the police. Lying to them.
Argument, Your Honor.
Again, Mr. Harmon, just, you need to phrase it that you believe the evidence will show. Okay? Overruled.
And the facts in this case and the evidence, that video will demonstrate to you.
Sure. We'll move, strike the word lying.
Okay.
Rephrase, Mr. Harmon.
Yes, Your Honor. The evidence will show that she makes statements to the police that are false, multiple statements. The evidence will show she lies to them over and over and over in this interview. She lies about her knowledge of these gangs. She lies about her knowledge of who Julio Foolio is. And you're going to see in the evidence that not only does she know who he is, she's known who he is for years. She has animosity towards him. You'll see that in the evidence. But she lies about simple facts that are easily rebutted. Namely, she lies about knowing this guy, Sean Gathright, the individual whose house she left from to come to Tampa, the individual who was driving the Chevy Impala that she was sitting in for almost 3.5 hours driving to Tampa on the 22nd, the individual who was best friends with her boyfriend, Isaiah Chance. She's shown that photograph. I don't know who that is. I don't know who that is. And you will see in the evidence that these lies are nonchalant lies. Her demeanor with these homicide detectives. They show her video. They show her all this video. And in the middle of this litany of lies that's coming out of her mouth, there's a couple little kernels of truth. Namely, she identifies herself in the teaser's video in the parking lot with Isaiah Chance wearing the mask. She identifies herself in the Truth 18 video. She identifies herself, like I said earlier, at the McDonald's in the Chevy Cruze. But she doesn't know who Davion Murphy is. They ask her, well, who is this guy? How did he end up driving this car that you're in? I don't know. Now, on the 26th of June, this is in Jacksonville. This is Jacksonville Sheriff's Office. They pull that 4Runner over, Sean Gathright driving, and they pull him over for a traffic infraction. They get him out of the car, and they end up searching that 4Runner. And inside of the 4Runner, they find several items. Glock magazines, a Glock extended magazine, components for AR-15 rifles including a brace, magazine holders, ammunition, and a box full of empty .223 and 5.56 shell casings. Now, you're going to hear in the evidence, if you're not already aware of this, that a 5.56 rifle, an AR rifle, can shoot .223 ammunition. They're almost interchangeable. And there's multiple empty casings in this box. They also find these two boxes, each containing 50 rounds of 9mm ammunition. Max Tech. On the top of the cartridge casings, on the head stamp, where the primer is MXT for Max Tech. That is the exact same ammunition as the 9mm shell casings found in the crime scene. All of those shell casings found, and there was 31 of them found outside of the home to suites. They're all Max Tech, all the same ammunition, the same as these is ammunition found in Mr. Gathwright's vehicle. And I'll come back to that. These shell casings, 223 5.56, those shell casings are later provided to the Florida Department of Law Enforcement, which is a statewide agency here in the state of Florida that maintains crime laboratories throughout the state. We have one right here, a regional laboratory here in Tampa, and there's one in Jacksonville, and they're both involved in this case. And they are submitted to the firearms section, to firearms analysts who analyze those shell casings, comparing them to the shell casings from the October 7th attack on Charles Jones, where he was shot in the leg. And they are fired from the same weapon. The analyst will tell you they were fired from the same weapon. She will tell you that was shell casings. She examines them microscopically and compares them and looks at markings that are left on the shell casings, markings that are left by the breech face of the gun, by the extractor ejectors inside the firearms, and by primer shear, as it's called, when the primer goes off. And by primer, talking about this little dot here in the middle of the gun where the firing pin hits, causing a very teeny explosion that then ignites the gunpowder inside the shell casing, the gunpowder that sits behind the bullet and pushes it out. She examines all of those areas, and she came to the conclusion those were fired from the same gun that was used to attack Charles Jones on October 7th in Jacksonville. Sean Gathwright's house. There's the forerunner. A search warrant is executed on that house in the days after this murder. And one of the things they find in the sink in water is all this torn up packaging. And when they start looking at the packaging, it's all firearm related. That is a Sig Sauer Romeo 05 package. These are Magpul, which is a firearms manufacturer of components for AR-15 rifles, also manufacturer of magazines. They find basically an arsenal within this house. And what they determined from their search is that Sean Gathwright, was the weapons man on this team. He is the man that provided the AR-15 5.56 caliber rifle and the AR-15 300 blackout rifle in this attack. There are ammo boxes full of 300 blackout and 5.56 ammunition. In this safe, they find multiple weapons to include rifles and brass catchers. That is a brass catcher. It has a wire structure with netting or mesh, and it's designed to be fitted onto a rifle where when the shell is ejecting, like I said earlier, the casings remain in that mesh. And in this mesh, this detached brass catcher, they found 2 9mm shell casings that somehow worked their way in there. Those shell casings are Max Tech ammunition, the same kind of ammunition that's found in this defendant's, Mr. Gathwright's forerunner. Those shell casings are submitted to the Florida Department of Law Enforcement, to the firearms section for analysis, and they're analyzed, and they're compared to a shell casing from our crime scene, and the firearms examiner will tell you they were fired from the same weapon, a Glock firearm. That weapon was not recovered in this case. It was never found. They find this rifle, 300 blackout, with the brass catcher attached. And when I say brass, brass, if you don't already know, and you'll hear in the evidence, is a common term for shell casings. Once they're fired and they come out of the gun, it's called brass. It's just a common way of referring to those. And so the brass catcher is still attached to this firearm. And you see it on the opposite side. This firearm is also located, this 5.56, and that brass catcher, as I said, had been detached already. There are multiple magazines located, and loaded magazines. Those are loaded with 300 blackout 30 caliber rounds. Ammo boxes, this is back at the sheriff's office in Jacksonville, where this ammunition was inventoried after collection from Mr. Gathwright's house. And you can see all of the different type of ammunition he had. Now, July 27th, that individual sitting in the rain, kneeling there at gunpoint, is Isaiah Chance. Officers arrived at that residence, his residence, and placed him under arrest for the murder in this case. And there is the defendant being brought out of the same house where she was with Mr. Chance. Davion Murphy. This is after his arrest months later, after being dragged out of an apartment in Jacksonville, Florida. Now, why am I showing you this photograph of the defendant? This is the defendant. This is Miss Andrews. In the interview with the officers, in the very beginning of the interview, the officers are asking her about Isaiah Chance, her boyfriend. Isaiah Chance's street name, gang name, and social media name is Gudda, or Gudda Man, Gudda, and they're calling him Gudda. And this is the defendant's response in the interview. Why are you calling him that? Why are you calling him Gudda? Like, you're idiots. Why are you calling him Gudda? Saying those words.
Okay, again, Mr. Harmon, just keep your statements
And
as
it's a
far as...
misstatement of the evidence, Your Honor.
Pardon me?
And it's a misstatement of the evidence.
Okay, well, when the jury, again, ladies and gentlemen of the jury, as I told you, what the attorneys say in the opening statement is not the evidence, and you're not to consider it as such. They're just telling you what they believe the evidence will be. You will be the ultimate decision makers regarding the evidence and any weight that it carries, okay? All right, go ahead.
The evidence will show that as those words are leaving her lips, tattooed on her body, underneath her clothes, is the name Gudda. Not only on her chest, but on her neck. Over the next week, the state of Florida, through the evidence that we will present to you, we will drag this conspiracy out of the darkness of the early morning hours. We will drag it into this courtroom for everyone to see, for everyone to know its evil and sinister and murderous nature. It will be exposed, and there will be no masks for this defendant to wear to hide from the state's evidence. The truth in this case, the truth will be clear, crystal clear, at the end of the state's case. There will be no Uber drivers waiting to whisk Miss Andrews away to avoid your verdict when you find her guilty. Guilty of conspiring with these four men, and guilty as a principal to first-degree murder. And folks, the state's evidence will let every single one of you know deep in your hearts that that is the truth, that she conspired in this wicked and despicably evil, cold-blooded murder. That she followed this man, watched him, encouraged her co-defendants by her actions and words, tried to find lodging, that she assisted in every way, and then, after the fact, did everything she could to defend this conspiracy. At the end of this case, there will be no doubts in your minds. There were discussions in the last couple of days about proof beyond a reasonable doubt. The state's case will prove to you clearly, beyond any doubt, that this defendant, Alicia Andrews, as she sits over here in this courtroom right now, is guilty of conspiring and committing first-degree murder.
All right, defense, do you wish to make an opening statement at this time?
All right, we're going to skip defense opening and we're going to go straight to her testimony because her testimony is like 3.5 hours. So let's get over. So that was the state's opening. It's going to be the same as tomorrow, probably, or I shouldn't say the same, similar. So that is Scott Harmon, is his name, along with Michelle Doherty and Ann Ismer. Those are the three lawyers on the state side. So now we're going to, I wanted to play that because I wanted to hear how it compares to tomorrow. So when we hear tomorrow's opening, it's going to be fresh in our minds and in our ears. Hopefully he won't say Seth Gaithright. He'll say Sean. Hopefully he'll get his name right, which I think he will. Okay, so now we're going to fast forward to Alicia taking the stand. And really appreciate you guys joining us. If you haven't hit the like button, please take a moment to do so. If you hear my voice, take a moment and hit the like button. And let's watch Alicia on the stand here.
Okay, thank you. Okay, very good. Let's bring the jury.
Yes, Judge.
All right, Ms. Andrews, I need you to raise your right hand to be sworn.
Can you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes. Okay, very good. You may proceed.
Miss Andrews, can you please turn to the jury and introduce yourself by name?
My name is Alicia Andrews.
All right, Miss Andrews, you're charged with 2 counts. One is first-degree murder, and the other is conspiracy to commit first-degree murder. Did you know that Charles Jones was going to die on June 23rd of 2024?
No, I did not.
Did you have any involvement in Charles Jones's murder?
No, I did not.
Did anyone tell you anything about a plot to kill Charles Jones when you went to Tampa?
No, they didn't.
I want to take a step back. How old are you, Miss Andrews?
22.
And at the time of this incident, how old were you?
21.
Did you go to high school?
Yes.
Which high schools did you go to?
I went to Raines High School and Andrew Jackson.
How long did you go to Raines High School for?
I think it was like a year, I believe.
It was a year? Do you know what year that was?
I think maybe 2017, 2018,
All right.
one of those.
And on what side of town is Raines?
I think that's considered the north.
That's the north side?
I think so.
All right. And did you live on the north side at that time?
I'm like on the north/east.
Okay. And why were you going to Raines?
My sister was going there, so I wanted to go to a school where I knew somebody.
When you were at Raines High School, did you hear of a shooting that happened at Raines High School?
Yes.
All right. Was this shooting big news at the high school?
Yes.
Why?
I mean, everybody talked, and it was at a football game, so police just came. It was all over the media.
And was it made known to you who was involved in the shooting?
Yes.
All right. Who do you know was involved in the shooting?
I just would always hear the name Robert Howard, but I didn't really know him.
You didn't know him personally?
No, I would see him though, but I didn't know him.
Where would you see him at?
He would be at the football games or like the Christmas tournaments, and they would have like these track meets that everybody go to called Bob Hayes.
Okay. Did you leave Raines High School to go to another school?
Yes.
Why did you leave that school?
I mean, it just really wasn't for me, and my sister had already graduated by that time, so.
All right. Where did you end up going?
Andrew Jackson High School.
And where is that school?
I don't know what side of town it's supposed to be. North, I guess.
All right. When you left Raines High School, did you have any friends still at Raines High School?
Yes.
Did you still communicate with those friends from Raines?
Yes.
Did you also have friends that went to the new school?
Yeah.
And do you maintain any friendships from either of those schools today?
Yes.
When did you meet Isaiah Chance?
It was like towards the end of 2021.
Towards the end of 2021?
Yeah, I think it was.
Well, tell me this. Were you in high school when you met him?
Yes.
And when did you graduate high school?
May 2021. I don't remember the date though, but
Okay.
it was May.
All right. So, when did you start to date Isaiah Chance?
I would consider that like in the summertime.
Summer of after you graduated?
Yes.
All right. Did you know him before? Did you know him before you started to date him?
I knew of him.
All right. What did you know of him?
He had a sister that I was close with, well, not close with, but like cool with at Raines High School.
Okay. And when you started dating in May or after May of 2021, how long did that relationship last for?
It wasn't very long. We were on and off.
Did you ever live with Isaiah Chance?
No.
Where did you live?
I stayed with my parents.
All right. And did Isaiah Chance ever come over to your parents' home?
He never been inside, but he's picked me up.
All right. Did you, at any point in time, ever stay the night at Isaiah Chance's home?
Yes.
Who did he live with?
His mom and family members, like sisters.
All right. How long would you stay, just generally, how long, or typically, how long would you stay at Isaiah Chance's house?
Sometimes it would be a week or two, or days. It depends, like, what I'm doing.
All right. Did you have a job?
It depends what year. I did have a job.
Well, what jobs did you have?
I worked at Amazon. I was a substitute teacher. I had a lot of jobs. Ulta Beauty, worked at Victoria's Secret. What else? I think that was all of them.
All right. When you were growing up at Raines or the Andrew Jackson High School, did you see any of the gang activity or the gang back and forth while you were in high school?
I saw it online.
All right. What types of things did you see online?
They would go on Instagram, like, and go live, and everybody would be sitting it to everybody, like, are y'all watching? Like, we're young, we don't have nothing to do, so we would be kind of tuned in, just watching.
All right. And when you say they are going live, who is they?
The victim in this case, he would go live, and I guess the other people that didn't like him.
All right. And who are the other people that didn't like him at that time?
The individual that goes by Yungeen Ace.
Okay. So they would go back and forth on social media?
Yeah, along with other people.
Was this popular conversation in school?
Yes.
And would people send these lives and these different things to each other?
Yes.
Would people text about these things?
Yes.
And would people talk about these things?
Yes.
Would they talk about it at school, like at lunch?
Yes.
Would they talk about it during practice and for sports?
Yes.
Would they talk about it at football games?
Yeah.
All right. This was common knowledge to everyone in the schools?
Yeah.
Why?
I mean, again, we were young, so everything that's going on in the media, everybody just talked about it.
Did you have any personal connection to Robert Howard?
No.
What about to Spaz?
No.
All right. Did you know Spaz?
No, I heard of him.
All right. And when I say Spaz, I'm referring to Gerard Adams.
Yeah, I don't know him. I heard of him.
Okay. Did you have any personal connection to this individual, Bibby?
No.
All right. Did you know of him?
Yes.
And how did you know of these individuals? Spaz, Bibby, how did you know of these people?
When one individual died, some people would post it, so I would see it.
Okay. When you started to date Isaiah Chance, how was your relationship with him?
In the beginning, it was good, I would say. But then he changed over time. I mean, once we got comfortable with each other.
What did he change? What changed about him?
He started to be a little more controlling. Like as I got older and I would want to go out, he didn't like that.
In what ways was he controlling?
Like he would tell me what to post, what not to post, or if he didn't want me to take something down, or don't wear this, don't wear that, like little stuff like that.
And when he was having these controlling ways, would you listen to him?
Yes.
Why?
I mean, I didn't know no better at the time.
Other than just having controlling ways, did Isaiah Chance ever put his hands on you?
Yes.
How many times?
I wouldn't say I was counting, but it's been a few times.
Do you remember the first time that it happened?
Yes.
When was the first time that it happened?
Back in like 2021 at his house.
What happened in that situation?
We were arguing over the phone. Like he wanted my phone and I wouldn't give it to him. And that was the first time he ever like snatched it and he ended up hitting me.
Hit you how?
With a closed fist. And I was kind of like just blocking myself and saying stop.
All right. Were you standing up? Were you on the ground?
I was on the bed, the edge of the bed.
All right. And how did it stop?
His mom came in. He was telling him like to back up off me. And he was like, no, she good. And he closed the door.
All right. That was the first time?
Yes.
Did you have any bruises?
Yes.
What happened? Did you go home when you had the bruises?
No, he wouldn't let me go home.
Who would not let you go home?
Isaiah.
Why would he not let you go home?
I think it was because he didn't want my parents to see it, and he probably thought they would make a big deal, which they would, so.
So, were you, I guess, hiding the bruise that you had?
At the time, yes.
Did you eventually go home?
Yes.
Did you tell anybody what happened?
Yes, my friend.
Who?
Jewel.
All right. All right. Was there any other times that you can remember Isaiah Chance putting his hands on you?
It was a few more times after that. I don't remember the specific date, but I know it was around my birthday in 2024. And then it was another time in 2022. It was a few times.
All right. Did he ever, outside of your house and in the car, did he ever put his hands on you?
Yes.
Can you tell me about that situation?
Well, the one in the car was before we went to Tampa. It was a couple of days before that. Somebody called me and I ended up telling him it was someone that he didn't want me to talk to, like one of my guy friends. And he assumed the guy liked me, so he got mad. And he came to my house, insisting that I come outside. So, I go outside, I look in the car, I'm like, what? He said, get in the car. I said, for what? And then he gave me a look, so I got in the car.
When you got in the car, what happened?
He drove me to like a park, and then he stopped and he was like, "Let me see your phone." And I said no. But he ended up grabbing it. He was telling me to unlock it, and I wouldn't unlock it. And that's when he repeatedly hit me to unlock the phone.
How did he hit you?
Like on the side of my face. So if I'm in the passenger seat, somebody hits you from the side, you're hitting the side of the seatbelt thing. It was like on the side. I don't know what they call that.
Where the seatbelt comes out of?
Yeah, like
where it retracts?
Yeah, my head was hitting on that.
All right. And how long did that last for?
I believe we were sitting there for like 20 minutes because I get frustrated and I just start kicking and hitting back, and then he told me to stop.
All right. After that, did you go back home?
Later on that day I did. Well, once we sit there for a minute, he ended up talking to me, apologizes, then we go out to eat.
All right. Was that his way of making up to you?
Yes.
All right. Did that happen more times than one?
Yes.
I'm going to show you something, and I want you to tell me if you recognize it. Do you recognize what you see?
Yes.
How do you recognize it?
It's me sending my friend a picture of my...
Just tell me how you recognize it. Don't tell me what it is.
Well, I see my face.
All right. And did you take these photographs?
Yes.
All right. Is it a fair and accurate depiction of the photograph you took?
Yes.
All right. At this time, defense would move what's defense exhibit 7 into evidence?
Any objection? No objection, Judge. Admitted.
I apologize, Judge. The computer is frozen. All right. Miss Andrews, what is this photograph of?
My face.
All right. And why? What is on your face?
That's when he bruised my eye.
Who is he?
Isaiah.
Do you remember when this was? Time frame?
I don't remember the exact date, but I recall sending her a picture though.
Who is her?
I think that's Jewel.
All right. Now, why did you send this picture?
Because I was already telling her about the other incidents, so when I sent it to her, I'm like I'm fed up, kind of like just telling her like, what do I do?
All right. All right. What is this photograph?
Of my eye that he bruised.
Exhibit
Same exhibit.
for the record, correct?
Yes, same
Are they
exhibit.
marked, are they different photos within one exhibit?
It's a composite exhibit, yes.
So do you have them identified for the record?
There'll be exhibit 7. It'll be A through D.
So what is this? You showed her A initially?
Well, the first one was D.
And what is this one?
This is going to be B.
Okay, thank you. Okay, go ahead.
What is this a photo of?
Of my eye that he bruised.
Is this a separate incident or the same?
It's the same day.
All right. And why did you take another picture?
I was just showing her closely.
All right. Showing 7A. What is this a photograph of?
One of my phones.
All right. What is the phone showing? What are you doing in this photograph?
Showing her that the screen is cracked.
Who is her?
I believe I sent it to Jewel.
And how did the screen get cracked?
He broke it.
How?
I think he threw it to the ground.
All right.
I don't remember exactly how he threw it, but
And while that exhibit is still up, hold on. How often or how many times did Isaiah Chance break your phone?
from 2021 to 2024, maybe 4 times.
Was it always the same way?
No.
What other ways did he break your phones?
I think one time he threw it to the wall, like repeatedly threw it to the wall over and over so that it wouldn't turn back on. And then the very last time he bent it some kind of way. So like this, I don't know what they call it on the iPhone. It had like a dent in it. I don't know how he broke it though, like what kind of way he broke it.
All right. And when he would break these phones, who would get them fixed?
My parents, or if I had a job, I'll get it fixed. Isaiah only ever paid for one to get fixed.
What is this a photograph of?
Showing her my eye.
Who is her?
Jewel.
And again, is this a new part
Yes,
of the
this is 7, exhibit 7, and this is going to be C.
Okay, thank you.
So this goes to that. Let me see that.
Your Honor, I had a
Jack, may we approach?
Yes.
So just a quick reminder, trial starts tomorrow for the four guys. We're just rewatching. We did a bunch of pretrial deep dives over the past couple of days, and we're just watching Alicia's testimony now, just to kind of wrap our heads around what she says, or what she said. This happened back in October. So again, just watching Alicia saying it's a defense team is going to be different, but the state prosecutors are the same. So again, just watching Alicia. We watched opening statements, and now we're watching her testimony. But we've been doing deep dives all week. Trial starts tomorrow for the four guys.
All right, Ms. Andrews, I'm going to show you something. I want you to tell me if you recognize it. Do you recognize what this is?
Yes.
All right. What is it? Without telling me what it says.
A message from Isaiah.
And are these messages that you see here, are they accurate representations of the messages that you received from Isaiah?
Yes.
How do you recognize these messages?
They're messages that he sent me, I think, on iMessage.
At this time, the defense will move Exhibit 8 into evidence.
State, you renew your objection?
Yes, Your Honor.
Okay, same ruling. Overruled. You can admit it.
All right. Do you recognize this email address here at the top?
Yes.
All right. And whose email address is that?
Isaiah.
And do you see where it says message sender?
Yes.
All right. Do you see the body of the message here?
Yes.
What does it say?
He said, "Stop fucking posting yourself, goddamn."
All right. Do you remember this message?
Yes.
This message went to who?
Me.
Do you see this second message here?
Yes.
What does the message say?
He said, "The fuck you keep advertising yourself for?"
All right. And this is from Isaiah Chance to you?
Yes.
What was he talking about when he says you keep advertising yourself?
I don't remember what picture I posted, but I posted a picture on Instagram that he didn't like.
Now, this third message, what does it say?
I said, "I'm not advertising myself."
Can you read the fourth message?
It said, "Just say deleted."
That message comes from... You know if you sent that or did he send that to you?
It say his name at the top, so I think he sent it.
The fifth message here?
He said deleted.
When he says delete it, what is he talking about?
He told me to take the picture down.
And what did you respond and say?
Okay.
Why did you take the photograph down?
I didn't really have a reason. I don't like to cause conflict between us, so I just took it down.
And that was in October of 2023?
Yes.
Judge, may we approach?
Yes?
When you said earlier that you just didn't want to have any disagreements between you and Isaiah Chance, if you do get him upset, what typically happens?
He'll probably end up hitting me or fighting me or something. It depends if I'm around him.
It depends what?
If I'm around him at the time.
All right. Was Isaiah Chance a jealous person?
Yes.
And did he get angry when he was jealous?
Yeah.
Is there a reason why you stayed with him throughout the abuse and throughout him being angry and jealous with you, of you?
It was kind of like he was manipulating me. Like, I did want to leave, but I didn't want to leave. And I mean, you really want to understand unless you're in the situation. It's not that easy to leave all the time. And then I'm young, and he'll tell me, you know, nobody wants you, nobody gonna want you, and like he'll make statements like that, and I'll kind of just like, okay, so I settled.
During the interrogation, you make a statement about you being pregnant before. Do you remember that statement?
Yes.
Have you been pregnant before your most recent pregnancy?
Yes.
All right. And what happened during that pregnancy?
Your Honor, I'm going to object as to relevancy.
Sustain the objection.
Do I answer it?
No.
I sustain the objection. It means you cannot answer, okay?
Okay.
All right. I want to talk about this trip. Well, let me first talk about the Airbnb. At a certain point in time, did you send an Instagram message to someone inquiring about an Airbnb?
Yes.
That Instagram message was sent from your phone?
Yes.
Isaiah Chance was not using your phone at that time.
No.
Why did you send that message?
He called me and said, can you text the girl that do the B&Bs? Let me know what she got available.
All right. Did you know why you were asking for the Airbnb at that point in time?
No.
When you asked the individual for the Airbnb, for the inquiry about the Airbnb, did they respond to you?
Yes.
Did they respond immediately?
I think the first message was fast, but the last message, she took a minute.
All right. Did you ultimately book an Airbnb through this individual?
No.
Was this individual that you sent the message to, was that Rashad Murphy's girlfriend?
No.
All right. Did that person that you sent that message to, do you know if she even knew Rashad Murphy?
No, but I knew her, so I knew she had he told me something, he was like, how do you know it's not Rashad's girlfriend? But I knew the girl, so...
Hold on. When you say he, who is he? You talking about the officer?
Yeah, the detective.
All right. We'll get to the interrogation. But the question is, did you know, or do you know whether this woman was Rashad Murphy's girlfriend?
No.
All right. All right. Did you ultimately book an Airbnb in this case?
No.
When the Airbnb, did somebody book it?
Yes.
Did anyone tell you when someone else booked the Airbnb?
When I called him back about the message I got, he told me, oh, it's already booked, it's okay.
When you say you called him back, who is him?
Isaiah.
All right. And so when you called Isaiah Chance back to tell him that you received a message back from Instagram, the woman on Instagram, he told you what?
He said it's already booked, it's okay.
All right. So someone else booked the Airbnb?
Yes.
Do you know who booked it?
At the time, I didn't know.
All right. Did he tell you that Rashad Murphy booked it?
No.
All right. Did you ask any questions about it?
No.
All right. At what point did you figure out that Isaiah Chance was going to Tampa, Florida?
That's the next day I called him on the 22nd.
All right. This is the day of?
Yeah, the day we
trip
leave.
down?
Yes.
All right. And how did you learn that he was going to Tampa?
I called him early that day like we always do, and I'm like, what you doing today? He said, I might be going out of town. I said, I wanted to go.
Did he tell you what he was going out of town for?
No.
Why did you want to go out of town with him?
Well, we were supposed to go to Atlanta, and we ended up fighting, so I didn't go.
You said you were supposed to go to Atlanta, and what happened?
We ended up fighting, so I didn't go.
All right. When were you supposed to go to Atlanta?
It was beginning of June.
All right. So, did he tell you where he was going?
What,
the city?
Yeah.
All right. So, what did you know about the trip?
Nothing much.
All right. Did you know who was going?
No, at the time he just said me and him. He told me to pack my stuff.
Where were you at when you had that conversation with him?
I'm at home.
Do you know where he was?
No.
Did you come to find out where he was?
Yes.
All right. Where was he at?
He referred to him as his little brother. He said his little brother's house.
All right. And how did you find out that he was at his little brother's house?
When I arrive and get in the car with him, he drives to someone's house, and I said, why are we here? He said, we're going to rob my little brother.
All right. When you say little brother, who is that? You know
Sean Gathright.
Okay. And so you get to Sean Gathwright's house by Isaiah Chance picking you up and taking you there?
Yes.
All right. Where did Isaiah Chance pick you up from?
It was a club that we met at.
All right. Did somebody take you to the club?
Yes, my sister.
All right. Is that because you do not drive?
Yes.
All right. So after your sister takes you to a club, were you actually partying at this club?
No.
Is it just a drop-off location?
Yeah, it was closer, and he told me to just meet him there.
All right. So Isaiah Chance picks you up from this club, and you go where?
To his little brother's house.
All right. When you get there, what do?
I just sit in the car.
You were waiting?
Yes.
Was Sean Gathright there when you arrived?
No.
All right. Was there a car in the driveway when you got there?
Yes.
Do you remember from the video, do you remember what color car was in the driveway?
It was a white car.
All right. And the brother was not there yet?
No.
When the brother got there, did you communicate with the brother at all?
No.
All right. Is there a reason why you don't communicate with individuals that Isaiah Chance is friends with?
Well, he tells me how to talk to his friends, so I just got in the car.
Why does Isaiah Chance tell you not to talk to his friends?
Because he'll think I like them or something like that. He just makes up stuff.
All right. So you get in another vehicle, and where do you sit in the vehicle?
Back seat.
And what happens next?
We drive off to a gas station.
What happens at the gas station?
I get out and get snacks.
All right. And do you know if there's anyone at the gas station? Anyone else?
No.
All right. What happens after you get snacks from that gas station? You all go to Tampa?
No, they drove to some, I guess, apartments.
Apartment complex?
Yes.
And what happens at the apartment complex?
They get out of the car and they dap two bigger guys up, but they had the windows outside.
So let me back up. You said they. Who is they get out the car?
Sean and Isaiah get out of the car and they dap two bigger guys, two dark-skinned guys.
And explain what you mean by dap.
Like shaking hands, acknowledging each other.
What happens after they get out, they being Isaiah Chance and Sean Gathright, after they get out and they acknowledge these other two individuals?
They get back in the car and drive off.
Who's they?
Sean, he drives off because he's driving.
All right. So what happens after you all leave this apartment complex?
We head to Tampa.
And are there any stops on the way to Tampa?
Another gas station.
What happens at this second gas station?
They get out of the car, they're talking, but I'm still in the car.
All right. Who's they?
Sean and Isaiah get out of the car.
All right. And they're talking amongst each other?
Yes.
All right. Do you know what they're saying?
No.
All right. Do you ask what they're saying?
No.
At the time, do you care what they're saying?
No.
All right. After you go to this second gas station, what happens?
Then we go to the Airbnb.
All right. When you arrive at the Airbnb, who all is in your vehicle?
Just Zay, me, and Sean.
Who gets out first?
I think they both got out at the same time.
All right. And were you paying attention to where they went when they got out of the car?
No.
What were you doing as they were getting out of the car?
I was on TikTok.
On your phone?
Yes.
And when you got out of the car, where were they at?
I didn't see them no more.
All right. When you didn't see them, what did you do?
I mean, I did what he told me to do. When he got out of the car, he said, when you're ready, it's the first door.
All right. So did you go to the door?
Yeah, I just knocked.
And what happened when you knocked? Initially?
He didn't open it.
Did you use an access code to get into the Airbnb?
No.
Did you have an access code?
No.
Do you have the Airbnb app on your phone, or did you have it on your phone?
No.
When you arrived, are you on your phone?
Yes.
Do you call anyone?
I was calling Isaiah to see if he's gonna open the door.
Okay. Did you see a Ring camera in front of the door?
Not at first.
All right. Do you care if there was a Ring camera in front of the door?
No.
Why not?
I mean, it's a camera.
When you get to the door and you get inside, how are you able to actually get inside?
Isaiah lets me in.
All right. And when you get inside, is it just yourself, Isaiah, and Sean Gathright inside?
Yes.
And where do you go?
Upstairs.
Are there any rooms downstairs?
No.
And upstairs, what's upstairs?
2 beds in the bathroom. 2 bedrooms in the bathroom on it.
Did you choose to occupy one of the bedrooms?
Yes.
All right. What did you do while you were sitting in the Airbnb from the time you got? Well, let me ask you this: did you get there around 8 a.m. or 8 p.m.?
Yes.
And what did you do for the next few hours?
I was in the bed.
What were you doing in the bed?
Scrolling through Netflix, trying to find a show. Then I was on my phone a little bit.
All right. At any point in time while you were upstairs, did Isaiah Chance and Sean Gathright leave?
Yes.
Do you know where they went?
No, Isaiah told me, be right back real quick. He left.
All right. Did you ask him where he was going?
No.
Did they include you in their travel plans?
No.
All right. At the time, were you hungry?
Yes.
All right. Were you looking for something to eat?
Yes, on DoorDash.
What were you looking for?
Some Pizza Hut.
All right. And is that the Instagram post that we've seen throughout the trial?
Yes.
All right. Did you ultimately order Pizza Hut?
No, they were high.
When you say they were high, what do you mean by that?
I was trying to get like 10-piece wings and a small pizza. I didn't want to buy it. It's too high.
Okay. Would you expect Isaiah to be buying food for you while you're away?
Yes.
When you didn't purchase the Pizza Hut, what did you decide to do?
I texted him and said I was hungry.
And then after you text him, what happened?
I think he said, I don't even think he responded. I think he just came back and asked me, it's like, what do you want to eat?
Did you make a decision about what you wanted to eat?
I said, I'll get McDonald's.
Okay. And what happens next?
He told me to hold on. He went downstairs.
And what happened?
He comes back and say, come on.
And what did you do?
I mean, I got up and went.
Who did you get in any particular car at that time?
Yes, it was the gray car.
All right. And did he tell you to get inside of that car?
Yes.
And you got into which seat?
The passenger seat.
The front or back passenger?
Hey, what you mean front or back?
Front seat or back seat?
Oh, the front seat.
Okay. And when you got in the vehicle, who was in the vehicle?
Isaiah comes outside and Davion.
And who sat where?
Davion gets in the front seat and Zay gets in the back seat.
Why did Davion get in the front seat as opposed to Isaiah Chance?
I mean, I wouldn't know what they said before they came out, so I don't know why he got in the front. But I assumed it was because he wanted food too, so he came.
At the time, did you know Davion Murphy?
No.
Had you ever seen him before?
No.
And when he got in the car, did he say anything to you?
No.
All right. Did you think that it was weird that he was sitting in the front seat next to you?
Yeah, I didn't know he was going.
Do you ultimately make it to McDonald's?
Yes.
When you get to McDonald's, do you order food?
Yes.
And who pays for the food?
I think it was Isaiah. I think he paid half and I did the other half. I can't remember.
There's a point in the McDonald's video that we've seen where Davion Murphy is lighting some sort of cigarette or blunt. Do you remember that?
Yes.
Do you remember, not just the video, but do you remember the actual event in the car?
Yeah, I remember.
And when he was doing that, what did you do?
Nothing.
Why did you do nothing?
I mean, I don't know him. It's his car. And I'm not really I don't talk much, so I was kind of scared to say something.
When you left McDonald's, well, you did leave McDonald's at some point, right?
Yes.
All right. And then at some point, does Davion get out of that car?
Yes.
And is it just you and Chance?
Yes.
Do you know, at the time, did you know an individual named Kyla Enright?
No.
Did you know that Sean Gathright was talking to an individual named Kyla Enright?
No, I did not.
Did you know that Sean Gathright was texting an individual named Kyla Enright?
No.
Right. At this time, had anybody told you anything about Julio Foolio?
No.
Were you searching Julio Foolio's Instagram account that night?
No.
Did you even know he was going to be in Tampa?
No, I did not.
After you leave McDonald's, do you go to a club?
Yes.
Do you know the name of this club?
I mean, I know the name now. It's Teasers.
At the time, did you know the name?
No.
Why did you not know the name at the time?
I mean, it was kind of irrelevant. I didn't remember. We didn't go in it, so.
You did not go in the club, but why did you go there?
We're thinking about going in there.
All right. Whose idea was it to go to this place?
Isaiah.
And did you follow his idea?
Yeah, he said he was taking me out.
Did you have any reason to think that he was doing anything wrong or illegal?
At the time, no.
When you got to this club, did you all park?
Yes.
And where did you park?
I believe it was the back of the parking lot.
Was that the only space available at the time?
Yes.
And were you driving?
No.
All right. Well, let me ask you this. At any point in time during that night, did you drive the vehicle?
No.
When you get out of the vehicle, what happens?
We start walking, then he stops me and say, "Let me see your phone."
Do you give him the phone?
Yes.
At the time, do you think anything of it?
No. I mean, he always has it.
Did he ask you for the code to get in?
Yeah.
And did you give him the code?
Yeah, I did.
All right. Do you know what he did with the phone?
He tried to make a call, I guess. He had it up, but I didn't hear what he was saying.
All right, so let me talk to you about this. Is it weird or strange, anything out of the ordinary, for Isaiah Chance to use your phone to make phone calls?
No.
Had he done that before in the past?
Yes.
Had he spoken to Robert Howard using your phone before?
Yes.
Had he spoken to other individuals using your phone before?
Yes.
Do you know why?
No, but I assumed it's maybe because he don't want him to have his number.
All right. When he would speak to individuals on your phone, would he always speak around you?
No.
Would he sometimes leave the room?
Yeah.
All right. And do you question him about why he's using your phone or why he's leaving the room?
No.
Why not?
I mean, it wasn't really a big deal to me at first.
So back to the parking lot at Teasers. I'm going to publish State Exhibit 41. And this is 41B, I believe 7. 8. All right, do you recognize this parking lot area?
Yes.
Do you recognize the car that's the silver car there, the top of the screen?
Yes.
What car is that?
That's the car we were in.
At this time, do you know where the other 3 boys are at?
No, I don't.
Do you care about where the other 3 boys are at?
Your object to calling the co-defendants boys.
Sustain the objection.
Do you know where the other 3 men were at?
No.
And do you care where these other 3 men were at?
No.
All right. Do you remember what's happening inside the car at this time?
I think we were just sitting there talking at first.
All right. And again, you're not driving this vehicle?
No.
Is there a reason why you have on a mask in this video?
Yeah, I was pregnant at the time, so I didn't want to smell any smoke and prevent like any health issues.
Why did you think that you might inhale smoke?
Because usually the clubs in my city, like the lounges, as soon as you go in, they let you smoke, so it'd be a lot of smoke in there. I didn't know how it was down here, but just in case, I wore one.
All right. Did you wear a mask to conceal your identity?
No.
Did you have on a hoodie?
No.
What did you have on?
Some blue jeans, a blue jacket, and a regular shirt.
All right. What type of shoes did you have on?
Some like regular Crocs I designed.
Crocs, like almost like slippers?
Yeah.
Those are not boots or anything that you could use to run in?
No, they're like the fancy ones where you get to put the things in them. I don't know what they call them.
When you say thing, you mean the pins on the top of the shoe?
Yeah, like you get to put what you want to put on them.
Okay. Are you and Mr. Chance getting out of the car now?
Yes.
Does Mr. Chance tell you that he's going to this club so he can find Julio Foolio?
No, he didn't.
If you can remember sort of what's happening in this moment, can you tell the members of the jury?
I was walking, and then he stopped me and said, "Let me see your phone."
At this time, are you trying to conceal your identity at all?
No.
Are you ducking or hiding or crouching behind any vehicles?
No, I'm just walking.
Are you stopping when he stops?
Yes.
And are you following him?
Yes.
Do you know what he's doing with your phone?
At the time, I just assumed he was trying to call someone, and they wasn't answering.
Did he talk to anyone in that clip?
No.
Do you ultimately leave this location?
Yes.
Do you go somewhere after that?
Yes.
Where do you go after that?
It was another club called Players Club.
At the time, did you know the name of that location?
No.
And who decided to go to the second spot?
He picked it.
Did you know of any clubs in Tampa?
No.
When you got to the second location, what happened?
We get out, walk across the street, and he walked up to the guy that they work at the front door, and he asked him how much was to get in.
So at this second location, you said, who asked how much it is to get in?
Isaiah asked the bouncer.
And what happened when he asked?
I don't remember the exact words, but he told him a price, and I guess he didn't like the price, so he just walked off.
Did you all stay there for any period of time?
Yes.
It's a short period of time?
Yeah.
And when you didn't go into the second location, what were you thinking?
Nothing much, like maybe he just didn't want to go in.
Were you also wearing a were you also wearing a mask at the second location?
Yes.
Did you go somewhere else after that?
Yes.
Where'd you go next?
Truth 18.
At the time, did you know what Truth 18 was, the name of it?
No.
Did you know who was going to be there?
No.
Did you ask Isaiah Chance to go to Truth 18?
No, he picked that.
Did he ask you for permission to go there?
No.
When you get to Truth 18, what do you do?
We sit there first, then we get out. He just starts to walk. He still has my phone, so I just walk after him.
Okay. Do you know if he talks to anyone while he's on your phone?
Yeah.
Do you know what app he's using to communicate with individuals?
No, at the time I didn't know.
Do you know if he's talking on FaceTime with anyone?
I believe it was FaceTime at that club that one time.
At Truth 18?
Yes.
And do you know who he was talking to at the time?
No.
When he's talking to the individual at Truth 18, there's a photograph that you've seen in evidence of the downstairs at Truth 18. Do you remember that photograph?
Yeah, I remember it.
All right. At the time that the photograph was taken, did you take the photograph?
No.
All right. From looking at it, what can you tell about that photograph?
I remember him flipping the camera because we came to a stop, and he said, like, man, he said that, man, this shit crowded, and he flipped the camera and was showing somebody on the phone.
Okay. Do you know who he was showing that on the phone?
No.
And when you say he was showing it on the phone, this is like he's showing it live?
Yes.
All right. And do you know how that live viewing became a screenshot photograph in your phone?
I think he just took a screenshot of it.
At the time, even though you didn't know exactly who he was talking to, did you, I guess, figure that it was one of the three men?
Yes, because he also said, where y'all at?
Did he say anything about Julio Foolio?
No.
Did he show you a firearm or anything like that?
No.
Did he say anything about wanting to kill Julio Foolio in front of you?
No.
Showing what's in evidence in State's Exhibit 44. Do you see this video?
Yes.
All right. Do you see yourself?
Yes.
All right. What is happening right here?
He's walking with the phone up.
Okay. And what are you doing?
Just walking behind him.
All right. And do you know where he's going at this point in time?
No, I'm just following him.
Do you know why he's walking, where he's walking?
No, I never asked.
All right. Is this where you all are at? Is this kind of like in direct eyesight of the top of the staircase at Truth 18?
I don't know if right there, but I don't really remember that.
All right. And you see you walk towards the sign and then back towards the right?
Yes.
All right. When you were standing anywhere in that parking lot or on the sidewalk, were you able to see Julio Foolio?
No.
Do you know that he's even inside?
No.
And is Isaiah Chance saying anything on the phone that would give you an indication that Julio Foolio is inside?
No. I only actually heard him say two things. He said that it was crowded and where y'all at.
Okay. After you leave from off the screen here, do you know what you're doing next?
We walk back down. He stops on somebody's car, still holding the phone, and I'm kind of just leaning on him talking.
When you say he stops on somebody's car, like whose car was it?
A random person.
So not like someone that he knew?
No.
And when you say he stops on, he's leaning on someone's car?
Yeah, like leaning back with the phone.
All right. And you and Isaiah Chance are talking at this point in time?
Yes.
All right. Do you ask him why you're not going inside?
Well, I think I did, yeah.
And do you want to go inside at this point?
Not really.
Why not?
We already been to 2 places. It was getting late, so I didn't really care to go nowhere else. He chose that place.
All right. At this point, what do you want to do?
Get some food.
Even though you just ate maybe 3 hours earlier?
Yeah, it was McDonald's. Just some nuggets and fries.
All right, so were you still hungry?
Yes.
And at this time, you're still pregnant?
Yes.
After you leave Truth 18, do you go somewhere else?
Yes.
Do you know where you're headed after you leave Truth 18?
No, I mentioned food, so I assumed he was going to go get me food.
All right. What does he do when he leaves Truth 18? Does his behaviors change anything at all?
Yeah.
In what way?
I mean, he started to act weird. I'm like, where are we going? He drive off to, I believe it's a college campus.
Showing, or about to show what's in evidence is State's Exhibit 24. Do you recognize this exhibit from earlier?
Yes.
You ever been to this location before?
Yes.
Well, okay, I'm sorry. Before this incident.
Oh, well, no, that day, yeah.
And did you recognize this area when you were in that area?
No.
All right. From this view, do you know which direction you came from?
I think he was straight ahead.
It's like at the very top of the screen?
Yeah, I think so.
And again, who's driving at this point in time?
Isaiah.
When you come from the area where the top of the screen is at, which direction does he go in this intersection? Pause it. Pause it.
That's him turning right there.
All right. So you came from the top. How did you end up on this corner making this right here?
That's where he turned.
Well, how did you get on that street?
I mean, that's where he just went. I don't know.
Let me ask you differently. When you came from the top area of the screen, did he make a right at this intersection if you're actually in the vehicle?
Yeah.
He made a right there?
Yeah, like he went straight and turned.
All right. And then did he make a U-turn to get to where he's at now?
I believe so.
All right. And for sure, that's the cruise that you were in?
Yeah.
Just let it play. All right. Now, the cruise is off camera right now. Is that correct?
Yes.
What happens when the cruise goes off camera?
He makes a stop in USF parking lot.
What does he do when he makes a stop?
He hops out of the car.
And when you say USF parking lot, is it in an actual parking lot that he stops the car?
No, it's like in the middle of the lot.
All right, so it's not in an actual space?
No.
When he hops, you said he gets out of the vehicle?
Yes.
All right, what does he do when he gets out of the vehicle?
He gets out my phone and he walks away.
He had your phone still?
Yes.
And you said he walked away from the vehicle.
Yes.
What did he do when he walked away from the vehicle?
I don't know what he's doing when he walks away, but he has the phone up. He just walked down.
All right. At this point, did you follow him?
No, I'm still in the car. He left the car on.
Why did you not follow him?
I didn't know he was getting out. He just came to a complete stop and hopped out.
All right. When he did that, did you think that that was strange?
Yeah.
Did you know at that time that he may be trying to kill someone?
No, I didn't.
Did he tell you that?
No.
After he hops out of the car, how long is he out of the car for?
I think it was like a couple minutes. It wasn't very long though.
Does he get back in the car?
Yes.
When he gets back in the car, do you say anything to him?
No.
Why not?
I didn't know what to say.
All right. You see the cruise?
Yes.
And you see the red light?
Yes.
When he ran the red light, what was going on in your head?
Why is he driving crazy?
Did you say anything to him at that point in time?
Yeah, I'm like, where you going?
Did you look at him?
Yeah.
And what was he doing?
He just holding the phone up driving.
Was he talking to anyone?
No.
So why was he holding up the phone?
I think he was looking at something on the messages.
All right. Did you see the car go into that lot to the right?
No, I didn't see it.
All right. You see the car go into the lot to the
Yes.
right? At that time, did you know what he was doing?
No.
Do you know where he was going?
No.
All right, did he tell you to look out for anyone?
No, he didn't.
Did he tell you to identify where Julio Foolio was at?
No, he never told me that.
All right. And how long are you inside that parking lot there in that hotel?
It was very quick. He just turned around.
All right. Did he get out the car and talk to anyone?
No. Did
you get out the car and talk to anyone?
No.
And then after you leave that parking lot, what happens?
He drives off to like 2 streets over.
Well, okay. Do you hear anything?
Yeah, I heard shots.
All right. Tell me about the shots that you heard.
It was like a lot, and I looked at him like my mouth open, like you heard that? But he didn't really pay attention to me. He like, what? So I didn't say anything.
After that, what happens?
He waits a little bit, then he drives off back to the Airbnb.
All right. At this point in time, what's going on in your head?
I heard a lot of shots, so I didn't know what went on. Somebody shooting in the air, somebody got shot at. I didn't know.
Did you know that somebody died?
No.
Did you know that someone got shot?
Hey, Judge.
No.
Take a break.
Yes, of course. Okay, I'm sorry it is. It's 5 to 11, and I know I had a lot of coffee this morning too. So, okay. So let's go ahead and take we'll come back at 11:05, okay? Very
All right.
What time is it?
So I think those are the 2 kids that got in trouble with the judge. I think they were taking pictures. If I remember correctly, guys, correct me if I'm wrong, but I think those were the 2 kids that she got really, really upset at. They were like taking pictures or something. All right, I see you guys asking questions about like how this started and everything. Let's go back to our timeline here, in case you're new to it. So the state's going to bring in 6 pieces of evidence as the incidences, right? So we backed it up. So the state's going to start with Bibby, right? So they're going to say Adrian Gaynor back in 2019, February 25th, that started this, which we go back further. We're taking it back further because there was a Kodak Black concert where PCE and maybe ATK were around, and there was a handshake that wasn't reciprocated, or was something happened, and the two sides started to fight and start shooting, and it was really bad. So then Aiden McClendon, 22-month-old, gets shot, unfortunately, and dies. And he's the cousin of Reginald and Noah Williams, who are WAP with the Choppa and Spinabens, and they're affiliated with ATK. So then you got Zion Brown, who was the cousin of Charles, Julio Foolio. He gets taken out by Trey Shorty. Then you got the Wasabi restaurant ambush, which was huge. That's Ace, his brother Quan, Kobe, and 23. That's where Julio, When I See You, his infamous, if you will, his song about 4 shot, 3 dead on your birthday. That was all about 23 and Quan and Kobe. Then you got Corbin Johnson. He disappears July 11th of 2018. His remains are found July 11th. Did I say? Yeah, July 11th, 2018. His remains are found July 11th, 2019. So it goes back, definitely goes back. Then you got Bibby. Bibby was a really close friend. Bibby, Tiki, and Lil Nine, they're prominently displayed in Who I Smoke, which is Ace's huge song. It's like 58 million hits right now, or views. When I See You, I think, has 75 million views. So then you got Gerard Adams, Spaz. He gets taken out. That's at the football game that Alicia was talking about. Alicia was talking about that earlier in her testimony. And then finally, the state's going to bring in Jaquan Pickens. You got Jacoby Beals. You got Antonio Tilley. And then, of course, Julio getting shot. That's when he got shot in the foot. So the state's only going to bring in six of these. As you see, it says state's evidence, but we took it back a little bit further. So from what I understand, from the research that I've done, it kind of started at that Kodak Black concert, and then and then Aiden getting shot, but then Zion Brown, I think, to me, Zion Brown kind of started it. But the state is saying they're going with Bibby as the flashpoint, and it very well could be, but it just seems like it could be traced back a little bit further. All right, let's continue on. Hope you guys are enjoying this. We are getting ready for the trial tomorrow. The 4 guys. So we're just watching Alicia's testimony. We watched her opening statements. Now we're watching her testimony as we just get through the jury. Yes,
All rise.
All rise.
All jurors are in, Judge.
Okay, very good. All right, everyone have a seat, and you may continue, Mr. McClyman.
All right, Ms. Andrews, I think we left off where you heard gunshots. Is that correct?
Yes.
All right. After that happens, what happens next?
He drives back, but I did make a reaction, but we didn't get the same reaction, so I left it alone.
And again, at that point in time, did you know that anyone had been shot?
No.
Even though you heard gunshots, you didn't know that anyone had been actually shot?
No, they could have been shooting in the air or something.
All right. Did you know that it had anything to do with Isaiah Chance?
No.
Were you suspicious of anything at that point?
Yes.
All right. And what happens after you leave the Home 2 Suites?
He was like 2 streets over, and he stopped and waited.
Stop and wait for what?
I don't think anything particularly. He was just on the phone.
Was he saying something on the phone?
No, like he was on the app, like Twitter or something, just scrolling.
What happens after that?
We go back to the Airbnb.
When you get back to the Airbnb, is anyone there?
Yes.
Who's at the Airbnb?
It was the other guys was there downstairs.
And did you go inside the Airbnb?
Yeah, I did.
And when you went inside, what did you see them doing?
I mean, they were just sitting around. One was on the couch, one was sitting at the dinner table, I think. And they were just sitting there, looked tired. They were stink. I just went upstairs.
All right. Did you see any guns when you went inside?
No, I didn't.
Did you see any rifles at all? Anything?
No.
They got to the house before you?
Yeah.
When you went upstairs, what did you do?
I changed, got back in the bed.
And what happened after that? Did you go to sleep?
Yeah.
In the morning, I assume you woke up.
Yeah.
And what happened when you woke up?
Well, he wasn't right there, so I texted him. I told him I was hungry. What happened? I know we ended up arguing about something. It was kind of petty, though. I just wanted food, and he takes so long to get me what I wanted. So I was just waiting there, and I took a shower. Then eventually he come in there, he shows me outfits, what do you want to put on today. And then that was pretty much it.
At some point during that day, did you all leave the Airbnb?
Yes.
All right. Where did you go?
Back to Jacksonville.
Was it your decision to go back home?
I mean, no, but I didn't mind. I was ready to go anyways.
Why?
I'm there with other people I don't know. It wasn't a trip that I thought it was going to be, so I was ready to go.
Did you take an Uber back?
Yes.
And whose idea was that?
Isaiah.
Why did you not take the Impala back?
I mean, I don't know. I didn't ask him. He made the decision to go in Uber.
Did Sean Gathright, the one who was driving the Impala, did he leave before or after you? Do you remember?
I think he was after.
Did he offer a ride to go back to Jacksonville in the Impala?
No. I remember him saying he had somewhere to go.
When you get in the, well, let me ask you this. There's a pink bag that the state's referencing, seeing you walk
Yes.
out of the Airbnb with it. You remember that?
Yes.
Whose pink bag is that?
Isaiah's.
And why does he have a pink bag?
I mean, it's his mom's bag. He just had clothes in it, though.
And were there any rifles in that bag?
No, it was just clothes.
You've seen the rifles that have been in this trial?
Yeah, I seen it.
Can those rifles fit in that pink bag?
No.
And the bag itself, was it heavy?
No.
What was inside the bag?
It was his clothes.
Did you look in any of the bags, any of the other bags that were there?
No, I never even seen those bags in the Airbnb. Unless when I was upstairs, they could have brought it in, but I didn't see them when I was down there.
When you get in the Airbnb to go home, what are you doing?
Just in the back seat, listening to music.
All right. Are you talking to the Uber driver?
We exchanged a few words, but nothing much.
At any point in time, do you tell the Uber driver to slow down?
No.
Are you worried about the Uber driver speeding?
No.
Do you have any guns on you?
No.
Did you commit any crimes?
No.
You get back to Jacksonville that day?
Yeah.
And what happens next?
We get out the car. I just get in his car. And then he drops the guy that was in the back, Rashad. He dropped him back off to the place he was at.
All right. Did the Uber driver help you all with your bags?
Yeah.
All right. That day, the day after you went to these nightclubs, did you go on social media at all?
I went on there, but wasn't doing nothing.
All right. When you say you weren't doing it, what do you mean by that?
I wasn't making any posts.
Okay. Yeah, so that's not what I'm asking. I'm asking if you went on social media.
Yeah, I did.
Did you see anything on social media?
Yeah, TikToks. I was on Instagram.
All right. And did you see that Charles Jones, Julio Foolio, had died?
Yes, on TikTok.
And what did you see, if you can remember?
I think people were outside recording, like the hotel.
All right. Did you recognize the hotel?
Yeah.
And when you saw that on your social media, what did you think?
I mean, I was confused. I'm like, that's probably what I heard, but...
All right. And did you ask Isaiah about it?
Not necessarily asked him, but I showed him the video.
And what happened?
He was like, dang, and who page was it on?
Did he at that point tell you anything about him being involved in anything?
No, he didn't.
Did you think it was strange that you were in that area?
Yeah.
All right. At a certain point in time, do you think that the individuals who were there, who were at the Airbnb, that they had anything to do with this?
I mean, at that time, I could say they were being weird, but I didn't think they would know. I don't know them personally to say, oh, they're a killer. Like, I don't know.
All right. And when you say they were being weird, what do you mean by that?
Like, I remember I walked downstairs to get some ice. It's like everybody stopped talking. So I'm like, I didn't know what for.
At some point, do the police come to talk to you?
Yeah.
And when the police come to talk to you, what do they come to talk to you about?
He asked me like what I did that weekend. Was I in Tampa?
All right. So they're questioning you about the shooting?
Yes.
The first time you talked to the police, is it in the interrogation video?
Yes.
This is Exhibit 59. I'm going to publish to the jury. Can you wait a 10-minute mark? Is that you in the interrogation room?
Yes.
All right. And what do you have on?
Blue jacket, some Adidas, and I believe Crocs.
Can you back it up just a little bit? That's fine. Keep it clear. Do you recognize the two individuals?
Yeah.
just so you can see this. Plug it back in. Just in there, the bottom. It's a different device.
We can use that. Yeah, no problem.
Judge, the sound is not working on any device, so I'm unaware of what's going on. So I'm trying to fix it.
Okay.
You understand that? You may use any of these rights at any time, before or during questioning, and you may... Just so you know, again, like you said, you want to see some stuff and you want to answer some stuff.
Is there a question?
There's about to be one. I'm about to ask you a question. So, Alicia Andrews, we're watching this video. I want you to tell me what you hear from Detective Ramos.
You can answer it. If you don't want to answer some stuff, you don't have to answer it.
What did Detective Ramos just tell you?
He said I can answer if I want to answer. If I don't want to answer, I don't have to answer.
in charge. This is you are in charge of what happens to you in your future starting right now. Okay. You have the right to remain silent. Do you understand that? You have the anything you say can be used against you in the court of law. Do you understand that? You have the right to consult with an attorney before you make a statement or answer any question, and the right to have an attorney present during the question. Do you understand that? If you want an attorney but cannot afford to hire an attorney, one will be appointed to represent you before during questioning, free of charge. Do you understand that? You may use any of these rights at any time, before or during questioning, and you may stop this interview at any time. Do you understand that? Do you understand all the rights that I've just read you? So you understand at any time. Up to you.
Mr. Andrews, had you ever had your rights read to you before?
That would have been the first time.
And when he's reading the rights to you, are you paying attention to him?
Sort of.
I want to show you a video here. Do you have any questions about your rights before I show you this video?
No.
Do you remember him asking you any questions about any facts prior to showing you the video?
No.
Can you see that?
What is Detective Ramos showing you?
A video of me at the Airbnb.
Had you ever seen the video before?
No.
Is that you in the footage?
Yeah.
Okay, can you tell?
Does he have to beat that out of you?
No.
Objection, Your Honor. I'm going to sustain the objection.
Going on here?
Wait, I'm not open the door.
Okay, where are you at in this video?
I am.
Do you remember what town you were in?
Yes.
Okay.
Was it difficult for you to tell him that you were in Tampa?
No.
Can you tell us what you're doing down in Tampa then? Usually, be honest.
I had to wait for my boyfriend 2 months before that, so he got accident on the first one.
Who's he?
My boyfriend.
Got him?
Yeah. Why do you call me?
Well, what do you call him?
Zane.
Zane?
When the detective called Isaiah Chance gutter and you laughed, why did you laugh?
I mean, I thought it was weird. Like, they're detectives. I thought they were going to at least use his real name.
Were you trying to say that you didn't know who Gutter was?
No.
In fact, did you tell them that your boyfriend was Gutter?
Yeah.
So does he go back? You never call him Gutter? Never?
That's not like a
Zane, you can call him Zane. If that's what you know him about.
Who all went down to Tampa with you?
When you told the detective that you don't know the people, was that true?
Yeah.
Do you know, or did you know Davion Murphy?
No.
I mean, today, do you know Davion Murphy?
Yeah, now.
All right. Do you know, or did you know at the time, Rashad Murphy?
No.
And Sean Gathright? What communications or contacts had you had with Sean Gathright at the time?
None at that time. I just told him I met him maybe one time.
Okay. You're saying none at that time, then you said you just met him one time. So I just want the jury to be clear. At this time of this interview, how many times had you met Sean Gathright before?
That would be 2, including Tampa, so that would be the second time.
Okay. The first time you met Sean Gathright, what was that at? Where was that at?
His house.
All right. And was he the only one there?
It was him and the other people I didn't know, but I think it was some of his family members.
All right. Was it a gathering?
Yes.
All right. With multiple people at the house?
Yeah.
And what did you do at the house?
I walked in, and Zay introduced me to them. He was like, this is my second family. He was like, what do you want to eat? So he fixed me a plate.
All right.
How long did you stay there?
I don't remember that time. It was long.
Do you remember meeting Sean Gathwright's mother there?
No, I don't remember that.
Do you remember if she was even there?
No, it was a lot of people.
All right. Do you, if you were to call out the people that were there, would you recognize them?
No.
All right. Hold on. While you're inside this interrogation room, do you feel any pressure?
Not in the beginning, but later on, yeah.
Why?
I mean, he was talking over me and yelling, and I felt like I was just closed in by two men.
The detective, was he cursing at you?
Yeah.
In your view, was he threatening you?
Yeah.
What types of threats did he make to you?
He said I was never going to see my baby. I was going to spend life in prison. He said you were never going to get to go out again, do your nails, your hair, something like that. He said a lot of stuff.
All right. When they asked you about other individuals like Davion Murphy or Rashad Murphy, at that point in time, did you feel comfortable talking about these individuals?
No.
Why not?
I mean, I don't really know them, so I didn't want to talk about them.
Did you tell the detective that you were the one inside of the cruise?
Yeah.
At McDonald's?
Yeah, I did.
Did you tell him that you went to clubs?
Yeah.
You told him that before he showed you any video of a club?
I think so, I did.
You also pointed out Isaiah Chance as being in the car at the McDonald's, right?
Yeah.
Did the detective know that Isaiah Chance was in the car at the McDonald's?
No.
But you gave him that information?
Yeah.
Getting an Instagram message to somebody to rent an Airbnb for you guys down here?
All right. What did Detective Campbell just ask you?
Did I DM a girl on Instagram?
When he asked you that question, did you remember what he was referencing immediately?
No.
You don't? You did. When you sent a message from your phone.
Oh, I know something.
Yeah. Tell me what happened.
Yeah, she do like have offs whenever you do though.
She does what?
She does have off. Like you can bring something to her at her price.
Okay. Who did you send a message to? Do you remember?
I don't know her name, it's a light skinned girl. Like she do promos, she posts on Instagram.
Okay. Did she end up booking the Airbnb that you guys stayed at? Do you know who
She
booked
touched
it?
on text back.
Do you know who booked the Airbnb that you guys stayed at?
I just asked and went over it. We're still going.
Was the guy who was driving the cruise while you were at McDonald's, okay, who you hadn't met before, was he at the Airbnb when you guys left the Airbnb? You don't know?
Like I'm a good person. Like I'm when you got me going. Like her.
When you say that you left first, are you referring to when you left to go back to Jacksonville?
Wait. I gotta hear what it said again.
I'm sorry.
I gotta hear what it said again.
when you guys left the Airbnb? Was the guy who was driving the cruise while you were at McDonald's, okay, who you haven't met before, was he at the Airbnb when you guys left the Airbnb? You don't know?
I was there first. Like when you got in the car.
When you're making that statement, are you referring to after, like when you all are leaving the Airbnb to go back to Jacksonville?
I think I was.
The person that he's mentioning, he says the one that's in the driver's seat at McDonald's, you know that person to be Davion?
Yeah, now.
All right. And did Davion ride back with you?
No.
Or just 24?
Where you got it back?
24 flat. 24 flat.
Well, I can't hear you in hand because you're the only one that goes in the front door. Nobody else can do that front door. Were you there by yourself at your Airbnb? Well, I can't hear you in hand because you're the only one that goes in the front door. Nobody else can do that front door.
That's fine.
Because they don't come in at the same time.
Was there some confusion about you letting people in the back door of the Airbnb?
Yeah.
Did the detectives believe that you let people inside the back of the Airbnb?
Yeah, that's what he thought.
And he thought that you were doing that to conceal their identity?
Yeah.
How did they get in?
I'm a good friend.
Yeah, but this camera goes off every time somebody passes it, and in order to get in, you have to put in a code, and that code gets tracked on the app. I spoke to the owner of the Airbnb. Nobody else went in. How did they get in?
I'm not sure.
Did you let them in another door?
Is it possible you could open the back door?
No.
Were you there by yourself at your Airbnb? Well, I can't hear you in hand because you're the only one that goes in the front door. Nobody else comes in that front door. It records every single person that comes in that front door and uses that code. When you guys went out to McDonald's, did you go out the front door? You don't know? Or did you go out the back door? Which door did you go out?
I'm not sure. Sorry.
Do you understand what I'm talking about? That you're the only one that went into the front door? Nobody else went in that front door? So how did they get inside if you were the only one who went in the front door?
I did not.
Huh?
I don't know. I did not.
No, I understand how you got in the front door.
Yeah.
How did anybody else get in because nobody else is on the
Anybody
camera?
else?
Hussein was with you. He stayed there,
Yes,
right?
I did.
He didn't go in the front door.
I don't know. I did not.
They didn't go in the front door.
When he's asking you the question repeatedly, you understand what he's asking you.
Yeah.
Is he accepting what you're saying?
No.
I'm not sure.
When he does not accept what you're saying, do you get frustrated with him?
Yeah.
Are you showing that frustration?
No, I'm kind of doing like
I'm
a...
going to sustain. Don't leave the witness. Ask the next, rephrase your question.
Are you showing the frustration?
No, I'm just doing a nervous laugh.
Wait a minute.
Was he inside with you?
Yes, of course. I'm going to myself.
Okay, but he didn't go in the front door.
Well, I don't know. Did y'all ask him that? 'Cause I don't know.
Why did you say, did y'all ask him that? Who is him?
Isaiah.
Why did you say that?
Because I mean, it's about him. Like, go ask him.
I'm going in and put myself in.
I want one honesty from you. You ready for my one honesty?
Are they back at this issue with the Airbnb door?
Yeah.
Did you open the back door to let other people in the Airbnb? That's an easy question. Then how did they get in the Airbnb? Because they did not go in the front door.
What they gotta do with me?
No, it's asking you for one honesty.
All I did was walk up and knock. Did you see me tap anything in? So what they gotta do?
You opened up the front door and you got it.
I didn't open nothing.
You didn't open up the front door of that place?
No.
How did you get in?
I'm seeing okay.
Nobody else went through the front door by you. I'm just asking one thing that I know is 100% truthful. And you can't answer that.
He has to give you the code over there.
Was it 100% truthful that you went to the back door, that you let people into the back door?
No.
It's actually just audio of that. You have to get the code to get in. He gave you the code. Oh, it's audio recorded. It's on audio.
That was the code.
Yeah.
The guy gave you the code.
I'm about to go. I don't have.
Did you hear Detective Campbell say that the guy gave you the code to go in?
Yeah, he did.
Is that accurate?
No.
It's on audio.
Okay, go back and listen. What code did you make me say?
I can tell you this. How many women do you know? How many women do you know that have been to prison?
Go to 38 flat. Or you could just let it go. I didn't realize it was so close. Just let it go.
Did you know any woman that's been to prison? You should know that. I can tell you this, you're young and you're small. And where you are likely to end up without the truth, without a truthful statement right now, is a horrible place.
I gave you the truth.
No, you have not.
I have, whether you believe it or not.
Let me ask you something. Do you think I'm probably good at my job or probably bad at my job?
I don't know you.
What was your response?
I said, I don't know you.
So, when you say that you don't know him, does that mean you don't see him in front of you?
No.
What does it mean when you say you don't know him?
I don't know him personally.
Is that the same sort of response you gave about whether you know Davion and Rashad Murphy?
Yeah.
All right. There were some things during this interrogation that you said that were not accurate, were not truthful. Is that correct?
Yes.
All right. What were those things generally about?
I mean, everything I didn't answer was about them.
Who's them?
The other co-defendants.
All right. Did you have any concerns for your safety at this time that if you said something about another individual, it could come back on you?
Yeah.
Did any of the detectives at any point in time, whether it be on this video or otherwise, did they tell you that they would make sure that you were safe from anyone?
No, they didn't.
Obviously, were your parents present?
No.
Was anyone there to assist you?
No.
At the time of this interview, do you know where Isaiah Chance was at?
No.
Do you know whether if he got pulled in by the officers at the same time?
No.
This ain't no shit you get to walk away from. The problem is you can't even say that you heard it all. You just weren't. It's in the passenger seat. In for the passenger seat. You talking to two grown men who've been in this way too long. Like how? Does that make sense to you? Does that make sense to you? If somebody told you I'm in a car with somebody and he's talking on the phone the whole time, I ain't hear nothing. You don't want what he said? That makes sense to you? How does that make sense?
Obviously, but I don't know.
I'm here. Here I am. I'm right here. I'm with you. Here's the center console. Boom. Hey, he just pulled up to the hotel. No. Drive around one more time. Hey, park real quick. All right, he's in the passenger seat. In for the passenger seat. Are you hearing that?
First of all, was Isaiah Chance saying anything like that to you?
No.
Was he saying anything like that on the phone?
No.
Is that just the officer's assumption about what was happening?
Yeah.
When the officer here gets in your face, what do you feel?
Aggravated.
Did you hear me say that? You didn't hear me say that?
What did you tell him?
I said, no, I'm kind of zoned out.
It's a game, Chief. It's a game, Chief. And it's sad, man. And it's sad because this isn't a game. This is real life. It's happening right now. This is real life. This ain't no TV shit. This ain't no shit you get to walk away from. The problem is you can't even say that you heard it all. You just weren't part of it. You can't even say that to us.
When the officers asked if you went down to Tampa with anyone other than Isaiah Chance, did you tell them that you went with his little brother?
Yeah.
All right. And at the time, did you know his name?
No.
Did they show you a photograph of the little brother?
Yeah, they did.
Did the photograph look like him initially?
No, not at first.
Why not?
I mean, I remember him having bushy hair, and he showed me a whole different picture, so I said no.
And you drove down with this individual, Sean Gathright, from Jacksonville to Tampa?
Yeah.
All right. Were you staring at his face the entire time you were driving down?
No.
Where were you at?
In the back seat.
And were you looking at his? Were you trying to look at his face while you were driving down?
Not really.
When you got to the Airbnb, did you and him hang out inside the Airbnb face to face?
No.
Did he go to McDonald's with you?
No.
Were you at Teasers with Sean Gathright at any point in time?
No.
And Sean Gathright, did he ride back to Jacksonville with you?
No.
Do you believe if you told the officers, these detectives here, if you told them what they wanted to hear, do you think they would have let you out?
No.
All right, Miss Andrews. Are you still in a relationship with Isaiah Chance?
I mean, he may think that. I never broke up with him.
When you say he may think that, what do you mean by that?
Like, we just got arrested. Nobody broke up with each other. None of that.
All right. Are you personally in a relationship with Isaiah Chance?
No.
I don't have any other questions.
Okay, very good. Members of the jury, it's noon. We're going to go ahead and take a lunch recess, okay? Is 45 minutes good enough for you guys? Okay, 45 minutes it is, all right? So be back here at 12:45. And we are you all going to want me to instruct the jury before on the elements before closing arguments or after?
Judge, I would like to go forward.
So I'm going to review these Okay, I'm going to review these one more time. I'm going to put them in the order that they're going to be given to the jury, and I'll read them to the jury before.
Yes, Judge.
Thank you, Your Honor.
Ms. Andrews, you've testified about your on-again, off-again relationship with the co-defendant, in this case, Isaiah Chance. Is that correct?
Yes.
In fact, you told this jury about some instances where you had been hit by him. Is that correct?
Yes.
You've dated Isaiah Chance for over 4 years. Isn't that true?
Not over 4 years.
How long?
It's about just 4 years.
Just about 4 years, okay. And it's been on again, off again, is that correct?
Yes.
And during that time period, you have dated other young boys, is that correct?
Maybe.
Does Kamari Outing sound familiar?
Yes.
He's a boy that you had dated, and you still were talking to him, in fact, up until the time of the crime, June of 2024. Is that correct?
We never dated, but yeah, I was talking to him.
Okay. And in fact, at some point, Isaiah Chance got upset and made phone calls to him, right?
Yes.
And you had conversations on your phone with Mr. Kamari Outing where you two discussed that. Isn't that true?
I believe so.
And they were still on your phone. They were backed up. They were saved on your phone, and they were on your phone on June 23rd of 2024. You never deleted these messages that you had with Kamari Outing. Isn't that correct?
I mean, I have to see the message. I don't know. What is that message?
Okay. Your Honor, I'll approach the witness. Would looking at those messages help refresh your recollection?
Yes.
Ms. Andrews, if you'll take a look at this.
Same one.
Ms. Andrews, you recognize these messages from your phone?
Yes.
And Kamari Outing, he was a member of 1200, isn't that correct?
No.
No? I'm going to show you State's Exhibit 75C12. That's a photo of you with Kamari Outing that was still on your phone. Isn't that true, ma'am?
That's not Kamari.
That's not Kamari?
That's my cousin.
Okay, what's your cousin's name?
Marcus.
Marcus, okay. And in this messaging with Kamari, He's upset because Isaiah Chance has called him and basically told him that you're with him and that you're pregnant, and you're still trying to get Kamari Outing to talk to you, right?
Objection, hearsay, and relevance. Tampa roll.
Isn't that true, ma'am?
Yeah, that's my best friend.
And he doesn't want to because of Isaiah Chance, correct? In fact, you're the one that keeps on insisting that he not block you and that you and him continue to talk. Is that correct?
Yeah, but the message behind that, that's my best friend. And Isaiah called him and was just going on and on about, he didn't want him to, he was giving him a reason to not text me back, to not talk to me. That's what that was about.
And so despite the fact that Isaiah Chance doesn't want you to have anything to do with him, you're fine with disobeying what Isaiah Chance wants because this is your best friend, right?
Yeah, and at the time I sent that, I was at home in my bed. I was not with Isaiah.
But all of these messages are still saved and on your iPhone, right?
I mean, I guess so.
They were, not you guessed. They're on your iPhone, right?
They're my iCloud.
Yes. And so your iCloud backs up your iPhone, ma'am. Isn't that true?
I'm not sure how that works, but I think so.
Okay. You don't recognize these messages? Something that you typed and you received on your little pink iPhone?
I believe so.
Okay. And your phone is also password protected, right?
Yes.
Because certainly when Isaiah Chance is using your phone that night on June 23rd of 2024, at some point when you're walking in that parking lot, your phone locks up, right?
Yes.
And you have to enter in your password.
Yes.
And so that's what happens with an iPhone. After your iPhone is not being activated over a lengthy period of time, a couple of minutes, 5 minutes, it does what?
It locks.
And so what do you have to do every time that happens?
Unlock it.
And obviously Isaiah Chance didn't know your password because you're standing there right next to him, and what does he have to do?
He asked for the password that first time, but he's looking at me.
And I'm going to show you State's Exhibit 34. You know who this is, right? Charles Jones.
Yes.
You have known who he was since 2021 when you were at Rains High School, right?
I knew of him, yes.
You were well aware of him, right? This is something that you discussed a lot with your friend Jewel Jordan.
I only discussed him maybe 2 times.
At the time when you were doing that, did you date somebody by the nickname K Shorty?
We weren't dating.
You didn't date him either, right?
No.
You weren't upset talking about Jewel Jordan and Julio Foolio, Charles Jones recruiting all these young men that were getting shot up in this gang war?
I wouldn't say upset. I was just gossiping.
Okay, we'll get to that in a minute. But this is State 75C13. This is a photograph with you and K Shorty.
Yes, that's Therese.
Okay. And do you see what he's doing there?
Yeah.
He's throwing up like 12?
I don't know what the sign means. I
have no idea what that means. But you're posting this on TikTok, right? You love TikTok. You've talked about, right? You posted on TikTok. You're both posing together.
Yes, ma'am.
And despite the fact that you intimately know a lot of people who are associated with these gangs, you have no idea what it means when he's throwing up that sign.
No, I don't.
No idea whatsoever.
Objection, asked and answered.
Overruled. Go ahead.
You followed Charles Jones on Instagram, isn't that correct?
Maybe back then.
Did you ever unfollow him?
Probably.
You were still following him when this crime occurred, right, on Instagram?
I don't remember following him.
You don't remember? You never looked and you never saw any of these advertisements that Julio Foolio was going to be in Tampa on June 22nd?
No, I never seen those.
You did not like Julio Foolio back in 2021. Isn't that true, ma'am?
I mean, I wouldn't say a personal issue. When you say like him, didn't like him.
So I'm going to show you State's Exhibit 75C2, conversation that you had with Jewel Jordan.
So I want you to read what you texted to her back on January 19th of 2021.
I said, but if you think about it, everybody dissing everybody. People from out east diss they side, so of course they gonna say something, but it don't even be proper like that like that for real. Julio be the one talking shit, then all his little niggas come, then other extra people.
Okay. So you are talking about out east, correct? That is a territory of 1200.
Yes, ma'am.
And you're talking about how the people in 1200 dish they side, correct? And then you're also talking about Papa, that's Little Papa, right?
Yes.
And who's Little Papa?
He's a rapper.
And you know that he also has a gang affiliation, is that correct?
I mean, he doesn't claim it, so I don't know.
Okay. You know your boyfriend, Isaiah Chance, is in a gang, isn't that true?
I don't know that.
That's something you've told your best friend since you were little, Jewel Jordan, that you knew that he was in a gang and that he was in it.
I never told her that.
You never said
I've heard allegations of it, but when I asked him, he denies it, so of course I took his word.
In this particular conversation, you then say, again, talking about Foolio, let's go down here. I want you to tell the jury what then you texted in response to Jewel Jordan saying that they keep killing each other. And we're talking about the gang war in Jacksonville, right? 1200 against 6 Block. ATK against 6 Block, right?
Yes, ma'am.
So let's see, what did you text her?
I said right, so it's gonna go on.
And I'm sorry, Miss Andrews, if you don't mind, you speak very quickly, so if you could just speak slowly, because I'm seated next to you and I'm having trouble hearing you. So thank you very much.
I said right, so it's gonna go on, and they keep saying let leak rest, but I'm sure the other side be feeling like that, so it's gonna keep repeating, and yeah, they know what come with it, so charge it to the game, go retaliate or something. They sitting up there rapping, but that's y'all homeboy. Just do what y'all have to do. They don't be in Jacksonville, so I doubt they care about anybody here or the upcoming rappers.
So Leaky is another person that has died in this gang war, correct?
Yes, ma'am.
And you're well aware of that, correct?
Yes, ma'am. He went to middle school with me.
So you have somebody who went to middle school that died in this gang war, and you had somebody who went to Raines High School that died in this gang war. Is that correct?
Yeah, I heard of it, but I'm not friends with him.
Well, you're not. You say you're not friends with Spaz, right? Joe Rod Adams, correct?
Yeah, I'm not friends with him.
But he wasn't the only one that got shot in that Raines High School shooting, was he?
I mean, I think so.
Will also got shot in that high school shooting. Will Go Crazy, the person who you communicate with on your phone, right? You know who Will is.
I wouldn't say like that. He texts me and he tries to talk to me like I'm cute. People are going to start talking to me like that.
He's who Jewel Jordan was talking about when she said that you two had a friend that was injured at the shooting at Raines High School, correct?
Yeah, when she says friend, she means associate.
Mm-hmm. So I didn't ask you that, but what her wording up there was friends, right?
Yes.
And he got shot in the arm. His name is Will Royal. He went to high school with you at Raines High School, right?
I believe so.
You believe so, or you know so?
I don't remember his last name being Royal, so that's why I said I believe so.
Okay, let's not call him Will Royal. Let's call him Will, who got shot in the left arm the same day that Spaz, Joe Rod Adams, got killed at Raines High School when you were attending there.
Yes.
You know who I'm talking about, right?
Yes, Will.
So what are you texting your friend Jewel Jordan on 1/21 of 2021?
You want me to read it?
Yes, ma'am.
I said it was deleted about the time I got up, but Julio had said it'd be everybody. Julio had said it, but everybody kind of knew that. It was just once that time he got shot, and I forgot the boy that died with him at the Raines game, but the boy Robert ain't even do that, even though he on the 6th side. It was Bibby, and Will knew that, but Bibby died like 3 weeks later, so that was crazy.
Okay. And so who we're talking about right now, that you claim not to know his last name, is the very person you are texting Jewel Jordan about, right? Will.
Yes, ma'am.
So you knew him well enough to be texting to your friend, Jewel Jordan, after the high school shooting at Rains, correct?
Yes, he was known.
And the other person that you are mentioning in the same sentence is Robert. You're referring to Robert Howard, the person who actually went to prison for manslaughter for that shooting, correct?
Yes, ma'am.
And you're also mentioning Bibby, is that correct?
Yes.
Bibby is a nickname. It is a gang nickname, isn't it, Miss Andrews?
I didn't know his real name. I'm just referring to him as Bibby.
Okay. Because Bibby is the way that the people who you hang out with refer to him, right?
No, the people on the internet refer to him as Bibby.
That's right. And that's how they know him, by his gang name.
I mean, I wouldn't know if it's his gang name.
Do you think Bibby is his legal name?
I don't know him personally to know, so.
And then Jill Jordan responds, OMG, LMFA, what does that mean?
Laughing my fucking ass off.
Everybody kind of knew. They all had comments to calling. You guys are also watching what is going on social media between these warring rival gangs, aren't you?
Yeah, that day we're actually referring to a post, so we're reading the comments, but instead of putting it in the comments, we're texting it to each other.
Now I want you to read to the jury what you texted your friend Jewel Jordan on January 21st of 2021.
I said, girl, I don't like Julio. Laugh my fucking ass off, ugly ass bitch. He need to die. And shit, that was Will friend. Fuck the cold shit. Then I said, bitch, he shot me and my friend died. Yeah, I'm pointing out who did it.
Okay. And so you don't like Julio Foolio. That's fair to say. Back in 2021, you didn't like him.
Yeah, that was my opinion when I was 17 years old.
And your exact words were, he need to die, correct?
Yeah, but I didn't mean it literally. I'm 17 just gossiping.
Okay. But you really are talking about your friend Will, and you're saying, fuck that code shit. If he shot me and my friend died, you're referring to Will and his friend Spaz that died.
Yeah, I was saying he knew probably who killed his friend. He should have spoke up. I'm saying if it's my friend, I'm going to tell who did it.
So you were upset that 6 Block, and you believe 6 Block and Julio Foolio's group were responsible for your friend getting shot, correct?
I mean, that was what was on the internet, and I wasn't upset. I mean, I'm just gossiping. I really don't care, honestly.
And then you emphasized it, right?
No, she emphasized it.
She emphasized it. Then I want you to go down here and say what you said, 1/22 of 2021.
I said, bitch, hold on, because I think Julio talking about Therese and his friends left my ass up. I do not like him.
Okay. And tell us again who Therese is.
Therese is the person I'm in a picture with.
And then what did you say?
I'm trying to put 2 and 2 together. I was reading the comments.
And then what did you say here?
No, that's her talking.
Oh, I'm sorry.
Top.
What did Jewel Jordan say in response?
She said, that is Julio, though. He recruit a bunch of dumbass niggas who willing to die.
And then what was your response to that?
I said, right. And he started to realize. But first time I saw him, that shit clicked on. When Julio called, we all in the garage. He talking about, nigga always want me to ride with him when he down here, so I could be the one that died, not him. I ain't nobody guard. I said, bitch, I was dying.
And what do you mean when you texted that?
I was in the garage with Therese one day, like just chilling, and one of his, I think that was his cousin or somebody older, and he gets a call from Julio, and he, I think, asked him to ride somewhere, and he tells the friend, like, at the phone, he goes, he said, I'm not riding nowhere with him. I'm not finna die. And I just sent it to my friend. I'm like, well, I'm over here laughing about it.
And you said Isaiah Chance, you did not know he was in a gang. Is that correct?
I mean, I heard people say it, but when I asked him, he says he's not.
You also were aware of what happened at the town center, is that correct?
Yes, it was on the news.
Tell us what happened at the town center.
Some people died in a car leaving Wasabi.
Okay. Yungeen Ace, correct?
He didn't die, but he got shot.
Yungeen Ace's group, is that correct? They were in that car.
His cousin and brother, I believe.
And he was the only one that survived, correct?
Yes.
His brother was killed?
I think that was his brother, yeah.
Person named 23, Royal Smith, was killed?
Yes, ma'am.
And Isaiah Chance, he was upset about that, wasn't he?
I mean, I don't know if he's upset, but he would say, like, he's heard about it sometimes.
That is something, a moment that he has shared with you intimately about what happened at the town center. Isn't that true, ma'am?
I mean, I already knew what happened, but he's explaining to me like he don't like to go out there.
Correct, because 23 died at the town center.
Yeah, he believes there's violence out there. He don't want to go out there.
And he was upset about it, right?
I mean, I guess so.
You had a conversation. You don't remember the conversation you had with him on your phone where you wanted to go do something at the town center?
Yeah, I believe I showed him a restaurant I wanted to go to.
That's you here, right? You want to go one day, question mark?
I think, is that him?
Oh, that's him, you're right.
That's him.
That's one of his old phone numbers, 904-575-7534.
Yes, that's his old number.
And he's like, you want to go one day? And you said, yeah, it's in the town center.
Yes.
And then what was your response?
I sent him a TikTok. I was responding to the TikTok saying, laugh my ass off, bro.
And then what was his response?
He said, I hate it here. I hate it there.
Why would he hate it there?
I guess he's traumatized about it. Somebody you know died out there. You don't want to go out there.
And his next response to you?
He says, I don't like the town center.
And then what did you say?
I said, you hate everywhere. We don't got to sit in.
And then what did he respond to you?
He's telling me 23 got killed in the town center. That's why I don't like it out there.
And then what was his next
He said, I don't like thinking about it for real. So when I do switch moves, like an MF.
And what was your response to this texting conversation?
I said, well, we don't have to go there if it's gonna bother you. I forgot about it. It's some other places we both ain't tried yet.
So this is a conversation that you have had more than once with Isaiah Chance. Isn't that true?
I think that's is it the one time?
You said you forgot about it, right?
No, I'm saying I forgot that it happened in the town center because I've seen it on the news.
You knew who 23 was, right?
So he referred to 23, yes, I knew of the person.
Knew that 23 is associated with Yungeen Ace, is that correct, ma'am?
Yes, I knew that.
He has confided in you about more than one death that occurred in this gang war. Isn't that true, ma'am?
I don't know of more than one. Which one you referring to?
You know, Antonio Tilley died between October 6th and October 7th of 2023.
Yes, he told me his friend died.
He was traumatized by that, correct?
I mean, I wasn't around him to know if he was traumatized, but he said he was sad, yeah.
Mm-hmm. Didn't you have a texting conversation with him October 7th of 2023 when he said that he was traumatized and that he was mentally not well, not right in the head?
I think I remember that conversation. I asked if he wanted me to be around him for, just more support. Yeah, but he didn't want me to come.
And you remember that conversation. He didn't want you around because he was not in the right headspace the day after his friend Tilly died, correct?
Yeah, I remember. I mean, who would be in the right headspace after their friend died?
And so much so that you agreed not to go see him, right?
Yeah, if he don't want me there, I'm not going to go.
And you were worried about him, right?
Yeah, but I know if he doesn't want me there, I'm not going to just go.
And that was October 6th and 7th of 2023. Are you aware that Charles Jones, his life, there was an attempt on his life that occurred on October 7th of 2023, the day after his good friend Tilly
was killed?
I've heard about it.
You heard about it from Charles Jones, right?
Yeah, I believe you went live or something.
Yeah, and in fact, not only did you hear about it from Charles Jones, you had conversations on your phone about it, and you assured him you would delete it, right?
Delete what?
Delete. I'm sorry. You had conversations with your boyfriend, Isaiah Chance, about it, and you deleted the conversations, didn't you?
About what?
About what he had done.
He never told me he did anything. I don't remember.
Well, then let me ask you, with looking at your messages with him on October 7th of 2023, refresh your recollection? See that conversation?
Yes, ma'am.
And you've been in this trial, correct?
Yes.
You heard that the shell casings that was taken off of your boyfriend's best friend's Toyota 4Runner, that the ballistics matched the casings that were used to shoot at Julio Foolio, Charles Jones, on October of 2023, right?
Yes.
It's been tied to that ballistically, right?
Yeah, I've heard it.
And it occurred the day after Tilly was killed.
Yes.
And he was torn up, and you guys had conversations about it. You and your boyfriend Isaiah Chance had conversations about that. Isn't that true, ma'am?
Yeah, he's telling me he's not himself right now. He needs space. He never told me he did anything.
Then what is it that you're referring to after he tells you to stay loyal, right? He tells you that. He texts that to you after that, after he said he needed some time, on October 8th, now that we're talking, the day after Charles Jones, where they tried to take his life, right?
I mean,
Overruled.
He says to you, don't go run off normally, what you normally do, be loyal, stay loyal. That's what he said to you, right?
yes, and you're misinterpreting what he's saying. When he says stay loyal, he means don't go cheat. Because, I mean, I talk to who I want to talk to at times. When he's not paying me no attention, I feel like you ignore me, you're doing what you want to do, I'm going to go talk to other people. So that's why he's telling me stay loyal, don't do what you normally do.
So when he's devastated because his friend died, and then he and his friend tried to kill their rival, what he's worried about is you staying loyal to him?
I mean, I guess so.
Okay. And so what are you referring to when you say in direct response to that, you're saying, it's fine, you're all right now, it's somebody close to you, not a random person, so I mean it's normal to feel how you feel. I'm not bae, we're straight, we're just together, we're good. I deleted what you said, and I'm not texting nobody, even if you don't want to talk about it at the moment. So what exactly are you referring to that you deleted?
He told me to delete a message with somebody's texting me. It was a different guy.
So again, he's worried about you cheating. He didn't make any sort of confessions and confide in you as to what happened on October 7th?
No, he didn't.
Overruled.
And so when you are with law enforcement and they are interviewing you and they bring up Charles Jones, Julio Foolio, and they specifically talk about this beef, you lie to them and act like you don't know nothing about that, right?
Yeah, he asked me if I had knowledge, like if I knew exactly who did what. Like, no, I don't have no direct knowledge. I know what's on the internet, but I didn't assume that's what he was asking me, so I said no.
You know nothing about Julio the big rapper, right?
I said I know what's on the internet. I don't know personally if it's true, who did what.
You know more than what is on the internet. Isn't that true, miss?
No, I actually don't.
You have just read to the jury about different deaths.
That's on the internet in our city. I don't know if it would be in Tampa, but Jacksonville is on the internet.
And also a person you know that's been shot, Will.
Yeah, I went to school with him, so I know.
Okay, so that's not just on the internet. That's something that you lived through, right?
I didn't live through it. I mean, that's his situation. I just know about it.
And you're dating Isaiah Chance Gutta, right?
Dating him when at that time?
And you know that his best friend, 23, has been killed.
I mean, okay, that's his friend. That's not my friend.
Okay. But you're aware of it, right?
Yeah, I'm aware.
And you know that Tilly has been killed.
Yes, that's his friend. That's not my friend.
But again, you are aware of it, right?
Yeah, it's on the internet.
Overruled. And you know that Bibby has been killed?
Yes, just like everybody else knows.
And you yourself know about it?
Yes, it was on the internet.
And law enforcement are informing you that they are asking you about the death of Charles Jones in Tampa, right?
Yes.
And they are talking to you and they are mentioning that they know the beef between these two groups, right?
Yes.
And your boyfriend, Isaiah Chance, is connected to many of the people who have died in this rival gang war.
Yeah, he's connected, not me, so.
But you know about it.
Yes, I know.
And you lied to law enforcement and withheld all of that information knowing that they are investigating another death in this rival gang war, right?
I mean, in the beginning they told me to talk about what I want to talk about. I don't have to talk about what I don't want to talk about, and I didn't want to be in the middle of that. I don't know for sure of any of these deaths for real. I looked on the internet. I don't know, so I didn't answer it.
They read you your Miranda rights, right? They told you that before they read you your Miranda rights, right?
I don't know if it was before or not.
You didn't just watch this video?
Yeah, I don't remember if it was before though.
They read you your Miranda rights and told you you had the right to remain silent, that you were in the driver's seat, right?
Yes.
They also informed you you could have an attorney present with you if you wanted to, right?
Yes.
And you chose to speak with them, right?
Yeah, I mean, I didn't know what I was there for, so I didn't have a problem speaking to them.
You didn't know what you were there for? They told you multiple times that you were there for the murder investigation of Charles Jones, right?
I'm saying as soon as it started, when I got arrested from my house, they said I had a warrant for resisting arrest. So that's what I was assuming I was going to jail for. I later ended up in a room with two guys. So I did sit there and talk.
Who told you what you were being questioned about?
Yeah, and I had no issue. I can answer the question.
And then multiple times in that interview, they were trying to impart to you the seriousness of what you were being questioned about.
Yes.
You would agree with that statement. Multiple times they tried to reach you and let you know how serious these charges were.
Yes.
And they asked you for details about who was involved, and they started showing you evidence.
Yeah, they did.
And in that moment, you chose to protect your boyfriend. Isn't that true?
I wouldn't say I protected him. I literally pointed him out, so that's not protecting him.
You never said that he was involved with a homicide, did you?
I didn't know if he's involved in it, so why would I tell them that?
You never said who or gave descriptions. If you truly believed he had nothing to do with this homicide, then why wouldn't you just share information and tell them and give them descriptions, even if you didn't know their name, what they look like, and where they came from?
I mean, again, I didn't know for sure, so I didn't answer that, and I'm not about to do their job for them, put my life on the line, to be in the middle of that, so I didn't answer it. I answered everything pertaining to me. Anything about them, I didn't answer.
You didn't seem like you were afraid in that interview. Were you afraid in the interview or not?
I was, but I handled myself well.
Okay. You weren't afraid of Isaiah Chance?
No, he's not even in there, so why would I be?
So, well, then I don't understand. Were you afraid to give up their names because you're afraid of them? You're afraid of Isaiah Chance and Davian Murphy and Rashad Murphy? Or are you protecting them in that interview?
I wouldn't say I'm doing any of that. I mean, you understand it's about a gang. I'm a female. I don't want to be in the middle of it, so I didn't answer it. And I don't know for sure if they did anything at the time of that, so I didn't say anything.
Then why are you up here testifying about how Isaiah Chance hit you?
Because, I mean, that leads up to why I act the way I act out of town.
You were afraid of him or not? Are you afraid of him? Does he beat you? And are you afraid to stand up to him?
Yes, at times.
And you said, I think you said in your direct examination, that people can't really understand because they don't know when you cannot leave. Is that what you said? Something to that
I
effect?
said people wouldn't understand a domestic violence relationship because you'll think, why don't you leave? Why don't you walk away? It's not that easy unless you're in it.
But that's not exactly true, is it?
It is true.
You say cannot leave. You did not live with him, did you?
No, I didn't.
You never lived with Isaiah Chance.
No, I didn't. But he knew where I stayed. He would pop up at my house, ring the doorbell all times of night. So I couldn't go nowhere. So
He never had financial control over you. He never paid your rent, did he?
I don't pay rent, so no.
You live with your parents.
Yes.
You live with two loving parents in a safe home. Isn't that true, Miss Andrews?
Yes, I do.
And you never mentioned to your mother or your father that Isaiah Chance was hitting you or abusing you ever, did you?
I did.
You never reported it to police?
No, she asked me, but I didn't want to cause any problems with him or his family, so I left it alone.
So you had choices, didn't you?
That was the very last time, so I told them.
Are you afraid of him and do things because you are fearful of him? Is that what you testified to on direct?
Yes.
So fearful of him that you have to do everything he says. Is that correct?
At times, yes.
And you are claiming to this jury that you're not in a relationship with him anymore. Is that true, ma'am?
I'm not. I said he may think that because I never broke up with him, but I'm not.
Think that he thinks that because you still talk to him even though he is locked in jail, right?
Yes, I do still talk to him, and that's because of my issue. I don't want to cause any safety issues in his jail. He sends me verbal messages and where I'm at, so, I mean, I just keep him at ease. There's nowhere for me to go.
What safety issues? He is locked up for first-degree murder charges and cannot get to you. Isn't that true, ma'am?
I mean, you do know his ways in a jail. You can send messages to people. People look at me sideways. Oh, that's your boyfriend? He said this. He told me to tell you this. Like, it's safety issues. Like, literally before I came to trial, a deputy told me one of my co-defendants were trying to have me jumped. So I just do what I have to do.
You are also safely in jail. Isn't that true, ma'am?
I wouldn't say safely. You can get in a fight at any time.
Okay. There are all kinds of deputies. Is that correct?
Yes, all of them don't do their job also. So.
And we're not talking about your safety from other people. We're specifically talking about your safety from Isaiah Chance, someone you claim to be so afraid of that you will go along and do anything for him, right?
I wouldn't do anything for him, but...
You wouldn't go along with a murder plot for him?
No, he never told me anything about a murder plot.
And you wouldn't try to call him multiple times incorrectly from the jail, right?
What do you mean, incorrectly?
You're not allowed to phone another inmate, can you?
I don't call him like that, so what do you mean?
You're right, you don't call him like that. You have to break policy of the Hillsborough County Sheriff's Office and do some kind of three-way call involving Isaiah Chance's mother. Isn't that true?
Yeah, we do that.
You do it all the time, right?
Yes, when he asks for me, I do it.
As for you, you have to initiate your own phone call. He can't call you in the jail either, can he?
I said when he asks for me, I do it. If he tells me to call, I'm going to call.
It's not just that he answers for you. You can't call him directly. Isn't that true, ma'am?
No, I can't.
You have to coordinate and you have to make arrangements with some third party who is not in jail so that you can talk to him. Isn't that true?
Yes, and like I said, it goes back to me keeping him happy. I don't want to cause any issues while I'm sitting here. If he gets mad, if I don't call him, it's no telling what he's going to say. They can all, I'm the odd one out of this. They can all turn around and say, oh, it was Alicia, and I'm not getting in the middle of that. So I keep him happy while I'm here. If he wants me to call, if he wants to talk to me, let him know about the baby. He lets me know, I let him know I'm okay. That's what I do.
You call him 5 to 10 times a day in there.
Yes, when he says call back, I call back.
And you also do messages. There's a kiosk system where you can kiosk with him. Isn't that correct?
Yes, he texts me and I text him.
And you have intimate conversations about your case, don't you?
Yes, when he asks, I let him know.
And he sends you messages which could be called sexting, right?
Yeah, he do. I keep him happy, like I said.
And you're no longer in a relationship with him, correct?
No, he thinks that.
And you call him multiple times a day, every day, for several months. Isn't that true?
Yes, like I said, I'm doing what I have to do. I'm not going to let him know. I'm not going to get on the phone and act like it's a change. I'm acting the same. I'm doing what I have to do.
Ma'am, you understand you're on trial for first-degree murder, right?
Yes, I do.
And it's for hanging out with him.
I do.
And you are still protecting him, right? To this day, you're protecting him.
I'm not protecting him.
You are still calling him and communicating with him, aren't you?
Yes, that's not protecting him, though.
So much so that you call his mother, right?
I do.
And you have been advised and you report to his mother that you don't care that your attorneys tell you not to talk to him. You're going to do it anyway, right?
Yes, because I feel like that's the best way to do it.
Okay. So you are so desperate to talk to him and have communication with him, you don't even care if it may be hurtful to your case.
I wouldn't say desperate, because when I did disappear and listened, he texted me from another person and said, why are you not listening to me? Why are you not responding? When are you going to get it through your big red forehead? And all these other things. So I started back talking to him.
So now again, you're talking to him because you're still afraid of him, right? Even though he is locked up for first-degree murder charges and cannot go near you.
I didn't say physically come to me. I'm talking about other people.
You take advice from him, don't you?
I listen to it.
He discusses the case with you many, many times. Isn't that true?
Yes, because he knows I don't know, so he tries to make sure I know everything.
In fact, he tells you to kind of stay strong because the state thinks you're the weaker link. Has he told you that before?
Yes, he told me that.
Have you responded to him on, let's see. What's the date? Recently as June 27th of 2025, did you tell them half the witnesses are dead, you're listening to Jacksonville, and they don't solve shit, I'm just lost because this is all pointless?
Said what?
Did you say to him, half of their witnesses are dead, you're listening to Jacksonville, and they don't solve shit, I'm just lost because this is all pointless?
Yes, I told him, and that's my opinion. I don't understand why I'm here. It's really about them.
So you're still talking about what you're charged with him?
Yeah, he's aware, so I can say that.
And he tries to tell you what you should do in your case, right? And he tries to tell you what is the plan about the Airbnb. Isn't that true, ma'am?
Yeah, and I don't control him, so he talks about what he wants to talk about.
Don't you say in response to him telling you all that, you don't got to say all that. Don't walk me through those stops. You said that, right?
Yeah, I stop him when he talks about the case because I already kind of know that. So he tries to let me know, and I already know.
It's not because you've already discussed what you two are going to say that you're on some kind of vacation to Tampa.
No, we haven't.
That's not what you're referring
talked
to?
about that. No. He's talking about the girl in the Airbnb.
On July 5th, 2025, you didn't tell his mother that you made the defense attorney's investigator so mad because you told him you're not going to leave until you want to, and that they can't tell you who you can talk to, specifically referring to him. Isn't that true?
I was referring to other people too, but him too.
Because you are not going to give him up. Isn't that true?
Like I said, I'm doing what I think I should do to keep him happy.
And that is calling him hundreds of times, multiple times a day.
Yes, you don't see the other messages when he asks us. He says, can you call? I need you to call. Are you okay? How are you? How's the baby?
So at some point, when I say you guys are off and on, there are times where he doesn't want to talk to you. Isn't that true, ma'am?
At times.
And there are times that he blocks you, right?
Yes.
And right before, let's talk about June 17th of 2024, right? This is within a couple of weeks of this happening, right?
I think a couple of days, yeah.
June 17th, 2024, he blocked you. So you got to resort to a text now chat, right? That's not a normal means of texting on an iPhone, right? This is a special app.
Yeah, that's the app, but pertaining to him, I always text on text now when he blocks me.
So he's blocked you before, right?
Yes, whenever he's mad, he blocks me.
So sometimes he's ended communication and broken up with you, right?
Not broken up, he just goes off for a day or two.
And so can you read to the jury what it is you texted this person that you're afraid of?
I said, bitch, you a sicko. Why you blocking me over a call I didn't even initiate, trying to act like you mad, and I make people comfortable.
You need to speak, I'm sorry, Miss Andrews, the court reporter's got to take down what you're
My
saying,
bad.
so you got to speak real slow, okay?
I said, bitch, you a sicko. Why you blocking me over a call I didn't even initiate, trying to act like you mad, and I make people comfortable. I didn't do shit to make nobody feel comfortable. It was out the fucking blue. Why the fuck are you acting like it's my problem? You just wanted to have a reason to talk. I messed up when I was typing. To talk to ugly bitches you talk to. Everybody you come across and you touch, you fuck them up. You're not even mentally there and stable in the head for no relationship. Even when I didn't do shit to your ass or start a conversation, you still fucking mad. The fuck. And then I said, and you acting like I'm not pregnant. You gonna talk to me one day, so I don't give a fuck about your attitude. And I said, bye, bitch.
So this reconciliation that you're talking about, this is what he is trying to stop communication with you, right?
This is one of the things he do. So when you say stop communication, he just disappears for a day. He doesn't even really mean it. He's gonna pop up the next day and be like, what you doing?
So you weren't trying to make this jury think when you first testified that there was domestic violence in your relationship, and this reconciliation was you trying to get back with him and him trying to reconcile with you because of something he did, right?
Wait, can you repeat it?
Yes, I can. You're not trying to make this jury believe that he was the one trying to reconcile with you after he hit you or something, are you?
I don't know what you mean by that pertaining to the message. I'm just cursing him out.
No, I said when you guys get back together, I thought you told the defense attorney on your direct that this was some kind of reconciliation trip. You guys was trying to get back together, right?
It was. After I sent that, he did eventually end up texting me, not on there, but he texted my phone and we're back cool. We always do that.
And why is his little brother coming on this reconciliation trip with you?
I mean, I don't know that. That's something you have to ask him. I didn't know he was even going.
But you know where you were going, right?
Yes, he invited me and I thought it was going to be us two.
and it wasn't, right?
Yeah.
And you get to an Airbnb and you're only there for a day.
Yes.
And you go nowhere except for 3 clubs, is that correct?
Yeah, and McDonald's.
And again, not with him and Davian Murphy, right?
Yes.
So what exactly was planned for this trip where you two were going to get back together after fighting?
It wasn't necessarily get back together. It was just to spend time. I didn't have a plan. Oh, if we get down here, go here, go here. If we go out, we go out. If we don't, I would be fine with that too.
So now it's not a reconciliation trip?
No, we are getting back cool, but I'm saying it wasn't a big deal to go out nowhere. That was his decision.
You kind of just testified that he didn't spend any alone time with you that entire night, right?
He was up there, but eventually he would go his own way.
Okay. You said that he didn't go with you anywhere, and you did not go with him to when they first checked out teasers around 10. Is that correct?
Yeah, I was still in the bed at that time.
And you lied to law enforcement in that interview when you said it was just the 2 of you, right?
The 2 of us went, because I mentioned Sean too.
You did, but that wasn't until later on in the conversation. When they first asked you about the Airbnb and the door, you specifically said, it's just me and him. Do you remember hearing that?
Yes, I did say that, because I meant like when we first came in, it was just me and him.
So again, there was no planned story that if the 2 of you got caught, that it was just going to be you and him on a romantic getaway.
We never talked about caught. There's nothing to get caught about because I didn't do anything.
So again, no conversation ahead of time if you were to get caught about what your story would be.
He never told me nothing about getting caught. When he got interrogated, he came back and told me that's what happened. And then he said, you don't have to worry about that because we didn't do anything.
When did you have the conversation with him about his interrogation?
When it was the first time they searched his house.
Okay. Before you were interrogated by law enforcement?
Yes, ma'am.
So there was some discussion about what it is that law enforcement was going to be questioning you about in that interview, right?
He didn't mention the guy. He just said our trip out of town.
Okay. Such a coincidence, right? He mentions the trip out of town. You still aren't suspicious. You have still no idea a murder happened. But after he's arrested for not a homicide, just for what?
It was
resist?
Resisting arrest.
You guys are talking about the trip to Tampa.
I mean, not in detail. He just said the trip.
But he wasn't arrested in Tampa, was he? He was arrested in Jacksonville by Duval County Sheriff's officers. Isn't that true, ma'am?
Yes, but I'm saying after they arrested him, he let me know what it was for.
For leaving the scene, right?
No.
So what? Oh, for resisting arrest. Nothing that had to do in the charges of Tampa, right?
No, they left a search warrant and it said the conspiracy thing on there and something else.
Jacksonville, Duval County left the conspiracy and murder charge up there for
I don't know if it was Jacksonville, but it was on one of the papers.
And so that's what led to a conversation of you all being down in Tampa. Is that correct?
Yeah, he just said it was about the trip to Tampa.
So when you testified to this jury that you had no idea why Tampa officers were pulling you in for that interview, you were lying up there on the stand?
That's not what I said. I mean, he didn't go in full detail about what they were coming to about Tampa. He just said the trip in Tampa.
You said you had no idea why these officers were pulling you into that interview room. Isn't that what you just testified
because when
to?
they came to my house, they were coming for resisting arrest, so I didn't know why Tampa was coming to talk to me.
But that's not what you just said, because you said after the resist charge, before your interview, you and your boyfriend, Isaiah Chance, were talking about what happened in Tampa.
That was way before. I mean, like when he got arrested.
So let's talk about some more lies that you told law enforcement. You said that you could not remember how it was you got through the back door of the Airbnb, right? Do you have any memory issues?
No, I'm not slow.
Overruled, go ahead. I'm sorry, what was the answer?
Any
I said
memory
no. I
issues?
mean, I'm not slow. What do you mean memory issues?
Well, they're talking to you within a couple of months of you coming to Tampa, right?
Yes.
You don't come to Tampa every day, right?
No.
And you were with your boyfriend at this Airbnb, correct?
Yes.
And you saw those videos of you at this front door. Can you take a look at the photo behind you?
And for the record, what are you showing her?
I'm showing her State's Exhibit 60. You recognize this Airbnb?
Yes.
And you saw the other video, State 61, where you are on the Ring camera, right?
Yes.
You're only on that Ring camera entering this front door 2 times, right?
Yeah, I think it was 2 times.
On June 22nd of 2023.
Yes.
And then you are not on that front door Ring camera at all, correct?
No.
And they don't just ask you about the front door. They ask you, you leave. You leave 2 times and come back, right?
Yes, I did.
You left and you went to the McDonald's with Davian Murphy and your boyfriend Isaiah Chance, right?
Yes.
And you didn't go out this front door and you didn't come back this front door, right?
Right.
Can you take a look at the video, ma'am? We're going to show you how it is you get to the back door of this Airbnb. This is the back door, right? This is how you would have to get in when you're going to the back door, right? You got to walk through this grass pathway. And then open this door, this gate, right? And then it takes you to the sliding glass doors, right?
Yes, ma'am.
They didn't just ask you about the front door. They asked you what door you got in when you came back from the McDonald's, right?
Yes, they did.
And you didn't tell them, if you have nothing to hide, and we're just talking about an Airbnb, you didn't just say, I went through the back door, right?
Yeah, I didn't say that.
You lied, right?
I don't think I answered it.
You said, I don't remember.
Yeah, and I probably was aggravated at the time, so.
But it's a lie, nonetheless, right?
Yeah.
Because certainly you're not going to make the jury believe that you going through some dark pathway in the middle of the night to leave and then get back is something that you're not going to remember, right?
I mean, not necessarily. It wasn't a big thing to remember that day.
Even though you're being questioned on a first-degree murder charge, you can't even tell them that you just left the back door to go to McDonald's?
Yeah, but I'm saying I didn't really remember that, so, and I was aggravated, so.
It's a lie. You lied to law enforcement knowing they're investigating a first-degree homicide.
Yeah, but he was just asking me about a back door, so I didn't see any relevance.
So it's okay to lie to law enforcement if you don't think it's relevant, right?
No.
You have no clue what they're planning, right?
No.
You see the 2 spots here?
Yes.
They're open, right?
Yes, they are.
Where's the Impala?
It's parked on the side.
Where on the side?
In one of the other parking spots they had on the side.
Close to where that back door is, that side parking lot where the back door is?
I don't remember if it was close. I think it was like in the middle.
Okay. They had some bags, right? You have a bag right there.
Yeah, my bag.
So when all of those bags and stuff are unloaded, except for yours, they have to go through that back pathway to load all of those heavy guns, right?
I mean, I can't answer that. I didn't see them carried in there.
And you didn't see Davian Murphy in there either, did you?
Not when I first got there, no.
But eventually you did see him, right?
Yes, later on.
State's Exhibit 38A. So again, you saw him at the Airbnb?
Yes.
He's staying at the Airbnb?
I mean, if you consider that staying.
You lied to law enforcement about there being any other individual at that Airbnb other than you, Isaiah Chance, and his little brother, right?
Yeah, I didn't answer anything about the other people.
So that's a lie, right, ma'am? You lied to them about Davian Murphy, a member of 1200 or an associate of 1200, being at that Airbnb.
Yeah, I didn't want to answer anything about them, so I didn't answer.
Also, not relevant, right?
I mean, I wouldn't know, so.
36A. You don't know who this is, right?
At the time I didn't, but I do now.
You rode in a car with him for 3.5 hours, right?
Yes, I also went to sleep. I didn't really look at him like that.
You have been to his house for a barbecue. Isn't that true, ma'am?
Yes.
He was introduced to you by your boyfriend of over 3 years of his second family, right?
Yeah.
He introduced you to all of his family members, right?
I didn't say all of his family members.
You said he introduced you at that barbecue and said, "This is my second family," right?
Yes, but I don't know if that's his real family members.
So you're suggesting to this jury that when you are being introduced by your boyfriend to his second family that he posed some fake people next to him?
I'm saying I don't know if he was talking about everybody that was standing there. Could have been talking about particular people.
But certainly Sean Gathright was there, right?
Yes, ma'am, he was there.
And he's one of the people he's saying, "This is my second family," right?
No, he said his little brother to him.
Part of his family. And then the rest of the people was his second family, right?
Yeah, he considered them second family.
And you care about Isaiah Chance?
I did.
And you would have us believe that after he introduced you to his little brother, his second family, you went off in some second room and never looked at his face?
I didn't go off to the second room. I just got a plate and went back to the car.
You hid in the car, right?
Yeah, I don't really talk much, so I got back in the car.
Oh, so you never had a conversation with him?
No, I just said hey and bye.
And you can't tell that this person in 36A is the same person in 36B?
I mean, at the time, it didn't really look like him. I just glanced at the picture. I said no.
And in the entire 3.5 car ride, you never looked at his face either?
I'm not staring him down, so I mean, no.
And at the entire time that you're at the Airbnb with him, you never looked at his face or had one conversation with him?
I didn't have a conversation with him, but I maybe glanced.
You were walking next to Isaiah Chance at Teasers. You were walking next to him at that parking lot when he was at Truth 18. I'm not going to play the videos again. You saw that. You guys were walking right next to him.
If you consider that right next to him, yes.
Some points you were a little behind him, is that correct?
Yes.
And some points you were right next to him, isn't that correct?
Yes.
And there were points when he has that phone, your phone, up to his ear.
Yeah, at certain points.
And at one point, when he has it up to his ear, he has to give it to you so you can do what?
Put the code in. That was at the first club.
And that's right. Put the call in, right? There is a call that is happening. And
I said the code.
The code. But there is a call happening. He's actually on the phone, right?
At the first club, he attempts to make a call, yeah.
Attempts, right? It's literally up to his ear.
Yeah, I don't think it went through.
Oh, because you're right next to him, you would know, right?
No, I mean, he didn't say anything, so that's why I said I don't think it went through.
And at some point, he hands it to you so you can do what?
I mean, I didn't put the code back in after that.
Just the one time?
Yes.
It didn't go off any other time that you were with him from the entire time to Teasers, to Truth 18?
I mean, later on, I think, yeah. At the next club, yeah.
What about in the car?
No, in the car was still unlocked.
And you never heard him utter one word on that phone while you were next to him in the parking lot at Teasers?
Teasers is the first club, right?
Yes, ma'am.
No, he didn't say anything.
And he never said one thing the entire time when you guys are sitting in that parking lot at Teasers at the same point when Charles Jones is there.
He said something, but he didn't say anything about him.
What did he say?
He just was saying how all the people were just standing there, standing around.
He never had one phone call?
I mean, he tried to call, but I don't know. Again, I don't know if he went through.
I'm going to show you State's Exhibit number 94C1. You see this when he's on the phone actually sharing a live location with Sean Gathright that's occurring at 2 a.m. You see that?
Yes, ma'am.
He does that multiple times. So he has your phone a lot in that car, right?
Yes.
And so anytime there's inactivity on the phone, you got to do what for him?
Unlock it, but he never locked it back. If he didn't respond, he just went and got on something else.
He doesn't lock the phone, right? That's something that happens automatically based on time, right?
Yes.
When that phone locks up in the parking lot, it's not because he locked it, it's because there's a timing mechanism on your iPhone that makes it go dark, right?
I mean, yeah, but the first time he got out the car, it's my phone. He stops me and asks for it, so it's not unlocked when he asks for it.
And then at some point, he starts texting NIGGA, pick up the FNO. He says that. He doesn't text it just once at 2:31. He sends this text again at 2:31 and 24 seconds. So he wants somebody to pick up that effing phone. Are you claiming when he's texting that, he's not saying anything to you?
No, not about that.
Do you see him desperately going like this?
No, not like he's rushing. He just regularly typing.
He just casually texts,
yes.
Pick up the effing phone. Twice.
Yeah.
And that was something that if he had done it very erratically, you would have noticed, right?
Yeah, but he wasn't.
That might have tipped you off that something pretty important was happening, right?
I mean, if you say so.
So he's just casually typing that in, and then he's sharing the location again later, 2 hours later. But after this exchange, he never gets a phone call. There's no conversation in that car.
I don't remember him having a conversation there.
But he's not sending one other text after he desperately texts that twice, right?
I don't think he did.
You don't think, or you're not willing to tell us?
I don't really remember what he texts, so.
And you don't remember or hearing him have any conversation in that car?
Not right there, no.
And you remember Detective Ramos when he was sitting next to you and he was kind of acting out what he thought happened after he saw the video footage and some of the messaging, that he's right next to you in that car and he's saying, he's sitting this close to you, right? He's in the driver's seat, right?
Yes.
And you are in the passenger seat, right?
Yeah.
Remember that exchange? And he kind of imitates and acts out, hey, get here, get here. He's going into the club now. You better get here now. That you're claiming something like that never happened.
No, I told you what he said.
Okay.
Only time he said something was when he flipped the camera and said it was packed. And where y'all at?
Do you also remember? Oh, so now they said where you're all at, right?
I'm talking about when he took the picture on the screenshot. That's what I said he said.
Okay. Did you know who he was talking to?
I mean, no, but I assumed it was his friends.
Do you remember when law enforcement specifically asked you about the black Chevy Impala?
Yes, ma'am.
That black Chevy Impala happened to be at the Home to Suites, correct?
I mean, yeah, but at the time I didn't know that.
You didn't see the black Chevy Impala when your boyfriend was circling around the parking lot not once but twice?
No, I didn't see that car.
That was a car that you had ridden down to Jacksonville with Sean Gathright, right?
Yeah.
And you didn't recognize that car in the parking lot?
I mean, how am I going to know if it's them, though? I don't know if it's them.
So just a coincidence that you happened to be at Home to Suites, right?
I mean, I'm not driving, so I can't tell you why he went there.
You got out of the vehicle with Isaiah Chance at both of those clubs, correct?
Yes, ma'am.
And you said on your direct examination that you went up to the bouncers, right?
Yes, ma'am.
That's a lie, right?
I wasn't referring to those clubs. I was referring to Players Club.
The detectives never mentioned the Players Club to you in that interview, right?
No, he showed me a video of a parking lot, so I just assumed it was that club.
He showed you the video of the two of you walking out of that club, correct?
No, he showed me a parking lot, the first video when I said that.
He also showed you Julio Foolio, is that correct?
He did.
At the front door.
I believe he did.
And they specifically asked you at Teasers and at Truth 18, the two clubs that you went to, whether or not you had talked to the bouncers, right?
I think he did ask me.
And you said that you had spoken to them at both and that the price was too high, correct?
Again, I was talking about Players Club. I had the clubs mixed up at the time. I didn't know the names, and I didn't say specifically that. I said I talked to the bouncer, the guys that be at the front door.
And there's no video footage at Players Club, right?
No.
All right, overruled if she knows.
I said no.
You know that there's no video footage at Players, right?
I mean, if he would have investigated it, he would have found it probably.
And there is video footage at Teasers and Truth 18, correct?
Yeah, because that's all the detective went and looked for.
And you admit that you never went to any of the bouncers at Truth 18, right?
No, again, when I bring up the bouncers, I was referring to Players Club.
So you and your boyfriend on your reconciliation trip just went to walk in the parking lot of Teasers, right?
Teasers is the first club?
Yes.
Yeah.
That's all you did, right? You just walked in the parking lot. You didn't even come close to the front door.
I mean, yeah, we were standing there, but it's his decision. He didn't want to go in there, so.
And you have no say in the matter on your reconciliation trip, whether or not you actually get to go into the club?
I mean, I didn't have an issue with it. If he didn't want to go, he didn't want to go.
So you're just happy on this trip to get back together with just walking in the parking lot?
I wouldn't say that.
Well, then you go to the second club, Truth 18. That's the club with the second story on the second floor.
Yes, ma'am.
And that same thing happens. You just walk in the parking lot, right?
Yeah, I mean, I'm following him.
Yeah. You don't even really walk up to the door. And it's at the same point when Charles Jones is at that location.
I mean, I didn't know he was there, so.
Okay. But you're okay just walking in the parking lot, right?
No, actually, I was irritated. I didn't really care to go in that when he chose the last club. After he took me to 2 locations, we didn't go anywhere. At that point, I am aggravated, so.
Well, you said they didn't go in because it was packed, right?
That's what he said.
Well, there was, at the time when you're walking on that video, there aren't tons of people in that parking lot, right?
It was. There was people parked on the side as well.
You don't even walk up those stairs to see how many people are inside, right?
We went by how many cars are outside.
Oh, so that's the definition of how a car is, or how a club is packed, by the cars, right?
I mean, to young people, yeah.
Okay. You said the next morning that that Isaiah Chance, the one time he did come in, it was to what? So you could look at his outfit, give an outfit check?
Yeah, he was showing me various outfits, laying around the bed. He said she could put back on what he had on because he didn't take any pictures. And that's what we were talking about.
Because he cares how he looks like, right?
Sometimes.
He got into a war with Julio Foolio online because Julio was making fun of him wearing fake designer clothes, right?
I didn't know of that.
You had no idea about that?
No.
But he is doing an outfit check with you because he's concerned about it, right?
I mean, not really. He just saying, what do you think I should wear? Like a regular person.
And the two of you said you're going clubbing, right?
I mean, supposed to be.
Right. And how do you normally dress up when you go clubbing?
I mean, this will be our second time going clubbing, so he wears whatever he wants to wear. When I go, I just wear whatever I want to wear.
You just kind of said that he's very controlling about what you wear on your direct examination.
Yeah, at times.
And as a young woman, when you go clubbing, you get dressed up, right?
Yeah.
In fact, on your phone, you had hundreds of photographs on your phone and videos of yourself, right?
Yes, ma'am.
Times when you went out with friends, times when you were with girls, and just times when you were having photographs done, right?
Yeah.
And on the day that you two are going clubbing, because that's the purpose, right? Going clubbing, right? Going out and having fun.
I mean, that was kind of last minute, so yeah.
Did you see what he was wearing? He was wearing, it's June in Tampa, right?
Yeah.
He was wearing a gray hooded sweatshirt with the hoodie all the way pulled up and a COVID mask.
Okay.
To go clubbing.
Yeah, you don't really go out, so I don't know what he would typically wear.
And you were wearing what?
I put on a jean jacket. I think I had on the blue pants and a regular shirt.
Is that how you normally go when you're going out for a night on the town to go clubbing?
I mean, no. Eventually, when I first arrived, I had a dress on. But once I realized other people were there, I took that off. So what you see me wearing is what I had on to McDonald's. And we stayed in the car, so I didn't go change. So, I mean, I just kept what I had on.
Because when you go clubbing, you normally look like 75 C9, right? You like to get dressed up, wear a nice dress, right?
Correction, I'm not clubbing in that. I'm out of town with my family.
Okay. And where are you going when you go out of town with your family?
Nowhere, I just put that on to take a picture.
Okay. But there are literally photo after photo, Instagram video after Instagram video of you going out with your friends, right?
Yes, ma'am.
And you're not dressed in a jean jacket and what, were they sweatpants or?
No, they're just regular pants.
And when law enforcement asked you about Gutta, and I think the defense attorney played that for you, again, you specifically asked them, why are they calling him that, right?
Yes, ma'am.
And you said that you are just surprised because they're law enforcement and you feel that they should be talking about his real name or mentioning him by his real name, right?
I mean, I didn't mean it like that. I'm saying I would have thought they would have came in a different way. We're starting the interview and you just say, oh, Gutta. And I'm like, what? Like, I'm just confused.
But you didn't say what. You said, why do you call him that, right?
Yeah, that was my response. But I'm saying in my head, I'm thinking, like, why are two detectives coming to me saying a nickname? Like, what is this about?
And then they laughed, and then they said, do you or you don't call him Gutta? And you shook your head no, right?
No, I don't call him that.
And it wasn't just you shaking your head no. You said, that's not a thing, right?
I mean, it's not a thing for me to call him that. That's what I meant.
But you just said, that's not a thing.
I said it's not a thing or something.
I'm going to show you State's Exhibit number. And Gutta, that's his rap name. That's the name that he uses for the gang, right? For those drill rap videos he makes. Gutta,
I wouldn't
Man.
necessarily say a drill name. It's just a nickname on Instagram.
But it's something you know, and you do call him that, don't you?
No, I don't call him that.
You just have it tattooed on your body, right? You have it tattooed down the middle of your chest. Gutta, right?
Yes, ma'am, I do.
Okay. And that's not the only place. I'm also going to show you State's Exhibit 75G. It's there. It's a long tattoo, and it goes all the way down your chest, right?
Yes, ma'am.
So you're familiar that he calls himself Gutta.
Yeah.
And despite the fact that you have that tattoo on your body, you have never referred to him as Gutta?
No, I still call him by Zay.
That's not the only place on your body that you have that Gutta tattoo, is it?
No, I have another one behind my ear.
I'm going to show you State 75C11. That's it right there. So
Yes.
not once, twice.
Yes, ma'am.
Referencing Isaiah Chance.
Yeah.
Someone who you're no longer in a relationship, right?
Yes, ma'am.
So it wasn't a lie to law enforcement when you said that you don't call him that.
No, it wasn't a lie.
Your Honor, may I have one moment?
Yes.
At the time when that photo, you said your Isaiah Chance took that photo in the parking lot of Truth 18?
Yes, ma'am.
That is, at that timing, that is when Charles Jones and his party are still up on that second floor. And you're saying you never saw that?
No, I didn't look up there.
Where are you looking at?
I mean, at him.
And you're looking at him taking the photo?
I don't think I was.
What?
I don't think I was. I seen the picture after because it was in my phone.
Are you looking at him when the photo was taken, or are you not looking at him?
I don't think I was.
So what are you looking at?
I think I was looking at him. Not like physically like what he's doing. I'm just sitting there just staring.
You're not looking at the club that you're supposed to be going to?
I can't remember if I was or not.
Okay. Well, you said that you can tell if a club is packed based on the cars in the parking lot, right?
Yeah, but we were parked on the other side. It was more cars.
Right, because there were parking spots available in Truth 18, right?
I don't remember that.
You could have driven through the parking lot and not even got out of the car if you could tell a club is packed just on the parking spots, right?
I mean, that's not my decision. Again, he's driving, so.
No. You said how young people determine whether or not a car or a club is packed is by the parking lot, right?
Yes, ma'am.
Both at Truth 18 and Teasers, there were cars in that parking lot. You didn't need to get out of the car to go up to the door to know that Teasers was packed, right?
Yeah, it was. But again, it's not my issue with the back places this is.
Well, what the issue is, you keep on giving us another reason why it is that you're in that parking lot. You understand that, ma'am?
Yeah, I mean, I'm just following him.
No, you said that you believed that you didn't go in because it's packed, right?
Yes, because that's what he said.
And you don't have to go into the club itself to know it's packed because of the parked cars in the parking lot, right, ma'am?
That's what I said. I don't know what he's thinking, though.
When you are at Teasers, you guys have to go around more than once to park because you can't find a parking spot, right?
Yeah, and then we see somebody coming out, so he just waited.
So it didn't matter that it's so packed, you gotta wait for a parking spot to open up?
Well, we did get out, but, I mean, all the people in the front, that's when he decided he didn't want to go in.
So it's not the parked cars in the parking lot that tells you a club is packed?
It is, but I'm saying once you seen all the people up there and nobody was going in, he changed his mind.
Judge, I don't have anything further.
Okay, redirect.
Ms. Andrews, do you want to answer any more questions?
I can.
I ask you one more question. There's a tattoo that's missing that hasn't been described on your arm here. What does that tattoo say?
Psalms 46, God is within her, she will not fail.
I'm going to sustain the objection.
No further
And is there
questions.
another motion?
Judge, we would move to strike that from the record.
Granted, stricken from the record. Jury's not to consider it. Okay, very good. Ladies and gentlemen, just step out momentarily. Okay, we'll be right with you.
All rise.
Wow, that got a reaction from the state and the judge. Whew, was not expecting that. All right, definitely want to watch this entire trial at some point. Alicia's got a new judge, so Judge Sisko was removed. Defense put in a motion, got Judge Cisco removed. Her new judge, so her sentencing is December, I think December 8th. Her new judge has a motion to dismiss, or I'm sorry, a motion for a new trial in front of her in May, I think around the 10th or 11th, something like that. So we will find out come May what happens with Alicia. But so they're going on the principal theory, right? Which is basically it's all for one. It's like you're the driver and the bank robber goes in, or somebody robs the bank and they shoot somebody. You are as much at fault as that person who did that. So that's where I'm wondering. I was talking to some of you guys in chat. That's what I'm wondering. How was the law written? Because you may say, "Oh no, she was telling the truth. She's not guilty. I have reasonable doubt." But maybe the law was written in such where, was she a part of this? Did the state prove that she was there? And it seems like the state proved that. Again, I haven't watched this trial, so I'm not going to speak too much on it. But it seems like if they didn't go for first degree, meaning the jury, they went for the lesser included, which was manslaughter. And a jury has been selected. That's the other thing. We'll talk about that in a second. Let me just get to her verdict. The verdict came in Halloween night, and but a jury has been selected. So let's get to this.
Okay, very good. Madam Clerk? Yes. Please publish the verdict.
In the Circuit Court of the 13th Judicial Circuit of the State of Florida, in and for Hillsborough County Criminal Justice Division, State of Florida versus Alicia Latoya Andrews, case number 24 CF 11996, Trial Division 1, verdict form. We, the jury, find as follows as to count 1, the defendant is guilty of manslaughter, a lesser included offense. We, the jury, find as follows as to count 2, the defendant is not guilty. So say we all, dated this 31st day of October 2025, signed foreperson of the jury.
All right, thank you very much. Have a seat. Does either side wish for me to poll the jury?
Yes, sir.
Okay, so ladies and gentlemen, I'm going to ask you, each of you, this is your true and correct verdict. I'm going to call you by your initials and your jury number. And I just need you to respond yes or no, okay? All right, juror number 5, initials DC. Is this your true and correct verdict? Yes. Juror number 13, initials LM. Is this your true and correct verdict? Juror number 14, initials SC. Is this your true and correct verdict?
Yes.
Juror 21, initials EM. Is this your true and correct verdict? Yes. Juror number 23, initials CJ. Is this your true and correct verdict?
Yes.
Juror number 41, initials AM. Is this your true and correct verdict?
Yes.
Juror number 42, initials LL. Is this your true and correct verdict?
Yes.
Juror number 45, initials JO. Is this your true and correct verdict?
Yes.
Juror number 58, initials SH. Is this your true and correct verdict?
Yes.
Juror number 61, initials SM. Is this your true and correct verdict?
Yes.
Juror number 62, initials PB. Is this your true and correct verdict?
Yes.
Juror number 71, initials MG. Is this your true and correct verdict?
Yes.
Okay. All right, very good. I have one final set of very brief formal instructions and then something a little less formal to say to you all. Ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. on behalf of everyone, we are indebted to.
All right, I'm just gonna go ahead and end it because that's basically it. You know, that's really all I wanted to see. All right, we'll go back here. Excuse me. All right, so jury has been seated. 12 on the panel with 3 alternates. So they seated 15 jurors today at 6 o'clock. News came down 6 o'clock. They seated a jury. We're going to find out the makeup of that jury. Still waiting to hear what the makeup is. So we'll have that hopefully for you guys tomorrow. And also finding when court starts exactly. Right now we're scheduled to start at 8:45 with court starting at 9 o'clock Eastern. So that's going to do it for our deep dive. Hopefully you guys have gotten a lot of information and knowledge out of the last couple days. We did yesterday and today. We did 3 days. 3 days last week. We did a history of ATK and KTA. Here, you know what? Let me pull up some. Let me pull up some graphics that we did. Might as well, right? Let's might as well do it now. Get you guys familiar with that. Let me see here. Aaron did some great graphics. Let's see here. All right, so this is Ace's crew. Don't want to call them a gang, right? Because officers were calling them a gang, but some people in chat are like, they are not a gang. They're affiliated with one, but they're not a gang. All right, so anyway, this is Ace's ATK, 1200 block. And then we've got Julio's group. Hold on, let me get this for you guys. All right, Queso's in jail. Royal Smith, 23, he passed away in that wasabi restaurant. It was his birthday. Spinabens and Wapa, they're still out. The Noah and Reginald, they're still out. They're still out doing their thing. All right, then we got KTA, which has killed them all. This is the 600 or 6 block. This was Julio. He grew up in the Hilltop Apartments. So you got Bibby, you got Lil Nine, you got Tiki, and you got Tweak and G, Zion Brown. So they're all gone. Not a single one of these guys is still around. So you look back at this crew, and 23 is the only one that's gone out of them. But then you look at these guys, they're all gone. No, he didn't die in the restaurant. They got shot when they were pulling out at the on the street. So, but we call it the Wasabi restaurant ambush, you know. But no, they did not get shot in the restaurant. We understand that. But I'm just thinking, think about it. So you look at these guys, 23 is the only one that's gone. And then you look at these guys, and not a single person is alive still. So if you weigh it from that standpoint, it's not good for KTA, that's for sure, if you weigh it by that standpoint. So, all right, so those you'll hear those names throughout the trial, but we'll go back here. All right, you guys, that's going to be it. That's it for us. Jury's been selected. We will be live tomorrow, so really appreciate you hanging with us for this for these deep dives we've been doing. Thank you to our mods for keeping it respectful. Thank you to Erin for all that she does on the back end. Just keep continuing being courteous and respectful to each other, people in the court. We're going to it'll be an interesting trial. Looking forward to spending it with you guys. So with that, have a great one. We're going to go on at 8:45 Eastern tomorrow. We're we're hoping that I think trial will start at 9. I'll find out later tonight when they start exactly, but we'll be on at 8:45. Or if they go on earlier, we'll shift and we'll go on earlier then too. So with that, have a great night and take care of yourselves, guys.